freedom from abuse, neglect, and exploitation. Appendix PP, Regulation Section 483.12, tags F600 through F610. Begin reading. Tag F600. Section 483.12, freedom from abuse, neglect, and exploitation. The resident has the right to be free from abuse, neglect, misappropriation of resident property, and exploitation as defined in this subpart. This includes, but is not limited to, freedom from corporal punishment, involuntary seclusion, and any physical or chemical restraint not required to treat the resident's medical symptoms. Section 483.1, 2A, the facility must. Section 483.12A1, not use verbal, mental, sexual, or physical abuse, corporal punishment, or involuntary seclusion. Intent Section 483.12A1. Each resident has the right to be free from abuse, neglect, and corporal punishment of any type by anyone. Note, refer to tag F602 for misappropriation of resident property and exploitation, and F603 for cases of involuntary seclusion. Definitions, Section 483.12A1. Abuse is defined at Section 483.5 as the willful infliction of injury, unreasonable confinement, intimidation, or punishment with resulting physical harm, pain, or mental anguish. Abuse also includes the deprivation by an individual, including a caretaker, of goods or services that are necessary to attain or maintain physical, mental, and psychosocial well-being. Instances of abuse of all residents, irrespective of any mental or physical condition, cause physical harm, pain, or mental anguish. It includes verbal abuse, sexual abuse, physical abuse, and mental abuse, including abuse facilitated or enabled through the use of technology. Neglect, as defined at Section 483.5, means the failure of the facility, its employees or service providers to provide goods and services to a resident that are necessary to avoid physical harm, pain, mental anguish, or emotional distress. Sexual abuse is defined at Section 483.5 as non-consensual sexual contact of any type with a resident. Willful, as defined at Section 483.5 in the definition of abuse, and means the individual must have acted deliberately, not that the individual must have intended to inflict injury or harm. Guidance Section 483.12A1. Note, for purposes of this guidance, staff includes employees, the medical director, consultants, contractors, and volunteers. Staff would also include caregivers who provide care and services to residents on behalf of the facility, students in the facility's nurse aid training program, and students from affiliated academic institutions, including therapy, social, and activity programs. Abuse. Sections, Section 1819 C1A Roman II and 1919 C1A Roman II of the Social Security Act provide that each resident has the right to be free from, among other things, physical or mental abuse and corporal punishment. The facility must provide a safe resident environment and protect residents from abuse. Staff to resident abuse of any type. Nursing homes have diverse populations including, among others, residents with dementia, mental disorders, intellectual disabilities, ethnic/cultural differences, speech/language challenges, and generational differences. When a nursing home accepts a resident for admission, the facility assumes the responsibility of ensuring the safety and well-being of the resident. It is the facility's responsibility to ensure that all staff are trained and are knowledgeable in how to react and respond appropriately to resident behavior. All staff are expected to be in control of their own behavior, are to behave professionally, and should appropriately understand how to work with the nursing home population. A facility cannot disown the acts of staff, since the facility relies on them to meet the Medicare and Medicaid requirements for participation by providing care in a safe environment. CMS does not consider striking a combative resident an appropriate response in any situation. It is also not acceptable for an employee to claim his or her action was reflexive or a knee-jerk reaction and was not intended to cause harm. Retaliation by staff is abuse, regardless of whether harm was intended and must be cited. Note, it should not be assumed that every accident or disagreement that occurs between an employee and a resident should be considered to be abuse. Accidents that may not be considered to be abuse include instances such as a staff member tripping and falling onto a resident, or a staff member quickly turning around or backing into a resident that they did not know was there. Resident-to-resident abuse of any type. A resident-to-resident altercation should be reviewed as a potential situation of abuse. The surveyor should not assume that every resident-to-resident altercation results in abuse. For example, infrequent arguments or disagreements that occur during the course of normal social interactions, e.g., dinner table discussions, would not constitute abuse. The surveyor must determine whether the incident would meet the definition of abuse. Also, when investigating an allegation of abuse between residents, the surveyor should not automatically assume that abuse did not occur, especially in cases where either or both residents have a cognitive impairment or mental disorder. Having a mental disorder or cognitive impairment does not automatically preclude a resident from engaging in deliberate or non-accidental actions. In determining whether F600 free from abuse and neglect should be cited in these situations, it is important to remember that abuse includes the term willful. The word willful means that the individual's action was deliberate, not inadvertent or accidental, regardless of whether the individual intended to inflict injury or harm. An example of a deliberate, willful action would be a cognitively impaired resident who strikes out at a resident within his or her reach, as opposed to a resident with a neurological disease who has involuntary movements, e.g., muscle spasms, twitching, jerking, writhing movements, and his or her body movements impact a resident who is nearby. If it is determined that the action was not willful, a deliberate action, the surveyor must investigate whether the facility is in compliance with the requirement to maintain an environment as free of accident hazards as possible, and that each resident receives adequate supervision. See F689. The facility may provide evidence that it completed a resident assessment and provided care. Planning interventions to address a resident's distressed behaviors, such as physical, sexual, or verbal aggression. However, based on the presence of resident-to-resident altercations, if the facility did not evaluate the effectiveness of the interventions and staff did not provide immediate interventions to assure the safety of residents, then the facility did not provide sufficient protection to prevent resident-to-resident abuse. For example, redirection alone is not a sufficiently protective response to a resident who will not be deterred from targeting other residents for abuse once he/she has been redirected. Staff should monitor for any behaviors that may provoke a reaction by residents or others, which include, but are not limited to, verbally aggressive behavior, such as screaming, cursing, bossing around/demanding, insulting to race or ethnic group, intimidating, physically aggressive behavior, such as hitting, kicking, grabbing, scratching, pushing/shoving, biting, spitting, threatening gestures, throwing objects, sexually aggressive behavior, such as saying sexual things, inappropriate touching/grabbing, taking, touching, or rummaging through others' property, and wandering into others' rooms/space. Also, resident-to-resident abuse could involve a resident who has had no prior history of aggressive behaviors, since a resident's behavior could quickly escalate into an instance of abuse. For example, a resident pushes away or strikes another resident who is rummaging through his or her possessions. Visitor-to-resident abuse of any type. Allegations of abuse have been reported between spouses or residents and their parents or children, in addition to visitors who are not members of a resident's immediate family. The surveyor may obtain information from the resident's social history to the extent possible that identifies concerns or issues regarding relationships between the resident and relatives, friends, and/or visitors. The surveyor should interview the social worker and review the resident's assessment and care plan to determine whether the facility identified and provided interventions on how to address the concerns. Also see F640, 5 medically related social services. In addition, the survey team must review whether the facility has developed and implemented policies and procedures related to visitor access. This would include safety restrictions, such as denying access or providing limited and supervised access to a visitor who has been found to be abusing, exploiting, or coercing a resident, or who is suspected of abusing, exploiting, or coercing a resident until an investigation into the allegation has been completed. Any such restriction should be discussed with the resident or resident representative first. Also, the resident maintains the right to deny visitation according to his or her preferences. See guidance at F563 Visitation Rights and F564 Resident Right to Visitors. Types of abuse. Identified facility characteristics. One that could increase the risk for abuse include, but are not limited to, unsympathetic or negative attitudes toward residents, chronic staffing problems, lack of administrative oversight, staff burnout, and stressful working conditions, poor or inadequate preparation or training for caregiving responsibilities, deficiencies of the physical environment, and facility policies operate in the interests of the institution rather than the residents. In addition, the risk for abuse may increase when a resident exhibits a behavior that may provoke a reaction by staff, residents, or others, such as verbally aggressive behavior, such as screaming, cursing, bossing around/demanding, insulting to race or ethnic group, intimidating, physically aggressive behavior, such as hitting, kicking, grabbing, scratching, pushing/shoving, biting, spitting, threatening gestures, throwing objects, sexually aggressive behavior, such as saying sexual things, inappropriate touching/grabbing, taking, touching, or rummaging through others' property, wandering into others' rooms/space, and resistive to care and services. Some situations of abuse do not result in an observable physical injury or the psychosocial effects of abuse may not be immediately apparent. In addition, the alleged victim may not report abuse due to shame, fear, or retaliation. Other residents may not be able to speak due to a medical condition and/or cognitive impairment, e.g., stroke, coma, Alzheimer's disease, cannot recall what has occurred, or may not express outward signs of physical harm, pain, or mental anguish. Neither physical marks on the body nor the ability to respond and/or verbalize is needed to conclude that abuse has occurred. Abuse may result in psychological, behavioral, or psychosocial outcomes including, but not limited to, the following. Fear of a person or place, of being left alone, of being in the dark, and/or disturbed. Sleep and nightmares. Extreme changes in behavior, including aggressive or disruptive behavior toward a specific person, and O. Running away, withdrawal, isolating self, feelings of guilt and shame, depression. Crying, talk of suicide or attempts. The guidance below identifies some characteristics of specific types of abuse. Physical abuse. Physical abuse includes, but is not limited to, hitting, slapping, punching, biting, and kicking. Corporal punishment, which is physical punishment, is used as a means to correct or control. Behavior. Corporal punishment includes, but is not limited to, pinching, spanking, slapping. Of hands, flicking or hitting with an object. Possible indicators of physical abuse include an injury that is suspicious, because the source of the injury is not observed, the extent or location of the injury is unusual, or because of the number of injuries, either at a single point in time or over time. Examples of injuries that could indicate abuse include, but are not limited to, O. Injuries that are non-accidental or unexplained. O. Fractures, sprains or dislocations. O. Burns, blisters, or scalds on the hands or torso. O. Bite marks, scratches, skin tears, and lacerations with or without bleeding, including those that are in locations that would unlikely result from an accident. O. Bruises, including those found in unusual locations such as the head, neck, lateral locations on the arms, or posterior torso and trunk, or bruises in shapes e.g. finger imprints, and O. Facial injuries, including but not limited to broken or missing teeth, facial fractures, black eyes, bruising, bleeding, or swelling of the mouth or cheeks. Deprivation of goods and services by staff. Abuse also includes the deprivation by staff of goods or services that are necessary to attain or maintain physical, mental, and psychosocial well-being. In these cases, staff has the knowledge and ability to provide care and services, but choose not to do it or acknowledge the request for assistance from a residentess, which result in care deficits to a residentess. Mental and verbal abuse. Mental abuse is the use of verbal or nonverbal conduct which causes or has the potential to cause the resident to experience humiliation, intimidation, fear, shame, agitation, or degradation. Verbal abuse may be considered to be a type of mental abuse. Verbal abuse includes the use of oral, written, or gestured communication, or sounds, to residents within hearing distance, regardless of age, ability to comprehend, or disability. Examples of mental and verbal abuse include, but are not limited to, O. Harassing a resident. O. Mocking, insulting, ridiculing. O. Yelling or hovering over a resident with the intent to intimidate. O. Threatening residents, including but limited to, depriving a resident of care or withholding a resident from contact with family and friends, and O. Isolating a resident from social interaction or activities. Note, although a finding of mental abuse indicates that a facility is not promoting an environment that enhances a resident's dignity, surveyors must cite a finding of mental abuse at F600 at the appropriate severity level with consideration of the psychosocial outcome to residents. Mental abuse includes abuse that is facilitated or enabled through the use of technology, such as smartphones and other personal electronic devices. This would include keeping and or distributing demeaning or humiliating photographs and recordings through social media or multimedia messaging, if a photograph or recording of a resident or the manner that it is used demeans or humiliates a residentess, regardless of whether the resident provided consent and regardless of the resident's cognitive status, the surveyor must consider noncompliance related to abuse at this tag. This would include, but is not limited to, photographs and recordings of residents that contain nudity, sexual and intimate relations, bathing, showering, using the bathroom, providing perineal care such as after an incontinence episode, agitating a resident to solicit a response, derogatory statements directed to the resident, showing a body part such as breasts or buttocks without the resident's face, labeling residents' pictures and slash or providing comments in a demeaning manner, directing a resident to use inappropriate language and showing the resident in a compromised position, depending on what was photographed or recorded. Physical and slash or sexual abuse may also be identified. Sexual abuse. Sexual abuse is non-consensual sexual contact of any type with a resident, as defined at 42 CFR Section 483.5. Sexual abuse includes, but is not limited to, unwanted intimate touching of any kind, especially of breasts or perineal area. All types of sexual assault or battery, such as rape, sodomy, and coerced nudity. Forced observation of masturbation and slash or pornography, and taking sexually explicit photographs and slash or audio/video recordings of a residentess and maintaining and slash or distributing them, e.g. posting on social media. This would include, but is not limited to, nudity, fondling, and slash or intercourse involving a resident. Generally, sexual contact is non-consensual if the resident either appears to want the contact to occur, but lacks the cognitive ability to consent, or does not want the contact to occur. Other examples of non-consensual sexual contact may include, but are not limited to, situations where a resident is sedated, is temporarily unconscious, or is in a coma. Any investigation of an allegation of resident sexual abuse must start with a determination of whether the sexual activity was consensual on the part of the resident, a resident's apparent consent to engage in sexual activity is not valid if it is obtained from a resident lacking the capacity to consent, or consent is obtained through intimidation, coercion, or fear, whether it is expressed by the resident or suspected by staff. Any forced, coerced, or extorted sexual activity with a resident, regardless of the existence of a pre-existing or current sexual relationship, is considered to be sexual abuse. A facility is required to conduct an investigation and protect a resident from non-consensual sexual relations anytime the facility has reason to suspect that the resident does not wish to engage in sexual activity or may not have the capacity to consent. Non-sexual physical contact with residents. Nothing in this guidance is intended to limit a resident's ability to receive non-sexual contact, such as holding a resident's hand. It is not the intent of this guidance for facilities to foster no contact of any type, policies/procedures/practices between staff and residents or residents and others, assuming such contact is consistent with the resident's preferences. It should also not be assumed that all physical contact involving a resident would constitute sexual abuse. Capacity and consent. Residents have the right to engage in consensual sexual activity. However, anytime the facility has reason to suspect that a resident may not have the capacity to consent to sexual activity, the facility must take steps to ensure that the resident is protected from abuse. These steps should include evaluating whether the resident has the capacity to consent to sexual activity. Note: for information related to determining consent, refer to Assessment of Older Adults with Diminished Capacity, a Handbook for Psychologists, American Bar Association, Commission on Law and Aging, American Psychological Association, located at http://www.pay.org/pi/aging/programs/assessment/capacity psychologist handbook PDF. This resource includes a discussion on determining issues related to determining consent, including The legal standards and criteria for sexual consent vary across states. Liddon, 2007. Stavis et al., 1999. The most widely accepted criteria which are consistent with those applied to consent to treatment are: 1. Knowledge of relevant information, including risks and benefits. 2. Understanding or rational reasoning that reveals a decision that is consistent with the individual's values, competence. And 3. Voluntariness as stated. Choice without coercion. Grisso, 2003. Kennedy, 1999. Stavis, 1991. Stavis et al., 1999. Sundram et al., 1993. When investigating an allegation of sexual abuse, the facility must conduct a thorough investigation to determine the facts specific to the case investigated, including whether the resident had the capacity to consent and whether the resident actually consented to the sexual activity. A resident's voluntary engagement in sexual activity may appear to mean consent to the activity. In these instances, if the facility has reason to suspect that the resident may not have the capacity to consent, the facility must protect the resident from potential sexual abuse while the investigation is in progress. See Section 483.12c3. Determinations of capacity to consent depend on the context of the issue, and one determination does not necessarily apply to all decisions made by the resident. For example, the resident may not have the capacity to make decisions regarding medical treatment, but may have the capacity to make decisions on daily activities, e.g., when to wake up in the morning, what activities to engage in. Determinations of capacity in this context are complex and cannot necessarily be based on a resident's diagnosis alone. Capacity on its most basic level means that a resident has the ability to understand potential consequences and choose a course of action for a given situation. Decisions of capacity to consent to sexual activity must balance considerations of safety and resident autonomy, and capacity determinations must be consistent with state law, if applicable. The facility's policies, procedures, and protocols should identify when, how, and by whom determinations of capacity to consent to a sexual contact will be made, and where this documentation will be recorded. See also 42 CFR. Section 483.10 FF 561 for concerns related to the resident's right to self-determination through support of resident choice, and 42 CFR Section 483.10 B37 F 551 for concerns related to the exercise of the resident's rights by the resident representative. Note: CMS is not requiring facilities to adopt a specific approach in determining a resident's capacity to consent. However, the facility administration, nursing, and medical director may wish to consider establishing an ethics committee that includes legal consultation in order to assist in the development and implementation of policy related to aspects of quality of life and or care, advance directives, intimacy and relationships. Cognitive functioning may change due to health issues such as, but not limited to, stroke, dementia, depression / psychiatric illnesses, or other impacts such as medication-s, hearing / visual loss, and stress. Therefore, the facility should continue to monitor and evaluate a resident's capacity to consent over time, as needed, based on the individual resident's physical, mental, and psychosocial needs. See also 42 CFR Section 483.10 G14 F 580. Notification of changes. Residents with designated or legally appointed representatives. A resident may have a representative that has been appointed legally under state law through, for example, a power of attorney, guardian, limited guardian, or conservatorship. These legal Appointments vary in the degree that they empower the appointed representative to make decisions on behalf of the resident, while a legal representative may have been empowered to make some decisions for a resident. It does not necessarily mean that the representative is empowered to make all decisions for the resident. The individual arrangements for legal representation will have to be reviewed to determine the scope of authority of the representative on behalf of the resident. A resident may also have designated an individual to speak on his or her behalf for decisions for care or other issues. However, it is necessary for the resident, his or her representative, and the facility to have a clear understanding of the types and scope of decision-making authority the representative has been delegated. Any decision-making power that is not legally granted to a representative under state law is retained by the resident. It is the responsibility of the facility to ascertain what decisions the representative is legally empowered to make on behalf of the resident. More specifically, regarding consent for sexual activity, state law and the legal instruments setting up resident representation may be silent on that topic. The facility must be aware of the representative's scope of authority regarding resident decision-making. When a resident with capacity to consent to sexual activity and his or her representative disagree about the resident engaging in sexual activity, the facility must honor the resident's wishes. Irrespective of that disagreement, if the representative's legal authority does not address that type of decision-making for sexual activity, if the resident representative's legal authority addresses decision-making for sexual activity, then the facility must honor the resident representative's decision consistent with 42 CFR Section 483.10b. Note, CF 551 at 42 CFR Section 483.10b6 if the facility has reason to believe that a resident representative is making decisions or taking actions that are not in the best interests of a resident, the facility shall report such concerns in the manner required under state law. Indicators of potential sexual abuse. In addition to reports from residents and others that sexual abuse occurred, possible physical indicators of sexual abuse that would require investigation by the facility and survey team include, but are not limited to, bruises around the breasts, genital area or inner thighs, unexplained sexually transmitted disease or genital infections, unexplained vaginal or anal bleeding and slash or torn, stained, or bloody underclothing. Literature indicates that the most prevalent psychosocial outcomes of abuse are depression, anxiety, and post-traumatic disorder 3. Other possible outcomes of sexual abuse 45 may include sudden or unexplained changes in the following behaviors and slash or activities, such as fear or avoidance of a person or place, of being left alone, of the dark, nightmares and slash or disturbed sleep. Allegations of sexual abuse. There are additional considerations when investigating allegations of sexual abuse involving sexual abuse by a staff member, resident-to-resident sexual abuse, and sexual abuse by a spouse or visitor. For any alleged violation of sexual abuse, the facility must immediately implement safeguards to prevent further potential abuse. Immediately report the allegation to appropriate authorities. Conduct a thorough investigation of the allegation, and thoroughly document and report the result of the investigation of the allegation. See tags F609C, Section 483.1 2B5, 483.12 C1 and C4, and F610C, Section 483.12 C2. C3 and C4. Allegations of staff to resident sexual abuse. Nursing home staff are entrusted with the responsibility to protect and care for the residents of that facility. Nursing home staff are expected to recognize that engaging in a sexual relationship with a resident, even an apparently willingly engaged and consensual relationship, is not consistent with the staff member's role as a caregiver and will be considered an abuse of power. Also, for some healthcare professionals, it is prohibited by licensure or certification. Requirements for professionals to have a relationship with a resident or patient. Note: refer to applicable state professional licensure/certification requirements and /or. Scope of practice: any sexual relationship between a staff member and a resident with or without diminished capacity may constitute sexual abuse in the absence of a sexual relationship that existed before the resident was admitted to the facility, such as a spouse or partner, and must be thoroughly investigated. However, in a rare situation, it may not be considered to be sexual abuse when a nursing home employee has a pre-existing sexual relationship with an individual, i.e., spouse or partner, who is then admitted to the nursing home, unless there are concerns about the relationship not being consensual. Allegations of resident-to-resident sexual abuse. Studies show that a considerable amount of unwanted sexual contact in nursing homes may be initiated by a resident who is sexually aggressive as a result of disease processes such as brain injuries or dementia. In addition, a resident may have a preoccupation for sexual activity or have had a prior history of sexual abuse. The resident who is sexually aggressive may target a resident who is unable to protect him/herself and may involve various types of sexual aggression such as fondling both over and under clothing, masturbation in the presence of another resident, and is unwanted by that other resident, forcing oral sex or sexual intercourse. If there is an allegation that a resident did not wish to engage in sexual activity with another resident or may not have the capacity to consent, the facility must respond to it as an alleged violation of sexual abuse. Allegations of visitor-to-resident sexual abuse. In certain situations, sexual activity between a resident and a visitor, e.g., spouse, partner, may not be considered to be abuse if there was a pre-existing sexual relationship. The resident has the capacity and ability to consent, and the resident wishes to continue with the sexual relationship. Regardless, the nursing home must ensure that a visitoress is not subjecting any residentess to sexual abuse. In addition, the nursing home staff must immediately act on any allegation or suspicion that a visitor is engaging in improper sexual activity with a resident. See F609 and F610. Response to alleged violations of sexual abuse. If an allegation of sexual abuse has been reported, the facility must immediately protect the alleged victimess involved, report the alleged violations to the administrator and appropriate state and local authorities, and begin an investigation of the allegation. See 42. CFR Section 483.12, C14, F609 reporting of alleged violations, and F610 response to alleged violations. As the facility conducts its investigation, the facility must not tamper with evidence. Tampering with evidence would impede completion of a thorough investigation by the facility and other investigating authorities. Examples of tampering include, but are not limited to, washing linens or clothing, destroying documentation, bathing or cleaning the resident until the resident has been examined, including a rape kit, if appropriate, or otherwise impeding a law enforcement investigation. If the surveyor identifies that the facility has tampered with evidence, the surveyor should investigate whether the facility is in compliance with F607 and F610. Determination of findings and potential to foresee abuse. It has been reported that some facilities have identified that they are in compliance with F600, free from abuse and neglect, because that they could not foresee that abuse would occur, and they have done everything to prevent abuse, such as conducted screening of potential employees, assessed residents for behavioral symptoms, monitored visitors, provided training on abuse prevention, suspended or terminated employment of the perpetrator, developed and implemented policies and procedures to prohibit abuse, and met reporting requirements. However, this interpretation would not be consistent with the regulation, which states that the resident has the right to be free from verbal, sexual, physical, and mental abuse. Therefore, if the survey team has investigated and collected evidence that abuse has occurred, it is appropriate for the survey team to cite the current or past noncompliance at F600 free from abuse and neglect. Determination of past noncompliance. Past noncompliance occurs when noncompliance has occurred in the past, but the facility corrects the deficiency and is in substantial compliance at the time of the current survey. Prior to citing a deficiency as past noncompliance, surveyors should investigate each instance thoroughly to determine if the facility took all the appropriate actions to correct the noncompliance and determine the date on which the facility had returned to substantial compliance. More specifically, a deficiency citation at past noncompliance meets the following three criteria. 1. The facility was not in compliance with the specific regulatory requirement tests at the time the situation occurred. 2. The noncompliance occurred after the exit date of the last standard recertification, survey, and before the survey standard, complaint, or revisit currently being conducted, and 3. There is sufficient evidence that the facility corrected the noncompliance and is in substantial compliance at the time of the current survey for the specific regulatory requirement tests, as referenced by the specific FDAG or KTAG. The surveyors must document the facility's corrective actions in the CMS 2567. The facility is not required to submit a plan of correction. Refer to SOM Section 7510.1 and 7510.2 for additional guidance and information on findings of past noncompliance. Note: when a facility has identified abuse, the facility must take all appropriate steps to remediate the noncompliance and protect residents from additional abuse immediately. Facilities that take immediate action to correct any issues can reduce the risk of further harm continuing or occurring to other residents, thereby potentially preventing the scope and severity of the deficiency from increasing. Failure to take steps could result in findings of current noncompliance and increased enforcement action, including, but are not limited to, the following: taking steps to prevent further potential abuse, see F600, 483.12a, and F610, 483.1, 2C3. Reporting the alleged violation and investigation within required timeframes, see F609, Section 483.1, 2C1 and C4. Conducting a thorough investigation of the alleged violations, see F610, 483.1, 2C2. Taking appropriate corrective actions, see F610, Section 483.1, 2C4, and the facility must revise the resident's care plan if the resident's medical, nursing, physical, mental, or psychosocial needs or preferences change as a result of an incident of abuse, see tag F656, Section 483.21b. Neglect. Note: for purposes of this guidance, staff includes employees, the medical director, consultants, contractors, volunteers, Staff would also include caregivers who provide care and services to residents on behalf of the facility, students in the facility's nurse aid training program, and students from affiliated academic institutions, including therapy, social, and activity programs. The link between noncompliance at residence, rights/quality of care/quality of life, and neglect of goods and services. Neglect at F600 should not automatically be cited, in addition to the resident's rights/quality of care/quality of life tags, while the latter citations identify potential or actual negative outcomes in the areas of residents' rights, quality of care, and quality of life. Neglect identifies the facility's failure to provide the required structures and processes in order to meet the needs of one or more residents. This may include, but is not necessarily limited to, the facilities failure to provide necessary staff, supplies, services, policies, training, or staff supervision, and oversight to meet the residents' needs. Noncompliance at tags such as F686 and F689 do not automatically indicate noncompliance. At F600 for neglect, for example, a survey team identifies that a facility had failed to perform a skin assessment for a resident, resulting in failure to implement interventions to prevent the development of an avoidable stage 2 pressure ulcer for a resident. Upon further investigation, the survey team finds that the facility identified the pressure ulcer and treated it with no further worsening. While the survey team would identify noncompliance at F686, the facility would not generally be cited at F600 as well. Another example is when a resident requires supervision when ambulating, and a staff member fails to provide assistance to the resident, resulting in a fall. In this scenario, the survey team would identify noncompliance at F689. However, the facility would not be cited at F600 for neglect. In both of these examples, a citation for neglect would require additional evidence that identifies that the facility knew, or should have known, to provide the staff, supplies, services, policies, training, or staff supervision and oversight to meet the residents' needs, but continue to fail to take action necessary to avoid the potential for harm or actual harm to the resident. Identifying neglect. Neglect is defined at Section 483.5 as the failure of the facility, its employees or service providers to provide goods and services to a resident that are necessary to avoid physical harm, pain, mental anguish, or emotional distress. Neglect occurs when the facility is aware of, or should have been aware of, goods or services that a residentess requires, but the facility fails to provide them to the residentess. That has resulted in or may result in physical harm, pain, mental anguish, or emotional distress. Neglect includes cases where the facility's indifference or disregard for resident care, comfort, or safety resulted in or could have resulted in physical harm, pain, mental anguish, or emotional distress. Neglect may be the result of a pattern of failures, or may be the result of one or more failures involving one resident and one staff person. Neglect of goods or services may occur when staff are aware, or should be aware, of residents' care needs based on assessment and care planning, but are unable to meet the identified needs due to other circumstances, such as lack of training to perform an intervention, e.g., suctioning, transfers, use of equipment, lack of sufficient staffing to be able to provide the services, lack of supplies, or staff lack of knowledge of the needs of the resident. Examples include, but are not limited to, a nurse aide was assigned to care for several residents who required assistance to eat, drink, dress, bathe, toilet, walk, and positioning in bed or chair. Due to the workload and resident care requirements, The nurse aide is unable to respond to call lights or complete the assignments for all of the residents that she is assigned to provide care. 4. In addition, due to insufficient numbers of staff in the facility, there is no other nurse aide available to assist her. This inability of the nurse aides in this unit to respond, to call lights, and to complete resident care assignments occurs throughout the shift, resulting in omissions in delivery of services to meet the residents' needs. Physical harm occurred as a result of the lack of sufficient staff to implement the care plan as ordered and inadequate supervision to assure that care was provided as ordered and or as planned. In addition, staff had reported to administration their concerns about not meeting the residents' needs, but administration failed to respond. The nursing home utilizes temporary staffing agencies, but does not have processes in place to provide orientation or medical or care plan information for the temporary staff regarding the individual residents' needs on the unit to which the temporary employee is assigned. The nursing home failed to respond to residents refusing to bathe/shower based on complaints of cold water during bathing/showering. Maintenance staff identified equipment failures and reported them to the facility's administrator with recommendations to replace the water heating system. However, the administrator did not address these failures, resulting in the diminished quality of life for residents. Identification of goods and services required by residents. When a resident is admitted to a nursing home, the nursing home has determined that it has the capability and capacity to provide goods and services to meet the needs of the resident by its staff. See, for example, requirements at Section 483.10 Resident Rights, Section 483.2 for Quality of Life, and Section 483.2 5 Quality of Care. In addition, other services as needed by the resident must be assessed and addressed by the nursing home. This does not mean that all services must be directly provided by the nursing home, but the nursing home must assist and or make referrals for the resident to receive necessary services. Examples of structures and processes in the facility include, but are not limited to, the following structures: the nursing home's capability and capacity to provide needed care, and services such as a facility's assessment to determine what resources are necessary to care for its residents competently, the provision of sufficient numbers of qualified, trained staff based upon the facility's assessment and as needed to meet resident needs, an effective orientation, training, and evaluation program, which includes, but is not limited to, nursing home resident care policies specific to residents' identified care needs, resident care requirements based upon assignments and duties including types of services and treatments required for each resident, and other interventions necessary to meet a resident's needs. Oversight and monitoring of staff performance, including conducting performance evaluations for direct care staff nurse aides, and how weaknesses or training needs are addressed. Oversight and monitoring of contracted services or services provided under arrangement. Resident care policies and procedures to ensure that the facility provides care and services in accordance with current standards of practice that address residents' diagnosis and that provide clinical and technical direction to meet the needs of each resident admitted. Sufficient amounts of food to meet dietary needs. Availability of medications and supplies necessary to provide care. Implementation of an infection control and prevention program that includes staff procedures for care including hand hygiene, standard and transmission-based precautions, including use of PPE. A safe and sanitary environment. O. Provision of sufficient clean linens. O. Adequate and appropriate equipment and devices and other available technology, including procedures for how to use, clean, maintain, and store equipment, and O. If admitted, the provision of specialized services for residents who require rehabilitation services, dialysis, respiratory therapy, mechanical ventilation, or oxygen therapy, Roman IV therapy, and hospice. Processes so that the needs of each resident are met based upon O. Initial and ongoing assessments of the clinical needs of the resident, including any acute changes in condition, such as cardio/respiratory failure, choking, hemorrhaging, poor glycemic control, onset of delirium, behavioral emergencies, or falls resulting in head injuries or fractures. O. The provision and implementation of a resident-specific care plan, including the ongoing evaluation and revision of the care plan as necessary, and O. Ongoing monitoring and supervision of staff to assure the implementation of the care plan as written. The cumulative effect of different individual failures in the provision of care and services by staff leads to an environment that promotes neglect. Neglect occurs when the facility is aware of, or should have been aware of, goods or services that a residentess requires but the facility fails to provide them to the residentess, resulting in, or may result in, physical harm, pain, mental anguish, or emotional distress. Examples of individual failures include, but are not limited to, the following: failure to provide sufficient, qualified, competent staff to meet residents' needs, failure to provide orientation and/or training to staff, failure to provide training on new equipment or new procedures or medications required for the care of a specified resident or required due to changes in acceptable standards of practice, failure to oversee the implementation of resident care policies, failure to provide supervision and/or monitoring of the delivery and implementation of care, failure of staff to implement resident interventions even when residents are assessed and interventions are identified in the care plan, failure to identify, assess, and/or contact a physician and/or prescriber for an acute change in condition and/or a change in condition that requires the plan of care to be revised to meet the resident's needs in a timely manner, failure to ensure staff respond correctly to medical or psychiatric emergencies, failure to implement an effective communication system across all shifts for communicating necessary care and information between staff, practitioners, and resident representatives, failure to monitor and/or provide adequate supervision to assure that environmental hazards are not present, including, but not limited to O. Access to hot water of sufficient temperature to cause tissue injury, O. Non-functioning call system without a compensatory action, O. Improper handling/disposal of hazardous materials, chemicals, and waste, O. Infestation by insects/rodents, failure to provide adequate monitoring and supervision if smoking is allowed, failure to meet financial obligations for the delivery of care and the maintenance of the facility, e.g. payment for staff, utilities, contractors, failure of the Quality Assurance and Assessment Committee to develop and implement appropriation action plans to correct identified quality deficiencies, failure of administration to effectively and efficiently use its resources to attain or maintain the highest practicable physical, mental, and psychosocial well-being, and failure to provide oversight of medical services that are provided in the facility. The failure to provide necessary care and services resulting in neglect may not only result in a negative physical outcome, but may also impact the psychosocial well-being of the resident, with outcomes such as mental anguish, feelings of despair, abandonment, and fear. Refer to Psychosocial Outcome Severity Guide. Investigative Summary for Abuse and Neglect Investigation of Allegations of Abuse. The process to review concerns are outlined in the Abuse Critical Element Pathway Form. CMS 20059. Summary of Procedures. Identify if there is an alleged violation of abuse, physical punishment, or allegations of an individual depriving a resident of care or services. Refer to the Neglect Critical Element Pathway Form CMS 20130 to investigate concerns about structures or processes leading to a residentess failing to receive required care and services. Refer also to the Investigative Protocol for F607, policies and procedures related to allegations of retaliation by the facility against a covered individual, for an allegation of retaliation, and F609 reporting reasonable suspicion of a crime, if a covered individual did not report a reasonable suspicion of a crime. Note, if you receive an unreported allegation of abuse, report this immediately to the facility administrator or person in charge. Use observations, interviews, and record review to gather and corroborate information related to the alleged abuse, including anything that could have placed the alleged victim at risk for abuse, who was involved, what happened, and when and where did it happen, any injuries and or physical psychosocial outcomes, including whether interventions medical treatment was required, details of actions taken, including protecting the residentess, reporting, investigating, and corrective actions, whether there is any indication that retaliation may have occurred, and what types of training and or orientation staff may have received related to abuse. For specific allegations of abuse, the surveyor should review. For allegations of staff to resident abuse, staffing rosters to determine staffing at the time of the alleged abuse, time cards for staff on duty at the time, and conduct staff. Interviews to determine whether there was adequate monitoring and supervision of staff at the time of the allegation. The surveyor should also review staff training logs to determine whether staff was trained on abuse prevention and review the alleged perpetrator personnel records, including screening and disciplinary records, if any. For allegations of resident-to-resident abuse, whether there is a history of distressed behaviors that could place residents at risk, whether resident assessments identified concerns related to behavior, mood, cognitive status, communication, and mobility, and whether care planning addressed the concerns identified with specific interventions, whether interventions were implemented, and whether there was adequate monitoring and supervision of the residentess. For allegations of visitor-to-resident abuse, whether there was any indication of risk to the residentess, and whether adequate monitoring and supervision were provided as appropriate. If tag F600 is cited for abuse, the survey team includes the following language at the beginning of the deficient practice statement on the form CMS 2567, based on observations /interviews /record review. The facility failed to protect the resident's right to be free from types of abuse, mental abuse /verbal abuse /physical abuse /sexual abuse /deprivation of goods and services by perpetrator type, staff /a resident /a visitor. Investigation for allegations of neglect. The process to review concerns are outlined in the Neglect Critical Element Pathway. Form CMS 20130. Use the Neglect Critical Element C pathway and the above guidance when investigating concerns related to structures or processes that have led to resident outcome, such as unrelieved pain, avoidable pressure injuries, avoidable dehydration, lack of continence care, or malnourishment. Utilize appropriate critical element pathways for care issues in order to identify whether noncompliance for a care concern exists first and determine whether further investigation is needed as to whether the facility has the structures and processes to provide necessary to provide goods and services to residents. Summary of procedures. Interview staff and review facility policies and procedures to determine how the facility monitors and provides oversight of the provision of care and services, and how the facility responds when there are concerns that a residentess is not receiving necessary goods and services. If tag F600 is cited for neglect, the survey team includes the following language at the beginning of the deficient practice statement on the form CMS 2567, based on observations/interviews/record review. The facility failed to protect the resident's right to be free from neglect. Key elements of noncompliance for abuse and neglect section 483.12A1. To cite deficient practice at F600, the surveyor's investigation will generally show that the facility failed to protect a resident's right to be free from any type of abuse, including corporal punishment and neglect that results in or has the likelihood to result in physical harm, pain, or mental anguish, or failed to ensure that a resident was free from neglect when it failed to provide the required structures and processes in order to meet the needs of one or more residents. Potential tags for additional investigation. During the investigation, the surveyor may have determined that concerns may also be present with related outcome, process, and or structure requirements. The surveyor is cautioned to investigate these related requirements before determining whether non-compliance may be present. Some examples of related requirements that should be considered include the following. Section 42, CFR Section 483.10 F4 Roman 2V, F563 visitation rights. Determine if the facility provided immediate access and visitation by family, designated representatives, or other individuals, subject to reasonable restrictions, and the resident's right to deny or withdraw consent. Section 42, CFR Section 483.10 F4 Roman 6, F564 Resident Right to Visitors. Section 42, CFR Section 483.10 G1, F572 Notice of Rights and Rules. Section 42, CFR Section 483.10H, F583 Personal Privacy/Confidentiality of Records. Section 42, CFR Section 483.12 A34, F606 Not employ/engage staff with adverse actions. Section 42, CFR Section 483.1 2B14, Section 483.1 2B5, F607 Develop/implement abuse/neglect, etc. policies. Section 42, CFR Section 483.12 C1, 4, Section 483.12 2B5, F609 Reporting of alleged violations. Section 42, CFR Section 483.12 C2, 4, F610 Alleged violations investigate/prevent/correct. Section 42, CFR Section 483.24, F675 Quality of Life. Section 42, CFR Section 483.2, 5D, F689 Free of accident hazards/supervision/devices. Determine if the facility ensured that the resident environment remains as free from accident hazards as is possible and each resident receives adequate supervision to prevent accidents related to resident-to-resident altercations, where the resident's action is not willful. Section 42, CFR Section 483.35, 483.35a, and Section 483.3, 5 CF 725, and F 726, sufficient and competent staff. Section 42, CFR Section 483.3, 5A3 and A4. Section 483.3, 5C, F 726, competent staff. Section 42, CFR Section 483.40 BB1, F 742 treatment/SVC for mental/psychosocial concerns. Section 42, CFR Section 483.75, G2 Roman 2F, 867, QAA activities. Section 42, CFR Section 483.95C, F 942 abuse, neglect, and exploitation training. Section 42, CFR Section 483.9, 5G, F 946 required in-service training for nurse aid. Deficiency Categorization Section 483.12A1. In addition to actual or potential physical harm, always consider whether psychosocial harm has occurred when determining severity level. See Psychosocial Outcome Severity Guide. As the Psychosocial Outcome Severity Guide, located in the Nursing Home Survey Resources folder, describes, to apply the reasonable person concept, the survey team should determine the severity of the psychosocial outcome or potential outcome the deficiency may have had on a reasonable person in the resident's position, i.e., what degree of actual or potential harm would one expect a reasonable person in the resident's similar situation to suffer as a result of the noncompliance. Generally, when applying the reasonable person concept, the survey team should consider the following as it determines the outcome to the resident, which include, but is not limited to, the resident may consider the facility to be their home, where there is an expectation that he/she is safe, has privacy, and will be treated with respect and dignity. The resident trusts and relies on facility staff to meet his or her needs. The resident may be frail and vulnerable. Determining the severity of psychosocial outcomes for abuse can present unique challenges to surveyors, given that the psychosocial outcome of abuse may not be apparent at the time of the survey. It is important for the survey team to apply the reasonable person concept in evaluating the severity of psychosocial outcomes. It is important for the surveyor to gather and document any information that identifies any psychosocial outcomes resulting from the noncompliance. 4. Abuse. Surveyors should also consider that the psychosocial outcome of abuse may not be apparent at the time of the survey. For example, a resident who was raped may demonstrate indifference to the incident at the time of the survey. In addition, residents may not be able to express themselves due to a medical condition and/or cognitive impairment, e.g., stroke, coma, Alzheimer's disease, not be able to recall what has occurred, or may not express outward signs of physical harm, pain, or mental anguish. However, when a nursing home resident is treated in any manner that does not uphold a resident's sense of self-worth and individuality, it dehumanizes the resident and creates an environment that perpetuates a disrespectful and/or potentially abusive situation for the residentess. There are situations that are likely to cause psychosocial harm, which may sometimes take months or years to manifest and have long-term effects on the resident and his or her relationship with others. Therefore, during a survey, immediate jeopardy or actual harm may be supported when there is not an observed or documented negative psychosocial outcome, or a Description of resident impact from the resident's representative or others who know the resident. Numerous situations involving abuse are likely to cause serious psychosocial harm, i.e., immediate jeopardy to a resident who is a victim of these types of actions. These situations include, but are not limited to, sexual assault, e.g., rape, unwanted sexual touching, sexual harassment, any staff to resident physical, sexual, or mental/verbal abuse. Note: sexual abuse does not include the rare situation where a nursing home employee has a pre-existing and consensual sexual relationship with an individual, i.e., spouse or partner, who is then admitted to the nursing home unless there are concerns about the relationship not being consensual. Staff posting or sharing demeaning or humiliating photographs or videos of nursing home residents. When facility staff, as punishment, threaten to take away the resident's rights, privileges, or preferred activities, or withhold care from the resident. Any resident-to-resident physical abuse that is likely to result in fear or anxiety. According to the Social Security Act sections, Section 1819 C1A Roman II and 1919 C1A Roman II, every resident has the right to be free from mental or physical abuse. A reasonable person would not expect that they would be harmed in his or her own home or a healthcare facility and would experience a negative psychosocial outcome, e.g., fear, anxiety, anger, humiliation, a decline from former social patterns. In incidents in which one resident abuses another resident, if a reasonable person would likely suffer actual harm as a result of the incident should not be cited below severity level 3 actual harm. Note: surveyors should refer to the guidance related to physical, mental/verbal, and sexual abuse and deprivation of goods and services by staff. Examples of severity level 4: noncompliance, immediate jeopardy to resident health or safety include, but are not limited to, the facility failed to protect a resident from sexual abuse when resident 1 was found in resident 2 bedroom. Resident 1 was holding resident 2, whose clothes had been partially removed and her breasts were exposed. Resident 2 was severely cognitively impaired. Resident 1 had a known history of sexually inappropriate behaviors, but there was no evidence that the facility had assessed and revised the care plan to identify the potential risks to other residents related to the behaviors. There was no evidence that resident 2 could consent to sexual activity with other residents. Based on interview with resident 2 daughter, the daughter described her shock about the incident and how her mother would have been upset because this type of inappropriate, unwanted sexual contact would reasonably cause anyone to have psychosocial harm. It can be determined that the reasonable person in the residence position would have experienced severe psychosocial harm, dehumanization, and humiliation as a result of the sexual abuse. The facility failed to ensure that a resident was free from physical abuse. A resident who required one supervision due to physical aggression was observed to have escalating behaviors, resulting in striking out at staff and residents in the vicinity. The staff failed to ensure that residents in the vicinity were safe, and the resident pushed another resident who was walking to his or her room while unsupervised by staff, as described by housekeeping staff who witnessed the incident. The victim fell to the floor with a resulting fracture to her arm that required treatment at the hospital, placement of a cast, and was in moderate pain due to the fracture. Even though there was no significant decline in mental or physical functioning, it can be determined that the reasonable person would have experienced severe psychosocial harm as a result of the physical abuse, since a reasonable person would not expect to be injured in this manner in his or her own home or a healthcare facility. The facility failed to ensure that a resident was free from mental abuse and corporal punishment. A resident who had a cognitive disability carried a doll around with her. Throughout the day, during an activity, the resident placed the doll in a chair next to her and refused to allow another resident to use the chair. The staff slapped the resident's hand and removed the doll so the other resident could sit down. The staff told the resident she could not attend any more activities with the doll, or he would get rid of it and the resident would never see it again. The resident began to scream, cry for her doll, and left the room. The resident will not leave her room to attend any activities for fear that the staff person will take her doll. The resident's behavior has declined and now cries and expresses fear when taken for bathing and meals without her doll. Based on the resident's behavior, it can be determined that the resident experienced severe psychosocial harm as a result of the mental abuse and corporal punishment. The facility deprived residents of care related to the failure of staff to respond timely to residents' requests and treat residents with dignity and respect, which resulted in ongoing embarrassment, humiliation, and the failure to provide incontinence care as needed to meet the needs of several residents, based on family and resident group interviews. Other residents and their family members complained that residents often waited a long time, up to an hour, before staff took them to the bathroom, resulting in residents urinating in their beds and lying in urine for long periods of time. Residents indicated that this is a problem, especially on the night shift. Residents were told by nurse aides to just urinate on their beds and staff would change the sheets in the morning. 2 night shift staff members confirmed that they had seen other staff disconnect call lights in residents' rooms so that they were not functioning. After investigation, it was determined that the nursing home failed to provide the necessary care. Note, in this example, the surveyor had already identified noncompliance at dignity F550 and urinary incontinence F690. It can be determined that the reasonable person in the resident's position would have experienced severe psychosocial harm, e.g., embarrassment, humiliation as a result of the abuse. The facility deprived a resident of care by failing to provide access for resident communication and response to residents' requests for necessary care, resulting in the residents' ongoing fear and anxiety. During a survey, the surveyor observed that residents' call light was pinned to a privacy curtain that was out of reach of the resident. The resident stated that the staff removes the call light at night because the nursing staff said he used it too much, and they did not have time to answer the light all the time. The resident began crying and expressed fear that something would happen, and he would have no way of getting assistance, as staff would not come if he called out for help. Based on the resident's behavior, it can be determined that the resident experienced severe psychosocial harm as a result of the deprivation of care. The facility failed to protect a resident from sexual abuse, resulting in serious psychosocial harm. A resident with moderate confusion and who was dependent on staff for care reported to staff that she was touched down there and identified the alleged perpetrator. However, staff, who thought the resident was confused, did not report her allegation to facility administration and failed to provide protection for the resident, allowing ongoing access to the resident by the alleged perpetrator. The resident expressed recurring fear whenever the perpetrator approached the resident, exhibited crying and agitation, and declined to leave her room. Based on the resident's behavior, it can be determined that the resident experienced severe psychosocial harm as a result of the sexual abuse. The facility failed to protect 2 residents from mental abuse and extreme humiliation, perpetuated by 2 staff who posted videos and photographs on social media of the Residents during bathing, using the bathroom and grooming, which included nude. Photos and photos of genitalia. In addition, on the videos, the two staff verbally taunted and made cruel remarks to the residents, including making fun of the way the resident looked and acted. One resident who was cognitively impaired was shown on the video to be crying in response to the remarks made to her by the staff. One resident, who was cognitively intact, told surveyors that he was extremely humiliated and angry when he found out that these items were posted. Based on the resident's behavior, it can be determined that the resident experienced severe psychosocial harm as a result of the mental abuse. The facility failed to ensure that a resident was free from neglect when it did not have the structures to provide necessary goods and services to residents. During facility tour, the surveyor noted a strong urine odor. Residents were observed to be in bed with soiled clothes and linens. Residents told the surveyor that they did not get out of bed or dressed since there were not enough nurse aides to assist them. During interviews with nurse aides, it was reported that the facility lacked supplies, such as incontinence briefs, laundry/housekeeping supplies, gloves, and food. Interview with the director of nurses revealed that the medical supply vendor was suspended and no longer providing supplies to the facility due to non-payment. Multiple staff also reported not receiving their last paychecks. During interviews with residents reported mice in their rooms. During observation of the kitchen and interview with the dietary manager, there was evidence of rodent infestation, including staff seeing rodents eating and finding torn bags and crumbs on the floor. The administrator reported that the pest control company had visited the facility recently, but there was no record of the visit or proposal for remediation. Also, there was no sanitizer for the dishwasher and no alternative method for sanitizing dishes. It can be determined that the reasonable person in the resident's position would have experienced severe psychosocial harm, e.g., embarrassment, humiliation, anxiety as a result of neglect. Examples of severity level 3 noncompliance actual harm that is not immediate jeopardy include, but are not limited to: the facility failed to protect a resident from physical abuse when resident 1 slapped resident 2 in the face. Based on resident and staff interviews, resident 1 had previously exhibited an aggressive tone towards other residents. Based on the interview with the nurse aide, resident 2 was talking loudly to resident 1 in the hallway. Resident 1 shouted profanity to resident 2, followed by, "If you say one more word, you're going to be sorry." The nurse aide was the only staff present in the area and was transferring another resident. The nurse aide could not intervene and did not call for assistance from other staff. Resident 2 continued to talk loudly. Resident 1 then reached out, slapped resident 2 on the left side of his face, and backed his wheelchair away from resident 2. Based on the assessment of resident 2, his left cheek exhibited some redness in the area that was slapped, but there were no other physical injuries. Based on the survey team's interview with resident 1 was also able to recall the incident and said, resident 2 just won't stop talking. I don't know what came over me." Resident 2 was moderately cognitively impaired and when interviewed could not recall the incident. The survey team interviewed resident 2's son, who said that his father would have been mad after an incident like this. Therefore, by using the reasonable person concept, the survey team would conclude that resident 2 would have experienced psychosocial harm, e.g. anger, directed at the action or at a person as a result of the physical abuse, since there is an expectation that the resident would not be slapped in the face in the facility. The facility neglected to provide supervision and monitoring to assure that continence care is provided with dignity, respect, and meets the needs of a resident. During a complaint survey, the investigation revealed that a cognitively impaired resident had been left with his body partially uncovered and unattended for several hours. Also, the investigation also identified that his catheter bag had been left lying flat on the bed, so that urine could not flow freely or drain, resulting in expressions of pain and distress. Interview with the charge nurse revealed that she was the only nurse in the building during the night shift and stated that she was unable to monitor the nurse aide's provision of care because she was providing treatments on other units. It was identified that insufficient nurse staffing has been reported to the administration and that this was an ongoing concern. Based on the resident's behavior, it can be determined that the resident experienced psychosocial harm as a result of neglect. Examples of severity level 2 considerations: noncompliance, no actual harm, with potential for more than minimal harm that is not immediate jeopardy, include, but are not limited to: the facility failed to protect resident 2 from verbal abuse. During the interview with resident 2, she mentioned that she does not get along with resident 1. Based on an interview with staff, resident 1 previously demanded resident 2 to sit up at the table, and that there was something wrong with her. However, staff would redirect the residents to separate tables to prevent any situation from escalating. According to interviews with other residents, one weekend, residents recall that temporary staff had placed resident 1 and 2 at the same table for a group activity. Resident 1 yelled to resident 2 to sit up straight a few times. However, staff in the room would not intervene. Resident 1 called resident 2 a derogatory name. Upon review of resident 1 and 2 records, there was no documentation related to altercations. Even though resident 2 did not have a reaction, it can be determined that the reasonable person would experience no actual harm with the potential for more than minimal psychosocial harm as a result of the verbal abuse. Severity level 1. No actual harm with potential for minimal harm. The failure of the facility to prevent abuse or neglect is more than minimal harm. Therefore, severity level 1 does not apply for this regulatory requirement. 1 CDC, 2016, Elder Abuse, Risk and Protective Factors, June. Accessed March 21, 2017. http://www.cdc.gov/violenceprevention/elderabuse/risk-protective factors HTML. 2 adapted from Latch, Mark S., Tony Rosen, Gina Teresi, Joseph P. Imick, Mildred Ramirez, Stephanie Silver, and Carl Pillemer, 2013. Verbal and physical aggression directed at nursing home staff by residents. Journal of General Internal Medicine, 660 to 667. 3 Dong, Xin Kai, Rui Jia Chen, Yixin Chang, and Melissa Simon, 2013. Elder Abuse and Psychological Well-Being, a Systematic Review and Implications for Research and Policy, a mini-review. Gerontology, 132 to 142. 4 adapted from Burgess, Ann W., Elizabeth B. Dowdell, and Robert Aprentke, 2000. Sexual Abuse of Nursing. Home Residents. Journal of Psychosocial Nursing and Mental Health Services, 10 to 18. 5 adapted from Burgess, Ann W., and Paul T. Clements, 2006. Information Processing of Sexual Abuse in Elders. Journal of Forensic Nursing, 113 to 120. Tag F600 2. Section 483.12. The resident has the right to be free from abuse, neglect, misappropriation of resident property, and exploitation as defined in this subpart. This includes, but is not limited to, freedom from corporal punishment, involuntary seclusion, and any physical or chemical restraint not required to treat the resident's medical symptoms. Intent Section 483.12. Each resident has the right to be free from misappropriation of property and exploitation. Note: refer to F609 for requirements related to reporting of a reasonable suspicion of a crime. Definitions: Section 483.12. Exploitation, as defined at Section 483.5, means taking advantage of a resident for personal gain through the use of manipulation, intimidation, threats, or coercion. Misappropriation of resident property, as defined at Section 483.5, means the deliberate misplacement, exploitation, or wrongful, temporary or permanent use of a residence, belongings, or money without the resident's consent. Guidance Section 483.12. Residence property includes all residents' possessions, regardless of their apparent value to others, since they may hold intrinsic value to the resident. Residents are permitted to keep personal clothing and possessions for their use while in the facility, as long as it does not infringe upon the rights of other residents. See F657. Examples of resident property include jewelry, clothing, furniture, money, and electronic devices, the resident's personal information, such as name and identifying information, credit cards, bank accounts, driver's licenses, and social security cards. Examples of misappropriation of resident property include, but are not limited to, identity theft, theft of money from bank accounts, unauthorized or coerced purchases on a resident's credit card, unauthorized or coerced purchases from residents' funds, a resident who provides a gift to staff in order to receive ongoing care based on staff's persuasion, and a resident who provides monetary assistance to staff after staff had made the resident believe that staff was in a financial crisis. Facility staff are in a position that may be perceived as one of power over a resident. As such, staff may be able to manipulate or unduly influence decisions by the resident. Staff must not accept or ask a resident to borrow personal items or money, nor should they attempt to gain access to a resident's holdings, money, or personal possessions through persuasion, coercion, request for a loan, or solicitation. For example, exploitation may include, but is not limited to, when a resident or resident representative has given his or her money or belongings to staff as a result of coercion, or because the resident or resident representative believes that it was necessary, e.g., in order to receive good care. A resident's apparent consent is not valid if it is obtained from a resident lacking the capacity to consent, or consent is obtained through intimidation, coercion, or fear, whether it is expressed by the resident or suspected by staff. Another example of misappropriation of resident property is the diversion of a resident's medication, including, but not limited to, controlled substances for staff use or personal gain. Investigative protocol for misappropriation of resident property and exploitation, Section 483.12. Objectives: to determine whether a residentess was free from misappropriation of resident property, and exploitation, F602. If the facility developed, implemented, and educated staff on policies and procedures that prohibit misappropriation of resident property and exploitation, F607. If the facility developed and implemented pre-employment procedures, F606, and how the facility protects, reports, investigates, and acts upon alleged violations of misappropriation of resident property and exploitation, F609, F610. Use this protocol during any type of survey as necessary in order to investigate an allegation of misappropriation of property or exploitation. Procedures, Section 483.12. Off-site survey preparation. Information related to an alleged violation may be obtained from reports from the Ombudsman or other state agencies. Any related previously cited deficiencies, Casper Report 3, and a complaint and / or facility self-report including name of alleged victim-s, alleged perpetrator-s and witnesses, if any. Narrative / specifics of the allegation-s, including frequency and pervasiveness of the allegation, and whether the allegation was reported by the facility and to other agencies. On-site survey activities. If a surveyor receives an allegation of misappropriation of resident property or exploitation, during the survey, he/she must immediately report this to the facility administrator or his or her designated representative. If the administrator is not present, the survey team should determine whether the facility then takes appropriate action in accordance with the requirements at F609 and F610. During the course of the investigation, if it is determined that the resident's property was misplaced and found and not misappropriated, or the property loss was not related to a facility failure to protect the property, e.g., resident/family accidentally disposed of the item or took the item home, the investigation may be stopped. Obtain and review the facility's policies and procedures related to misappropriation of resident property and exploitation. It is not necessary for these items to be maintained in one document or manual. Observation. Depending on the nature of the incident, the surveyor should conduct observations that are related to the allegation. Observations include, but are not limited to, for allegations of theft of medications, how medications are secured and accessed. For allegations of stolen property, where the property was stored, whether it was in a secure area, and how the property was accessed. Interview. The surveyor follows the guidelines below for interviews, which include, but are not limited to, conduct interviews in a private location, preferably seated in order to be able to maintain eye contact with the individual being interviewed. Be impartial, use discretion and non-judgmental language, and to the extent possible, ask open-ended, non-leading questions. Note, it is important to maintain the confidentiality of the names of the persons, to the extent possible, who reported the allegation. Conduct follow-up interviews, as necessary, to evaluate new information obtained, discrepancies or changes in information, and maintain documentation of interviews including dates, times, locations, and names of individuals interviewed. Note, it is important to attempt to obtain as accurate information as possible, and it may be necessary to obtain assistance from an interpreter if English is not the spoken language of the resident or staff. Resident/family interview. Interview the alleged victim privately. However, the alleged victim may request that another person be present. If so, be aware that the alleged victim may not be comfortable speaking openly in the presence of another person, and another interview may be necessary to follow up on any discrepancies identified. A resident with a cognitive impairment and / or mental illness may mistakenly be assumed to be an incompetent witness. In those situations, interview the alleged victim to the extent possible and corroborate statements with other observations. Interviews and record review. During the interview, observe the resident's emotions and tone, as well as any nonverbal expressions or gesturing to a particular body area in response to the questions. Interview the resident or resident's representative to determine for an allegation of misappropriation of resident property. What is missing? If the missing item is money, how much? For how long the item has been gone. Whether the resident has any idea of what might have happened to the item. Whether the resident suspects a specific person S was involved in the loss of the item S and the name, title if any, and / or relationship to the resident. O, whether the resident / family reported the missing property to facility staff, and if so, when and to whom, and the facility's response. O, whether local law enforcement or other outside agencies were notified, and if so, any response that they are aware of, and O, how the resident feels about losing the item. O, for an allegation of exploitation. O, when and where the alleged exploitation occurred. O, what occurred prior to, during, and immediately following the alleged exploitation. O, whether she can identify who was involved, including the alleged perpetrator, and / or any witnesses. O, why the resident gave the item to the alleged perpetrator or allowed the alleged perpetrator to take the item. O, how the resident values the item. O, whether she reported the alleged exploitation to the facility, when and to whom. Reported and the facility's response, and O, whether she feels safe, is afraid of anyone, or fearful of retaliation. Staff interview. Review staff attendance, records from any department to determine who was working at the time of the alleged misappropriation or exploitation, and who may have had access to the resident and / or the resident's room to collect information about. O, whether she had knowledge of the allegation and what actions, if any, she took in response to the allegation. O, any changes in the resident's behavior as a result of the allegation. O, whether an individual has been identified as the alleged perpetrator and how the alleged perpetrator and resident related to one another prior to and after the incident. O, whether she reported the allegation to management / administrative staff or any state or local agencies, and if so, to whom was the allegation reported and when. O, if not reported, what prevented him / her from reporting. O, whether she is fearful of retaliation. O, if she reported the allegation, whether she feels that retaliation has occurred as a result of reporting the allegation, and if so, what actions were taken against staff, and O, whether she has received training from the facility on misappropriation and exploitation identification, prevention, and reporting requirements. Alleged perpetrator interview. If the alleged perpetrator is a staff member, the staff member may have been suspended or assigned until the investigation is completed, and in some situations, the facility may have terminated the employment of the individual. In some cases, the alleged perpetrator may not be in the facility or may refuse to be interviewed. If possible, interview the alleged perpetrator either in person or by phone to determine what information she can provide regarding to the allegation of missing property or exploitation. Whether she was present in the nursing home at the time the alleged misappropriation of property or exploitation occurred. Whether she has any information on the allegation, such as O, when and where the alleged incident occurred, and O, if she has any other information that she wishes to share in regard to the investigation. Facility investigator interview. If the facility was aware of the allegation, identify the staff member responsible for the initial reporting and investigation of alleged misappropriation of resident property or exploitation. This may be the administrator in some facilities. Obtain a copy of the investigation report. Interview the responsible staff person to determine how the facility investigated the allegation of misappropriation or exploitation. If the facility did not know if the resident had the property prior to the alleged loss, and how the facility protects the resident's property from loss or theft. Whether local law enforcement or other outside agencies were notified, and if so, any response that they are aware of, and what findings and resolutions have occurred. Record review. It may be necessary to obtain copies of specific entries in the record for the period of time that is relevant to the allegation. Review the alleged victim's record to obtain necessary information as applicable, such as the diagnosis and physician orders including medications, the RI to include the resident's cognitive status, care plan and interventions/goals, physicians, nurses, social workers, and other staff members' progress notes as applicable, e.g. for investigation of drug diversion, whether there was indication of unrelieved pain during certain times of the day for residents who were prescribed the allegedly diverted medication. Any lists of resident valuables or resident items brought into the facility, and social and psychological history. If staff is identified as the alleged perpetrator, review the staff member's personnel file for information related to the allegation being investigated or history of other allegations. Adverse personnel actions taken relevant to exploitation or misappropriation of property. Screening that occurred prior to and during employment, and training and orientation related to abuse and neglect prevention. For an alleged theft of monies, if the resident's funds are managed or held by the facility, review the accounting records for the resident's funds, including receipts for expenditures from the resident's funds. Attempt to reconcile whether the items are in the resident's possession. Review interdisciplinary notes that relates to the alleged exploitation or misappropriation of property for documentation of the following. The date/time of the alleged exploitation/misappropriation and or the date/time when the alleged exploitation/misappropriation was first discovered. Any change in the alleged victim's mood and demeanor before and after the alleged misappropriation/exploitation, such as distrust, fear, e.g., fear of being touched or shying away from being touched, angry outbursts, tearfulness, agitation, trembling, cowering, panic attacks, and changes in sleeping patterns. Reports from other investigatory agencies. At the time of the survey, if another investigatory agency has completed its investigation, the surveyor should request a copy of the report. Other investigatory agencies may include State Adult Protective Services, State Professional Licensing Boards, and law enforcement/police. Reports. Interview with person responsible for quality assurance. Interview the person responsible for quality assurance activities. Determine how the committee is providing monitoring and oversight of potential and or actual reported allegations of misappropriation of resident property and exploitation. Evaluate whether the committee has made recommendations such as policy revision and or training. Administrator interview. The administrator is responsible for the overall implementation of the facility. Policies/procedures to prohibit misappropriation of resident property and exploitation. This includes the obligation to report, investigate, protect the alleged victim, and take corrective actions as necessary based upon the outcome of the investigation. Obtain and review the copy of the investigation report, if any. Note that some of this information may have already been obtained from the facility investigator. Interview the administrator to determine when she was notified of the alleged exploitation/misappropriation, and when the initial report was made to the required agencies and law enforcement as required. Who is responsible for the investigation, whether it has been completed, and the outcome, or whether the investigation is ongoing. When the results of the investigation were reported to the administrator and to the required agencies. O. Whether the alleged perpetrator, if an employee, had previous warnings or incidents at the facility. O. How the alleged victim and other residents at risk of exploitation/misappropriation were protected during the investigation. O. What actions were taken to prevent misappropriation and exploitation after the investigation was completed. O. Whether any changes were necessary to the facility's policies and procedures. O. How the facility assures that retaliation does not occur when staff or a resident reports an allegation of misappropriation of resident property or exploitation. O. What actions have been taken for education of staff and residents regarding the facilities, prevention plan and reporting requirements, and O. How does the facility protect the residents' property from loss or theft? Provide an opportunity for the facility to provide any other information regarding the alleged misappropriation of the residents' property or exploitation. Additional investigatory activities related to allegations of drug diversion. For allegations of drug diversion, the surveyor determines O. If there is evidence and / or potential outcomes such as unrelieved pain. For example, there may be evidence that on a particular shift or when a particular staff member is working, a resident's pain symptoms are not relieved to the extent possible, but the pain symptoms are relieved on other shifts. Based upon validated evidence, see also tag F697 for concerns related to pain management. O. Whether pharmacy policies at a minimum address safeguarding and access, monitoring, administration, documentation, reconciliation and destruction of controlled substances. See also tag F755 for concerns related to facility procedures for pharmacy services. O. Whether the pharmacist has established a system of records of receipt and disposition of all controlled drugs in sufficient detail to enable accurate reconciliation, and that the drug records are in order, and that an account of all controlled drugs is maintained and periodically reconciled. See also tag F755 for concerns related to responsibilities of the licensed pharmacist, and O. Determine whether the resident's clinical record provides accurate documentation of the administration of a controlled medication and resident outcomes related to the medication. Administration, see also tag F755 for concerns related to procedures for administration and documentation of controlled substances. If the surveyor, during the investigation, has determined that a resident's medications were diverted, the state agency should make referrals to the following agencies as appropriate, such as O. Drug Enforcement Administration, D. O. Local Law Enforcement, O. State Boards of Nursing, Pharmacy and Nursing Home Administrators, and / or O. Other agencies the SA is required to notify in accordance with state law. Key elements of noncompliance section 483.12. To cite deficient practice at F602, the surveyor's investigation will generally show that the facility failed to protect a resident's right to be free from misappropriation of resident property and / or exploitation. Potential tags for additional investigation. During the investigation, the surveyor may have determined that concerns may also be present with related outcome, process, and / or structure requirements. The surveyor is cautioned to investigate these related requirements before determining whether non-compliance may be present. Some examples of related requirements that should be considered include the following. Section 42, CFR Section 483.10E2, F557, right to have personal property. Section 42, CFR Section 483.10 F10I Roman 2, F567 Protection/Management of Personal Funds. Section 42, CFR Section 483.10I, F584, Safe Environment. Section 42, CFR Section 483.10J, F585 Grievances. Section 42, CFR Section 483.12A34, F606, Not employ/engage staff with adverse actions. Section 42, CFR Section 483.12B15, F607, Develop/implement abuse/neglect, etc. Policies. Section 42, CFR Section 483.1, 2B5, C1 and C4, F609, Reporting of alleged violations. Section 42, CFR Section 483.12C2, 4, F610, Alleged violations investigate/prevent/correct. Section 42, CFR Section 483.2, 5K, F697 Pain management determine if there is evidence and/or potential outcomes such as unrelieved pain. For example, evidence that on a particular shift or when a particular staff member is working, a resident's pain symptoms are not relieved to the extent possible, but the pain symptoms are relieved on other shifts, based upon validated evidence. Section 42, CFR Section 483.45, Section 483.4, 5AB, F755 Pharmacy, SBCS/procedures/pharmacist/records. And 42 CFR Section 483.45GH, F761 label/store drugs and biologicals determine whether pharmacy policies at a minimum address safeguarding and access, monitoring, administration, documentation, reconciliation and destruction of controlled substances. Determine whether the pharmacist has established a system of records of receipt and disposition of all controlled drugs in sufficient detail to enable accurate reconciliation, and that the drug records are in order and that an account of all controlled drugs is maintained and periodically reconciled. Section 42, CFR Section 483.75, G2 Roman 2F, 867, QAA Activities. Section 42, CFR Section 483.95C, F942 Abuse, Neglect, and Exploitation Training. Section 42, CFR Section 483.9, 5G, F946 Required in-service training for nurse aide. Deficiency Categorization Section 483.12. In addition to actual or potential physical harm, always consider whether psychosocial harm has occurred when determining severity level. See Psychosocial Outcome Severity Guide. Examples of severity level: 4. Noncompliance, immediate jeopardy to resident health or safety include, but are not limited to, the facility failed to assure that a resident's personal property was safeguarded and that staff did not misappropriate resident's property. A resident who had a medical condition in which she had loss of hair owned 2 wigs which were personalized for her needs, which she used consistently during the daytime hours. Staff documented that the resident was crying loudly, shouting, and was hysterical, and when investigated, she stated someone had stolen her wigs over the weekend. She stated she told staff and they discounted her complaints. The resident refused to leave her room or see anyone, was extremely agitated, and wanted the police called. During the facility investigation, 2 employees who had worked the evening shift over the weekend were heard by other staff members talking and laughing about how they had taken the residents' wigs. Examples of severity level: 3 noncompliance, actual harm that is not immediate jeopardy include, but are not limited to. The facility had failed to protect residents from misappropriation of resident property, had failed to immediately report and investigate alleged violations, and had failed to implement policies and procedures for reporting the possible crime to law enforcement. A resident reported to staff that she was missing a gold necklace. She had last seen the necklace in a nightstand drawer next to her bed. The resident was tearful since she had received the necklace from her children who had purchased it for her 80th birthday. The resident was worried that she had carelessly lost the necklace and did not want her children to be angry at her. The resident discontinued attending activities since she did not want to leave her room so that she could protect her belongings. During the facility's investigation, during an interview, CNA-1 stated that she had noticed that CNA-2 had a new necklace that looked familiar. CNA-1 said that CNA-2 quickly evaded questions as to how she had acquired the necklace until she said that a new boyfriend had given it to her. CNA-1 stated that she did not want to cause any trouble and did not report anything about the necklace until a week later, when it was brought to the director of nursing's attention that a resident's necklace was missing. Also, during the investigation, the facility received more reports from staff of stolen jewelry from 5 other residents, but no staff reported any of the incidents to law enforcement or the state survey agency. Examples of severity level 2, noncompliance, no actual harm with potential for more than minimal harm that is not immediate jeopardy include, but are not limited to. The facility had failed to protect a resident from misappropriation of resident property. When a radio was stolen from a resident's room, the resident, who was cognitively impaired, also had severe confusion and was unable to communicate. The resident had an activity program for listening to classical music in his room. On Monday afternoon, it was reported that the activity staff came into the resident's room to provide the activity, but were unable to locate the radio and subsequently reported the loss to the administrator. Staff stated the radio had been in the room when they had left on Friday. After the afternoon activity, the administrator contacted the resident's son and confirmed that the family had not removed the radio during a visit over the weekend and had no knowledge of where it might be. The facility replaced the radio. The administrator reported the incident to the SA. Although the resident could not articulate what had occurred with the radio, the family wished to have the music therapy continue, as the resident had a lifelong interest in classical music, and they felt, even though the resident could no longer communicate and was confused, that the music provided a sense of comfort. The facility completed the investigation and identified that a temporary staff member had stolen the radio. The temporary staff member was not allowed to work in the facility again. Severity level 1. No actual harm with potential for minimal harm. The failure of the facility to prevent misappropriation of resident property and exploitation is more than minimal harm. Therefore, severity level 1 does not apply for this regulatory requirement. Tag F600 3. Section 483.12A1. The resident has the right to be free from abuse, neglect, misappropriation of resident property and exploitation as defined in this subpart. This includes but is not limited to freedom from corporal punishment, involuntary seclusion, and any physical or chemical restraint not required to treat the resident's medical symptoms. Not use verbal, mental, sexual, or physical abuse, corporal punishment, or involuntary seclusion. Intent Section 483.12A1. Each resident has the right to be free from involuntary seclusion. Definitions, Section 483.12A1. Involuntary seclusion is defined as separation of a resident from other residents or from her/his room or confinement to her/his room with or without roommates against the resident's will or the will of the resident representative. Guidance section 483.12A1. Note: during a situation in which a resident's behavior has escalated and immediate interventions are required for the safety of the resident, staff and/or other residents, the facility must immediately consult with the resident's physician about the behavioral symptoms and the resident's designated representative, and provide necessary supervision of the resident to ensure that the resident and other residents are protected. Involuntary seclusion may take many forms, including but not limited to the confinement, restriction, or isolation of a resident. Involuntary seclusion may be a result of staff convenience, a display of power from the caregiver over the resident, or may be used to discipline a resident for wandering, yelling, repeatedly requesting care or services, using the call light, disrupting a program or activity, or refusing to allow care or services such as showering or bathing to occur. Involuntary seclusion includes, but is not limited to, the following. A resident displays disruptive behaviors, such as yelling, screaming, distracting others, such as standing and obstructing others, viewing abilities for the TV or programs, and staff remove and seclude the resident in a separate location, such as in an office area or his or her room, leaving and closing the door and without providing interventions to address the behavioral symptoms. In an attempt to isolate a resident in order to prevent him/her from leaving an area, the residentess is involuntarily confined to an area by staff placing furniture, carts, chairs in front of doorways or areas of egress. Staff hold a door shut from the opposite side of the door in order to prevent egress. Staff place a resident in a darkened room, office, or area secluded from other staff and residents for convenience or as punishment. A resident is physically placed in an area without access to call lights and/or other methods of communication, creating an environment of seclusion and isolation for the resident, and a resident placed in a secured area of the facility but does not meet the criteria for the unit and is not provided with access codes or other information for independent egress. Considerations involving secured/locked areas. If a resident resides in a secured/locked area that restricts a resident's movement throughout the facility must ensure that the resident is free from involuntary seclusion. A resident in a secured/locked area would not be considered to be involuntarily secluded if all of the following are met. The facility has identified the clinical criteria for placing a resident in the secured/locked area. Placement in a secured/locked area is not 1. Used for staff convenience or discipline. 2. Based on the resident's diagnosis alone, since the determination for placement in the area must be made on an individualized basis, and/or 3. Based on a request from the resident's representative or family member without clinical justification. For example, if the POA requests placement in the secured/locked area, but the resident declines placement and placement does not meet the clinical criteria and is not in the best interest of the resident, then placement of the resident in the secured/locked area would be involuntary seclusion. The facility involves the resident/representative in care planning, including the decision for placement in a secured/locked area and the development of interventions based upon the resident's comprehensive assessment and needs, and the facility provides immediate access and visitation by family, resident representative, or other individuals, subject to reasonable clinical and safety restrictions and the resident's right to deny or withdraw consent. It is expected that each resident's record would include documentation of the clinical criteria met for placement in the secured/locked area by the resident's physician, along with information provided by members of the interdisciplinary team. Documentation that reflects the resident/representative's involvement in the decision for placement in the secured/locked area. Documentation that reflects whether placement in the secured/locked area is the least restrictive approach that is reasonable to protect the resident and assure his or her health and safety. Documentation by the interdisciplinary team of the impact and/or reaction of the resident, if any, regarding placement on the unit, and ongoing documentation of the review and revision of the resident's care plan as necessary, including whether he/she continues to meet the criteria for remaining in the secured/locked area, and if the interventions continue to meet the needs of the resident. Note, a resident who chooses to live in the secured/locked unit, e.g., the spouse of a resident who resides in the area and does not meet the criteria for placement, must have access to the method of opening doors independently, the chosen method for opening doors, e.g., distribution of access code information is not specified by CMS. Staff should be aware of which residents have access to opening doors and monitor their use of the access to ensure other resident safety. Note, see also tags at resident rights for guidance related to justice-involved individuals. Transmission-based precautions. When used appropriately, transmission-based precautions, i.e., isolation due to infection, is not to be considered involuntary seclusion. The facility's policies must identify the type and duration of the transmission-based precautions required, depending upon the infectious agent or organism involved, and the precautions should be the least restrictive possible for the resident based on his or her clinical situation. Furthermore, the resident's record must contain the rationale for the selected transmission-based precautions. However, once the resident is no longer a risk for transmitting the infection, the removal of transmission-based precautions is required in order to avoid unnecessary involuntary seclusion. See also 42 CFR Section 483.65. Infection Control Tag F880. Investigative Protocol for Involuntary Seclusion Use. Section 483.12A1. Use this protocol for investigating an alleged violation of involuntary seclusion during a standard survey and abbreviated surveys, complaint investigations, on-site investigations of self-reported incidents, and/or revisits, and an allegation of involuntary seclusion involving a resident who resides in a secured/locked area or who was on temporary transmission-based precautions. If a surveyor determines that an act of involuntary seclusion has occurred or is occurring, she must immediately report this to the administrator or his or her designated representative. If the administrator is not present, the survey team should determine whether the facility then takes appropriate action in accordance with the requirements at F607, F609, and F610, including implementing safeguards to prevent further potential involuntary seclusion. Review of facility policies and procedures. Obtain and review the facility's policies and procedures related to the allegation. Under investigation. Observations. Observe the physical environment in which the alleged involuntary seclusion may have occurred. This may include observations of the following, which include, but are not limited to: room configuration, location of the alleged involuntary seclusion in relation to supervised areas, and Objects that may have been used to obstruct residents. Observe whether staff members make remarks and behave in a manner that may indicate concerns with staff treatment of residents. Interview. Alleged victim/resident representative and witness interviews. Interview the alleged victim/resident representative to determine as much information regarding the alleged involuntary seclusion that he/she may be able to provide. Interview the alleged victim privately. However, the alleged victim may request that another person be present. If so, be aware that the alleged victim may not be comfortable speaking openly in the presence of another person, and another interview may be necessary to follow up on any discrepancies identified. A resident with a cognitive impairment and/or mental illness may mistakenly be assumed to be an incompetent witness. In those situations, interview the alleged victim to the extent possible and corroborate statements with other observations, interviews, and record review. During the interview, observe the resident's emotions and tone, as well as any nonverbal expressions or gesturing to a particular body area in response to the questions. Interview witnesses, including but not limited to the assigned staff in the immediate area, staff from the shifts prior to or after the alleged involuntary seclusion, the victim's roommate if any other residents and/or visitors. Make every attempt to maintain the confidentiality of witnesses. It may not be appropriate to interview the person who reported the allegation first, as that may unintentionally identify the person. The surveyor may ask the witness to recreate or reenact the alleged incident to better understand the sequence of events. Interview the alleged victim/resident representative and witnesses to determine what happened when, where, and how often. Whether he/she can identify the alleged perpetrator and any witnesses. What occurred prior to, during, and immediately following the alleged involuntary seclusion. Whether he/she reported the allegation to anyone within the facility or to an outside agency, e.g., other staff, ombudsman. If so, to whom, when, and what was the response? For the alleged victim. Whether he/she feels safe, is afraid of anyone, or is fearful of retaliation. And whether the alleged victim has had past encounters with the alleged perpetrator. Staff interview. Review staff schedules to determine who was working at the time of the alleged involuntary seclusion. Interview staff from any department who has direct contact with the residentess, as appropriate, to collect information about whether he/she had knowledge of the alleged involuntary seclusion and what actions, if any, he/she took in response to the allegation. Any changes in the alleged victim's behavior as a result of the alleged involuntary seclusion. How the alleged perpetrator and alleged victim related to one another prior to and after the incident. Whether the alleged perpetrator had exhibited inappropriate behaviors to the alleged victim or other residents in the past, such as using derogatory language, rough handling, or ignored residents while giving care. Whether he/she reported the alleged involuntary seclusion to management/administrative staff or any state or local agencies, such as Adult Protective Services or local law enforcement, and if so, to whom was the alleged involuntary seclusion reported and when? If not reported, what prevented him/her from reporting? If he/she reported the allegation, whether he/she feels that retaliation has occurred as a result of reporting the allegation, and if so, what actions were taken against staff, and whether he/she has received training related to involuntary seclusion from the facility. Note, if the staff member was a witness, refer also to the questions above under witness. Interview. Alleged perpetrator interview. The alleged perpetrator may or may not be in the facility or may refuse to be interviewed. If the alleged perpetrator is a staff member, the staff member may have been suspended or assigned until the investigation is completed, and in some situations, the facility may have terminated the employment of the individual. If possible, interview the alleged perpetrator, either in person or by phone, to determine what position he/she holds and how long the alleged perpetrator has worked in the facility. What type of orientation, training, work assignments, and supervision he/she receives. Whether he/she was present in the facility at the time of the alleged involuntary seclusion. What information he/she can provide regarding the alleged involuntary seclusion, such as what happened, why was the resident separated/secluded, how often does it occur? What is his or her relationship to the alleged victim, and if he/she has any other information that he/she wishes to share in regard to the investigation. Other healthcare professionals interview the director of nursing, social worker, and physician/practitioner, as necessary, to determine whether he/she was notified by staff of the alleged involuntary seclusion, and if so, the response. Whether he/she conducted an assessment of the resident for potential injuries and/or changes in mental status, and if identified, what interventions or treatment, e.g. counseling, were provided and when, and if a resident is under transmission-based precautions, the reason why the resident is under transmission-based precautions, and when transmission-based precautions are to be removed. Record review resident. It may be necessary to obtain copies of any relevant information in the resident's record. Review the alleged victim's record to obtain necessary information, as applicable, such as the diagnosis and physician orders including medications. The to include the resident's cognitive status, functional status independent, ambulation, transfer status, uses a wheelchair, using an assistance device or requires staff assistance for adults. Care plan and interventions/goals. Physicians, nurses, social workers, and other staff members' progress notes, as applicable. Social and psychological history, and hospital transfer/discharge information, if applicable. Note, the surveyor may follow up with an interview with the treating practitioner at the hospital. Review interdisciplinary notes within the time frame of the alleged involuntary seclusion for documentation that supports, clarifies, or verifies the allegation. Determine if the record reflects the date/time of the allegation and or the date/time when the allegation was first discovered and reported, and any change in the alleged victim's mood and demeanor before and after the alleged incident, such as but not limited to distrust, fear, e.g., fear of being left alone, angry, outbursts, tearfulness, agitation, trembling, cowering, panic attacks, withdrawal from social interaction, changes in sleeping patterns, or symptoms similar to PTSD symptoms. Record review alleged perpetrator's personnel file review, if staff is identified as the alleged perpetrator, review the staff member's personnel file for information related to the allegation being investigated or history of other allegations. Adverse personnel actions taken. Screening that occurred prior to and during employment, and training and orientation related to abuse and neglect prevention. Additional activities for investigating possible involuntary seclusion for residents in secured/locked areas. If a resident lives in an area that restricts free movement throughout the facility, the survey team must determine the following. Whether the facility has developed and implemented policies and procedures related to secured/locked areas, including criteria for placement and ongoing assessment to assure that the resident meets the criteria. Whether the facility attempted alternatives prior to placement in a secured/locked area. If so, what alternatives, and what the resident's response was to the alternative. Interventions. Why the resident is placed in the secured/locked area. Whether the resident/resident representative was involved in the placement decision. Whether the resident/resident representative agreed with the decision or not. If not, how did the facility address this? And whether the secured/locked area is accessible to other residents in the facility and visitors, and if so, how. Facility investigator interview. If the facility has investigated the alleged involuntary seclusion, identify the staff member responsible for the initial reporting and the overall investigation of the alleged involuntary seclusion. This may be the administrator in some facilities. Obtain a copy of the investigation report, if any. Note, refer to F609 for further investigation if the facility does not have a copy of the investigation report available. Interview the facility investigator to determine when she was notified of the allegation and by whom. When and what actions were taken to protect the alleged victimess while the investigation was in process. Steps taken to investigate the allegation and a timeline of events that occurred. What happened as a result of the investigation. When and who received the results of the investigation, and whether there is any related information regarding the allegation that may not be included in the investigation report. Administrator interview. The administrator is responsible for the overall implementation of the facility. Policies/procedures, including to prohibit involuntary seclusion. This includes the obligation to report, investigate, protect the alleged victim, and take corrective actions as necessary. Based upon the outcome of the investigation, note that some of this information may have already been obtained from the facility investigator. Interview the administrator to determine when she was notified of the alleged involuntary seclusion and when the initial report was made to the required agencies. Who is responsible for the investigation, whether it has been completed and the outcome, or whether the investigation is ongoing. When the results of the investigation were reported to the administrator and to the required agencies. How the alleged victim and other residents at risk were protected during the investigation. If the alleged violation is verified, what corrective actions are being taken. Whether any changes were necessary to the facility's policies and procedures. Whether the alleged perpetrator had previous warnings or incidents at the facility, and what information has been provided to staff and residents related to involuntary seclusion, including reporting requirements. Interview with person responsible for quality assurance. Interview the person responsible for quality assurance activities. Determine how the committee is providing monitoring and oversight of potential or actual reported allegations of involuntary seclusion. Evaluate whether the committee has made recommendations such as policy revision and or training to prohibit involuntary seclusion. Key elements of noncompliance section 483.12A1. To cite deficient practice at F603, the surveyor's investigation will generally show that the facility separated or secluded a resident against the resident's will or the resident representatives will without clinical justification. Potential tags for additional investigation. During the investigation, the surveyor may have determined that concerns may also be present with related outcome process, and / or structure requirements. The surveyor is cautioned to investigate these related requirements before determining whether non-compliance may be present. Some examples of related requirements that should be considered include the following. Section 42, CFR Section 483.10, Section 483.10A12, Section 483.10B12, F650 resident rights and dignity. Section 42, CFR Section 483.10C1, 4, 5, F652 right to be informed / make treatment decisions. Section 42, CFR Section 483.10C23, F653 right to participate planning care. Section 42, CFR Section 483.10G14, F680 notify of changes, injury / decline / room, etc. Section 42, CFR Section 483.10J, F685 grievances. Section 42, CFR Section 483.12A34, F606 not employ / engage staff with adverse actions. Section 42, CFR Section 483.12B15, F607 develop / implement abuse / neglect, etc. policies. Section 42, CFR Section 483.12B5, C1 4, F609 reporting of alleged violations. Section 42, CFR Section 483.12C2, 4, F610 alleged violations investigate / prevent / correct. Section 42, CFR Section 483.20B12I2 Roman 3, F630 6 comprehensive assessments and timing. Section 42, CFR Section 483.20B2 Roman 2, F637 comprehensive assess after significant change. Section 42, CFR Section 483.21B1, F656 develop / implement comprehensive care plan. Section 42, CFR Section 483.21B2, F657 care plan development and revision. Section 42, CFR Section 483.24, F675 quality of life. Section 42, CFR Section 483.95C, F942 abuse, neglect, and exploitation training. Section 42, CFR Section 483.95G, F940 6 required in-service training for nurse aide. Life Safety Code requirements. If there are concerns with Life Safety Code requirements, the survey team should notify its SA supervisor that a life safety code concern has been identified and may require a life safety code survey. Deficiency Categorization Section 483.12A1. In addition to actual or potential physical harm, always consider whether psychosocial harm has occurred when determining severity level. See Psychosocial Outcome Severity Guide. Examples of severity level. 4. Noncompliance, immediate jeopardy to resident health or safety include, but is not limited to, the facility failed to assure that a resident was free from involuntary seclusion, the resident with a history of suicidal ideation and displaying behavioral symptoms which included episodic periods of yelling and screaming, especially towards the end of the day and during the night. According to the resident's record, after dinner last evening, the resident was placed by staff in her recliner with a tray attached by the nurse's station. It was documented and corroborated by staff interviews that they heard the resident yell and scream loudly, pounding on her tray. Several residents began complaining about the noise. A nurse aide transferred the resident to a wheelchair and placed the resident, who was at risk for suicidal ideation, in a housekeeping supply room, which was used for storage of chemicals. The nurse aide closed the door and went back to the floor. The resident began crying loudly, banging on the doors and yelling for help. Another staff person thought that she heard a resident yelling, but was busy completing tasks for another resident. Afterwards, she heard the yelling continue, found the resident, and removed the resident from the room. The resident was sweating profusely. Her face was reddened and was shaking and sobbing incoherently. Upon interview, the nurse aide who had secluded the resident stated that she did not have the time to deal with the yelling, and she had to get other residents to bed. She moved the resident to the supply room to quiet her down. Examples of severity level 3 noncompliance: actual harm that is not immediate jeopardy include, but is not limited to: the facility failed to assure that a resident was free from involuntary seclusion. A resident was admitted to a secured area at the request of his representative. After admission, the resident requested the security codes in order to go in and out of the area, but staff refused to provide the codes. The resident then requested to be transferred, but staff refused his request. The staff then contacted the resident's attending physician, who made the determination that was not any clinical reason for the resident to be located in the secured area. Once the physician made this determination, he notified the facility, which immediately transferred the resident to a room not located in the secured area. During interview with the resident, he stated that he was still angry that he had been placed in the secured area against his will for his first day in the facility, and felt afraid to leave his room except for meals, or else staff would place him again in the secured area, even though staff attempted to regain his trust. Examples of severity level 2, noncompliance: no actual harm with potential for more than minimal harm that is not immediate jeopardy include, but is not limited to: the facility failed to assure that a resident was free from involuntary seclusion. Based on resident and staff interviews, it was stated that a nurse aide was transporting him to an activity. The resident, who was dependent on staff for mobility in his wheelchair, said that he was annoyed that he was late to the activity. He began to insult the nurse aide. The nurse aide transported the resident in his wheelchair to an unused shower room instead of to the activity room, and the nurse aide told the resident that, when he stopped insulting her, she would take him to the activity. The nurse aide stood outside the door to supervise the resident, and when the resident became quiet, she took the resident back to the activity. Afterwards, the resident reported what had happened to the activity director and said that he did not want the aide working with him anymore. During interview, the resident stated that this was the only time something like this happened. Severity level 1, no actual harm with potential for minimal harm: the failure of the facility to prevent involuntary seclusion is more than minimal harm. Therefore, severity level 1 does not apply for this regulatory requirement. Tag F600 Section 483.1, 0E, respect and dignity. The resident has a right to be treated with respect and dignity, including Section 483.1, 0E1, the right to be free from any physical or chemical restraints imposed for purposes of discipline or convenience, and not required to treat the resident's medical symptoms, consistent with Section 483.12A2. Section 483.12. The resident has the right to be free from abuse, neglect, misappropriation of resident property, and exploitation as defined in this subpart. This includes, but is not limited to, freedom from corporal punishment, involuntary seclusion, and any physical or chemical Restraint, not required to treat the resident's medical symptoms. Section 483.1, 2A. The facility must. Section 483.1, 2A2. Ensure that the resident is free from physical or chemical restraints imposed for purposes of discipline or convenience, and that are not required to treat the residents. Medical symptoms. When the use of restraints is indicated, the facility must use the least restrictive alternative for the least amount of time and document ongoing reevaluation of the need for restraints. Intent. The intent of this requirement is for each resident to attain and maintain his or her highest practicable well-being in an environment that prohibits the use of physical restraints for discipline or convenience, prohibits the use of physical restraints to unnecessarily inhibit a resident's freedom of movement or activity, and limits physical restraint use to circumstances in which the resident has medical symptoms that may warrant the use of restraints. When a physical restraint is used, the facility must use the least restrictive restraint for the least amount of time and provide ongoing reevaluation of the need for the physical restraint. Definitions. Convenience is defined as the result of any action that has the effect of altering a resident's behavior such that the resident requires a lesser amount of effort or care and is not in the resident's best interest. Discipline is defined as any action taken by the facility for the purpose of punishing or penalizing residents. Freedom of movement means any change in place or position for the body or any part of the body that the person is physically able to control. Manual method means to hold or limit a resident's voluntary movement by using body contact as a method of physical restraint. Medical symptom is defined as an indication or characteristic of a physical or psychological condition. Position change alarms are alerting devices intended to monitor a resident's movement. The devices emit an audible signal when the resident moves in certain ways. Physical restraint is defined as any manual method, physical or mechanical, device, equipment, or material that meets all of the following criteria: is attached or adjacent to the resident's body, cannot be removed easily by the resident, and restricts the resident's freedom of movement or normal access to his or her body. 1. Removes easily means that the manual method, physical or mechanical device, equipment, or material can be removed intentionally by the resident in the same manner as it was applied by the staff. Guidance. As described under definitions, a physical restraint is any manual method, physical or mechanical device / equipment or material that limits a resident's freedom of movement and cannot be removed by the resident in the same manner as it was applied by staff. The resident's physical condition and his or her cognitive status may be contributing factors in determining whether the resident has the ability to remove it. For example, a bed rail is considered to be a restraint if the bed rail keeps a resident from voluntarily getting out of bed in a safe manner due to his or her physical or cognitive inability to lower the bed rail independently. Similarly, a lap belt is considered to be a restraint if the resident cannot intentionally release the belt buckle. Examples of facility practices that meet the definition of a physical restraint include, but are not limited to, placing a chair or bed close enough to a wall that the resident is prevented from rising out of the chair or voluntarily getting out of bed, placing a resident on a concave mattress so that the resident cannot independently get out of bed, tucking in a sheet tightly so that the resident cannot get out of bed, or fastening fabric or clothing so that a resident's freedom of movement is restricted. Placing a resident in a chair, such as a beanbag or recliner, that prevents a resident from Rising independently. Using devices in conjunction with a chair, such as trays, tables, cushions, bars, or belts that the resident cannot remove and prevents the resident from rising. Applying leg or arm restraints, hand mitts, soft ties, or vests that the resident cannot remove. Holding down a resident in response to a behavioral symptom or during the provision of care if the resident is resistive or refusing the care. Placing a resident in an enclosed framed wheeled walker in which the resident cannot open the front gate, or if the device has been altered to prevent the resident from exiting the device, and using a position change alarm to monitor resident movement, and the resident is afraid to move to avoid setting off the alarm. Physical risks and psychosocial impacts related to use of restraints. Research and standards of practice show that physical restraints have many negative side effects and risks that far outweigh any benefit from their use. Physical restraints may increase the risk of one or more of the following. Decline in physical functioning, including an increased dependence in activities of daily living, e.g., ability to walk, impaired muscle strength and balance, decline in range of motion, and risk for development of contractures. Respiratory complications. Skin breakdown around the area where the restraint was applied, or skin integrity issues related to the use of the restraint, i.e., pressure ulcers/injuries. Urinary/bowel incontinence or constipation. Injury from attempts to free him/herself from the restraint, and accidents such as falls, strangulation, or entrapment. Psychosocial impact related to the use of physical restraints may include one or more of the following. Agitation, aggression, anxiety, or development of delirium. Social withdrawal, depression, or reduced social contact due to the loss of autonomy. Feelings of shame. Loss of dignity, self-respect, and identity. Dehumanization. Panic, feeling threatened or fearful, and feelings of imprisonment or restriction of freedom of movement. Assessment, care planning, and documentation for the use of a physical restraint. The regulation limits the use of any physical restraint to circumstances in which the resident has medical symptoms that warrant the use of restraints. There must be documentation identifying the medical symptom being treated and an order for the use of the specific type of restraint. See Section 483.1 2A2. However, the practitioner's order alone, without supporting clinical documentation, is not sufficient to warrant the use of the restraint. The facility is accountable for the process to meet the minimum requirements of the regulation, including appropriate assessment. See Section 483.20. Resident assessment, care planning by the interdisciplinary team. See Section 483.21. Comprehensive person-centered care planning and documentation of the medical symptoms and use of the physical restraint for the least amount of time possible and provide ongoing reevaluation. See Section 483.1 2A2. The resident or resident representative may request the use of a physical restraint. However, the nursing home is responsible for evaluating the appropriateness of the request and must determine if the resident has a medical symptom that must be treated and must include the practitioner in the review and discussion. If there are no medical symptoms identified that require treatment, the use of the restraint is prohibited. Also, a resident or the resident representative has the right to refuse treatment. However, he/she does not have the right to demand a restraint be used when it is not necessary to treat a medical symptom. Facilities are responsible for knowing the effects devices have on its residents. If a device has a restraining effect on a resident and is not administered to treat a medical symptom, the device is acting as a physical restraint. The restraining effects to the resident may have been caused intentionally or unintentionally by staff and would indicate an action of discipline. Convenience. In the case of an unintentional physical restraint, the facility did not intend to restrain a resident, but a device is being used that has that same effect and is not being used to treat a medical symptom. These effects may result in convenience for the staff, as the resident may require less effort than previously required. The use of a restraint must be individualized and be based upon the resident's condition and medical symptoms that must be treated, while a physical restraint may be used to treat an identified medical symptom for one resident. The use of the same type of restraint may not be appropriate to treat other residents with the same medical symptom. If a resident is identified with a physical restraint, the facility must be able to provide evidence that ensures the resident's medical symptom that requires the use of a physical restraint has been identified. A practitioner's order is in place for the use of the specific physical restraint based upon the identified medical symptom. Note, if a resident is recently admitted to the facility and a restraint was used in a previous healthcare setting, the facility must still conduct an assessment to determine the existence of medical symptoms that warrant the continued use of the restraint. Interventions, including less restrictive alternatives, were attempted to treat the medical symptom but were ineffective. The resident/representative was informed of potential risks and benefits of all options under consideration, including using a restraint, not using a restraint, and alternatives to restraint use. Note, the resident or resident representative, if applicable, has the right to refuse the use of a restraint and may withdraw consent to use of the restraint at any time. If so, the refusal must be documented in the resident's record. The facility is expected to assess the resident and determine how resident's needs will be met if the resident refuses/declines treatment. The length of time the restraint is anticipated to be used to treat the medical symptom. The identification of who may apply the restraint, where and how the restraint is to be applied and used, the time and frequency the restraint should be released, and who may determine when the medical symptom has resolved in order to discontinue use of the restraint. The type of specific direct monitoring and supervision provided during the use of the restraint, including documentation of the monitoring. The identification of how the resident may request staff assistance and how needs will be met during use of the restraint, such as for repositioning, hydration, meals, using the bathroom, and hygiene. The resident's record includes ongoing reevaluation for the need for a restraint and is effective in treating the medical symptom, and the development and implementation of interventions to prevent and address any risks related to the use of the restraint. See also the long-term care facility resident assessment instrument user's manual, version 3.0, chapter 3, section P, restraints. For further guidance, and 42 CFR section 483.2, 5D F689, for concerns related to ensuring the resident receives adequate supervision to prevent accidents. Note, falls generally do not constitute self-injurious behavior or a medical symptom that warrants the use of a physical restraint, although restraints have been traditionally used as a falls prevention approach. They have major serious drawbacks and can contribute to serious injuries. There is no evidence that the use of physical restraints, including, but not limited to, bed rails and position change alarms, will prevent or reduce falls. Additionally, falls that occur while a person is physically restrained often result in more severe injuries, e.g., strangulation, entrapment. The use of handcuffs, manacles, shackles, Other chain-type restraint devices, or other restrictive devices, are not considered safe. Appropriate healthcare restraint interventions for use by a nursing home. This would not include arrests made on-site if a resident is taken into custody and is removed from the premises by law enforcement. Note: for more information regarding requirements for providing services to justice involved individuals and facilities, see also F600 50 residents' rights and S&C 16 to 21. https://www.cms.gov/medicare/provider enrollment and certification/survey certification geninfo/downloads/survey insert letter 16 to 21 PDF. Convenience and or discipline. A facility must not impose physical restraints for purposes of discipline or convenience. 483.10E1 and 483.12A2. The facility is prohibited from obtaining permission from the resident or resident representative for the use of restraints when the restraint is not necessary to treat the resident's medical symptoms. Anecdotally, it has been reported that staff will inform a resident or the resident representative that a restraint will be beneficial to the resident to prevent a fall or to safeguard the resident who may be wandering into other residents' rooms. However, in these instances, the surveyor should consider whether the restraint was used for the sake of staff convenience. Reasons for using restraints for staff convenience or discipline may include: staff state that a resident was placed in a restraint because staff are too busy to monitor the resident, and their workload includes too many residents to provide monitoring. Staff believe that the resident does not exercise good judgment, including that he/she forgets about his or her physical limitations in standing, walking, or using the bathroom alone and will not wait for staff assistance. Staff state that family have requested that the resident be restrained, as they are concerned about the resident falling, especially during high activity times, such as during meals, when the staff are busy with other residents. Staff have identified to management that there is not enough staff on a particular shift or during the weekend, and staffing levels were not changed. Staff state that new staff and or temporary staff do not know the resident, how to approach and or how to address behavioral symptoms or care needs, so they apply physical restraints. Lack of staff education regarding the alternatives to the use of restraints as a method for preventing falls and accidents. Staff have negative feelings or a lack of respect towards the resident and restrain the resident to teach him/her a lesson. In response to a resident's wandering behavior, staff become frustrated and restrain a resident to a wheelchair, and when a resident is confused and becomes combative when care is provided and staff hold the resident's arms and legs down to complete the care note. This example differs from an emergency situation where staff briefly hold a resident for the sole purpose of providing necessary, immediate medical care ordered by a practitioner. Situations where a facility uses a physical restraint or device acting as a physical restraint that is not for treating a medical symptom, whether intentionally or unintentionally by staff, would indicate an action of discipline or convenience. An example that illustrates unintentional use of a physical restraint for staff convenience is when a staff member places a resident with limited mobility in a beanbag chair while other residents receive assistance during high activity times. Determination of use of restraints for a period of imminent danger to the safety and well-being of the resident. Some facilities have identified that a situation occurred in which the residentess is in imminent danger, and there was fear for the safety and well-being of the residentess due to violent behavior, such as physically attacking others. In these situations, the order from the practitioner and supporting documentation for the use of a restraint must be obtained either during the application of the restraint or immediately after the restraint has been applied. The failure to immediately obtain an order is viewed as the application of restraint without an order. And supporting documentation. Facilities may have a policy specifying who can initiate the application of restraint prior to obtaining an order from the practitioner. If application of a restraint occurs, the facility must determine that a physical restraint is a measure of last resort to protect the safety of the resident or others. Provide ongoing direct monitoring and assessment of the resident's condition during use of the restraint. Provide assessment by the staff and practitioner to address other interventions that may address the symptoms or cause of the situation, e.g., identification of an infection process or delirium, presence of pain. Ensure that the resident and other residents are protected until the resident's behavioral symptoms have subsided or until the resident is transferred to another setting. Discontinue the use of the restraint as soon as the imminent danger ends. And immediately notify the resident representative of the symptoms and temporary intervention implemented. Documentation must reflect what the resident was doing and what happened that presented the imminent danger, interventions that were attempted, response to those interventions, whether the resident was transferred to another setting for evaluation, whether the use of a physical restraint was ordered by the practitioner, and the medical symptoms and causes that were identified. Determination of use of bed rails as a restraint. Facilities must use a person-centered approach when determining the use of bed rails, which would include conducting a comprehensive assessment and identifying the medical symptom being treated by using bed rails. Bed rails may have the effect of restraining one individual, but not another, depending on the individual resident's conditions and circumstances. See Section 483.25N, Bed Rails. Residents who are cognitively impaired are at a higher risk of entrapment and injury or death caused by restraints. Residents in a bed with bed rails have attempted to exit through, between, under, over, or around bed rails, or have attempted to crawl over the footboard, which places them at risk of serious injury or death. Serious injury from a fall is more likely from a bed with raised bed rails than from a bed where bed rails are not used. In many cases, the risk of using the bed rails may be greater than the risk of not using them, as the risk of restraint-related injury and death is significant. For example, a resident who has no voluntary movement may still exhibit involuntary movements. Involuntary movements, resident weight and gravities effects may lead to the resident's body shifting toward the edge of the bed, increasing the risk for entrapment when bed rails are used. Also refer to 42 CFR Section 483.25N, Bed Rails Tag. F600. The use of partial bed rails may assist an independent resident to enter and exit the bed independently and would not be considered a physical restraint. To determine if a bed rail is being used as a restraint, the resident must be able to easily and voluntarily get in and out of bed when the equipment is in use. If the resident cannot easily and voluntarily release the bed rails, the use of the bed rails may be considered a restraint. Determination of the use of position change alarms as restraints. Position change alarms are any physical or electronic device that monitors resident movement and alerts the staff when movement is detected. Types of position change alarms include chair and bed sensor pads, bedside alarmed mats, alarms clipped to a residence, clothing, seatbelt alarms, and infrared beam motion detectors. Position change alarms do not include alarms intended to monitor for unsafe wandering, such as door or elevator alarms, while position change alarms may be implemented to monitor a resident's movements. 4. Some residents, the use of position change alarms that are audible to the residentess may have the unintended consequence of inhibiting freedom of movement. For example, a resident may be afraid to move to avoid setting off the alarm and creating noise that is a nuisance to the residentess and staff or is embarrassing to the resident. For this resident, a position change alarm may have the potential effect of a physical restraint. Examples of negative potential or actual outcomes which may result from the use of position change alarms as a physical restraint include loss of dignity, decreased mobility, bowel and bladder incontinence, sleep disturbances due to the sound of the alarm or because the resident is afraid to move in bed, thereby setting off the alarm, and confusion, fear, agitation, anxiety, or irritation in response to the sound of the alarm as residents may mistake the alarm as a warning or as something they need to get away from. Procedures Section 483.12 and A2 Physical Restraints. The process to review concerns are outlined in the Physical Restraints Critical Element. Pathway Form CMS 20077. Note: a resident may have a device in place that the facility has stated can be removed by the resident. For safety reasons, do not request that the resident remove the restraint, but rather request that staff ask the resident to demonstrate how he/she releases the device without staff providing specific instructions for the removal. Use observations, interviews, and record review to gather and corroborate information related to the use of the physical restraint, including whether the facility identified a device as a restraint, why it is used, how long it has been used, duration of use, alternatives attempted, what information was provided to the resident regarding the use of the restraint, and whether the use of the restraint reflects the resident's preferences and choices, whether the physical restraint is used for or has the effect of staff convenience or discipline or physical and psychosocial outcomes from the use of the restraint. Use the physical restraint's critical element C pathway, along with the above guidance. When a resident's clinical record reflects the use of a physical restraint, if the survey team observes a position change alarm or other device or practice that restricts or potentially restricts a resident's freedom of movement, physically or psychologically, if the resident or other individuals report that a restraint is being used on the resident, or if an allegation of inappropriate use of a physical restraint is received. Key elements of noncompliance. To cite deficient practice at F604, the surveyor's investigation will generally show that the facility has failed, in one or more areas, to do any one or more of the following. Ensure that the resident is free from physical restraints imposed for discipline or staff. Convenience. Identify the medical symptom being treated when using a device or a facility practice that meets the definition of physical restraint. Define and implement interventions according to standards of practice during the use of a physical restraint that is used for treatment of a medical symptom. Provide the least restrictive restraint for the least time possible. Providing ongoing monitoring and evaluation for the continued use of a physical restraint. To treat a medical symptom, or develop and implement interventions for reducing or eventually discontinuing the use of the restraint when no longer required to treat a resident's medical symptoms. Potential tags for additional investigation. During the investigation, the surveyor may have determined that concerns may also be present with related outcome, process, and/or structure requirements. The surveyor is cautioned to investigate these related requirements before determining whether non-compliance may be present. Some examples of related requirements that should be considered include the following. Section 42, CFR Section 483.10, Section 483.10A12, Section 483.10B12, F650 resident rights and dignity. Section 42, CFR Section 483.10C23, F653, right to participate planning care. Section 42, CFR Section 483.21B1, F656 develop/implement comprehensive care plan. Section 42, CFR Section 483.24, F675 quality of life. Section 42, CFR Section 483.25D, F689 accidents. Section 42, CFR Section 483.25N14, F700 special care, betrayals. Section 42, CFR Section 483.35, 483.35A, and Section 483.3, 5 CF 725 and F 726, sufficient and competent. Staff. Section 42, CFR Section 483.40BB1, F 742 treatment/SVC for mental/psychosocial concerns. Section 42, CFR Section 483.70G, F841 responsibilities of medical director. Section 42, CFR Section 483.75, G2 Roman 2F, 867, QAA activities. Deficiency categorization. In addition to actual or potential physical harm, always consider whether psychosocial harm has occurred when determining severity level. See Psychosocial Outcome Severity Guide. Examples of severity level. 4. Noncompliance, immediate jeopardy to resident. Health or safety include, but are not limited to, the facility failed to identify the resident's medical symptom that warranted the use of a restraint. It was identified that a resident had repeated falls in his room, usually after meals, when he attempted to transfer from his wheelchair to the bed. The clinical record documented that the resident repeatedly requested to be assisted to lie down after eating. Staff recorded that the belt restraint was being applied to prevent falls, as he had fallen several times when attempting to stand up from the wheelchair after meals and lie down. Although the resident verbalized distress at being tied down in the wheelchair, staff stated they had informed the resident that they would put the resident in bed as soon as they finished taking care of the other residents in the dining room. It was documented that after staff left the room, the resident had attempted to stand up with the lap belt in place in the wheelchair, and as a result, the wheelchair tipped over and he sustained a fracture of his hand and had hit his head, resulting in hospitalization and treatment for multiple head and face lacerations and a subdural hematoma. The facility failed to identify bed rails as a physical restraint, failed to assess the resident for use of a bed rail, and failed to ensure that the bed rails did not pose a risk of injury from falls. A moderately cognitively impaired resident was admitted to the facility who required extensive assistance with bed mobility and transfer, and was not ambulatory. The staff recorded on admission that the resident was at high risk for falls, and as a result, placed full bed rails on all open sides of the bed. No assessment was conducted related to the use of bed rails or the use of restraints. Documentation in the record revealed that the resident crawled to the foot of her bed while the full bed rails were in a raised position, attempted to stand and walk, and fell off the right side of the bed. The Resident was hospitalized for surgical repair of a femoral neck fracture. Examples of severity level 3 noncompliance actual harm that is not immediate. Jeopardy include, but are not limited to. The facility failed to assure that a restraint was an intervention to treat a medical symptom and was not being used for staff convenience. Facility staff had placed a resident in a bean-bag chair from which he could not rise. Based on staff interview, the resident was ambulatory but had fallen in the past when attempting to stand up. The facility staff did not recognize that the beanbag was a physical restraint. Thus, the staff did not conduct any assessment to identify any medical symptoms that would necessitate a restraint. Staff stated that they placed the resident in the bean-bag chair while caring for other residents. The resident reported being placed and left in the bean-bag chair every day in the afternoon and was not able to stand to walk to his room or to activities. The resident said that he felt humiliated that he is not able to get out of the chair himself when he wants to, especially since he enjoys talking with the other residents. The surveyor observed the resident struggling to get up, but was not able. The facility failed to assure that the use of a physical restraint was used to treat a resident's medical symptoms and was not being used for staff convenience. A resident was admitted with a diagnosis of dementia and had been hospitalized due to a head injury related to a fall at her home. The physician admission orders included an order for a lap belt to be used when the resident was up in the wheelchair. However, there was no identification of the medical symptom that necessitated the use of the lap belt. In a phone interview with the physician, he indicated that staff had requested the lap belt order due to the resident's falls. Based on observation, the resident sat in the day room in a wheelchair with the lap belt in place through the morning, from the breakfast service through the end of the noon meal. Staff did not provide repositioning assistance with using the bathroom or release of the lap belt for mobility. After lunch, the resident was transported to her room in the wheelchair with the lap belt in place. However, the lap belt was not removed, and the resident remained in the same position through the afternoon without opportunities for repositioning, assistance with using the bathroom, or release of the lap belt for mobility. The resident was observed to be moving about restlessly, pulling at the lap belt and calling out for help without staff response or intervention. When staff prompted the resident to release the belt, the resident was not able. Observation of the resident's skin when put to bed after the PM shift arrived revealed reddened areas on the coccyx, urine-soaked incontinence product with visible skin maceration. Staff interviewed stated that the lap belt was being used as a falls prevention intervention. They stated, and the record corroborated, that there had been a decline in the resident's mobility and continence since admission. Examples of severity level 2, noncompliance, no actual harm with potential for more than minimal harm that is not immediate jeopardy include, but are not limited to. The facility failed to assure that a physical restraint used for one resident was for the treatment of medical symptoms. Record review and observation revealed that the resident was alert and responded to her name, but was identified as mildly cognitively impaired and had fallen at home prior to her admission several weeks before. Observations revealed that a seat belt was used intermittently when the resident was in the wheelchair, but the resident had not attempted to rise, nor had attempted to remove the seat belt. Staff stated that they thought the resident could release the seat belt, although an assessment had not been completed regarding the use of the seat belt. There was no documentation of an assessment for the use of the seat belt, whether the resident could release the seat belt, or of identification of medical symptoms that would require the use of the seat belt while in the wheelchair. The resident's record reflected no decline in functional status. The facility failed to ensure that the use of a concave mattress was being used in the treatment of medical symptoms and not for staff convenience. A resident who could independently transfer self from bed to wheelchair and to bathroom was observed to have a concave mattress. During resident interview, the resident stated that it was hard to get out of bed. The resident's record indicated no history of falls or injuries. During interview, the nurse assigned to the resident verified that the concave mattress was used to prevent the resident from exiting the bed independently. The resident's record did not include any information in the assessment, physician's orders, or care plan related to the concave mattress. Severity Level 1. No actual harm with potential for minimal harm. The failure of the facility to assure residents are free from physical restraints, not required to treat the resident's symptoms is more than minimal harm. Therefore, Severity Level 1 does not apply. For this regulatory requirement, 1C CMS Minimum Data Set Resident Assessment Instrument Manual. Tag F600 Section 483.1 0E Respect and Dignity. The resident has a right to be treated with respect and dignity, including Section 483.1 0E1 the right to be free from any physical or chemical restraints imposed for purposes of discipline or convenience and not required to treat the resident's medical symptoms, consistent with Section 483.12A2. Section 483.12. The resident has the right to be free from abuse, neglect, misappropriation of resident property, and exploitation as defined in this subpart. This includes but is not limited to freedom from corporal punishment, involuntary seclusion, and any physical or chemical restraint not required to treat the resident's medical symptoms. Section 483.1 2A. The facility must. Section 483.1 2A2. Ensure that the resident is free from physical or chemical restraints imposed for purposes of discipline or convenience and that are not required to treat the resident's medical symptoms. When the use of restraints is indicated, the facility must use the least restrictive alternative for the least amount of time and document ongoing reevaluation of the need for restraints. Intent. The intent of this requirement is for each person to attain and maintain his or her highest practicable well-being in an environment that prohibits the use of chemical restraints for discipline or convenience and not required to treat a resident's medical symptoms. When a medication is indicated to treat a medical symptom, the facility must use the least restrictive alternative for the least amount of time, provide ongoing reevaluation of the need for the medication, and not use the medication for discipline or convenience. Note, the surveyor's review of medication use is not intended to constitute the practice of medicine. However, surveyors are expected to investigate the basis for decisions and interventions affecting residents. Definitions. Chemical restraint is defined as any drug that is used for discipline or staff convenience and not required to treat medical symptoms. Convenience is defined as the result of any action that has the effect of altering a resident's behavior such that the resident requires a lesser amount of effort or care and is not in the resident's best interest. Discipline is defined as any action taken by facility staff for the purpose of punishing or penalizing residents. Indication for use is defined as the identified, documented clinical rationale for administering a medication that is based upon an assessment of the resident's condition and therapeutic goals, and is consistent with manufacturer's recommendations and or clinical practice guidelines. Clinical standards of practice, medication references, clinical studies or evidence-based Review articles that are published in medical and or pharmacy journals. Medical symptom is defined as an indication or characteristic of a medical, physical, or psychological condition. Guidance. The indication for use for any medication ordered for a resident must be identified and documented in the resident's record. Also refer to F657 and or F658 when any medication restricts the resident's movement or cognition, or sedates or subdues the resident, and is not an accepted standard of practice for a resident's medical or psychiatric condition. The medication may be a chemical restraint, even if use of the medication follows accepted standards of practice. It may be a chemical restraint if there was a less restrictive alternative treatment that could have been given that would meet the resident's needs and preferences, or if the medical symptom justifying its use has subsided. The facility is accountable for the process to meet the minimum requirements of the regulation, including appropriate assessment, care planning by the interdisciplinary team, and documentation of the medical symptoms and use of a less restrictive alternative for the least amount of time possible, and provide ongoing reevaluation. Note, a medication may have been required to treat a medical symptom, and as a result, the medical symptom is no longer present. In some cases, the clinical goal of the continued use of the medication is to stabilize the symptoms of the disorder so that the resident can function at the highest level possible. In other words, the clinical goal is to have no symptoms of the disorder. Although the symptom may no longer be present, the disease process is still present. For example, diseases may include chronic psychiatric illness, such as schizophrenia or schizoaffective disorder, bipolar disorder, depression, or post-traumatic stress disorder, neurological illness, such as Huntington's disease or Tourette's syndrome, and psychosis and psychotic episodes. In such instances, if the medication is reduced or discontinued, the symptoms may return. Reducing or eliminating the use of the medication may be contraindicated and must be individualized. If the medication is still being used, the clinical record must reflect the rationale for the continued administration of the medication. If no rationale is documented, this may meet the criteria for a chemical restraint, such as for staff convenience. See also F658 for concerns related to unnecessary use of a psychotropic medication and lack of gradual dose reduction. Determination of medical symptoms. The clinical record must reflect whether the staff and practitioner have identified, to the extent possible, and address the underlying causes of distressed behavior, either before or while treating a medical symptom. Potential underlying causes for expressions and or indications of distress may include, but are not limited to, delirium, pain, the presence of an adverse consequence associated with the resident's current medication regimen, and environmental factors, such as staffing levels, overstimulating noise or activities under stimulating activities, lighting, hunger/thirst, alteration in the resident's customary location or daily routine, physical aggression leading to altercations, temperature of the environment, and crowding. Note, if it is determined that the administration of a medication is being used to treat a medical symptom, the survey team should review to assure that the use of the medication is supported by adequate indication and rationale for use, and is used at the correct dose and duration and with adequate monitoring. See also F641, F657, and F658 for concerns related to non-pharmacological approaches of redirecting or addressing behavior. Determination of indication for medication use. The clinical record must reflect the following: Whether there is an adequate indication for use for the medication, e.g., a psychotropic. Medication is not administered unless the medication is used to treat a specific condition. Whether an excessive dose and / or duration of the medication was administered to the resident. Whether there is adequate monitoring for the effectiveness of the medication in treating the specific condition and for any adverse consequences resulting from the medication. Whether a resident who uses a psychotropic drug is receiving gradual dose reduction and behavioral interventions unless clinically contraindicated, and whether a resident who receives a psychotropic drug pursuant to a PRN pro renata or as needed order is not administered the medication unless the medication is necessary to treat a diagnosed specific symptom as documented in the clinical record. If the practitioner orders a medication to be administered on a PRN time-limited basis for the provision of medical treatment to address an emergency medical condition, e.g., delirium, this would not be considered to be a chemical restraint. The dosage cannot exceed what is prescribed by the practitioner, and if the resident does not respond to the initial administration of the PRN medication, the practitioner must be contacted regarding reassessment of the resident's medical condition and evaluation of interventions. The administration of a PRN medication must be discontinued when the resident does not need the medication for treatment of the medical condition. Also see Section 483.4, 5 EF 758 for limitations on psychotropic and antipsychotic medication, PRN orders. If staff continue to utilize a PRN medication that subdues or sedates a resident and is not treating a medical condition, this would be considered to be a chemical restraint for staff convenience or discipline. Risks and psychosocial impacts related to use of chemical restraints. A medication that is used for discipline or convenience and is not required to treat medical symptoms may cause the resident to be subdued, sedated, or withdrawn, asleep during hours that he/she would not ordinarily be asleep, or limited in his or her functional capacity. Additional effects resulting from sedating or subduing a resident may include, but are not limited to, the following: loss of autonomy, dignity, self-respect, and orientation; confusion, cognitive decline, withdrawal, depression; decreased activity levels, including social activities; decline in skin integrity; decline in continence level; decline in physical functioning, including an increased dependence in activities of daily living, e.g., ability to walk, impaired muscle strength and balance, decline in range of motion and risk for development of contractures, increased risk of falls, and weight loss if missing meals. Facilities are responsible for knowing the effects medications have on their residents. If a medication has a sedating or subduing effect on a resident and is not administered to treat a medical symptom, the medication is acting as a chemical restraint. The sedating/subduing effects to the resident may have been caused intentionally or unintentionally by staff and would indicate an action of discipline or convenience. In the case of an unintentional chemical restraint, the facility did not intend to sedate or subdue a resident, but a medication is being administered that has that effect and is not the least restrictive alternative to treat the medical symptom. These effects may result in convenience for the staff, as the resident may require less effort than previously required, even if a medication was initially administered for a medical symptom. The continued administration of a medication in the absence of a medical symptom that sedates a resident or otherwise makes it easier to care for them is a chemical restraint. Other examples of facility practices that indicate that a medication ordered by a practitioner is being used as a chemical restraint for staff convenience or discipline include, but are not limited to. O staff indicate that a medication is being administered based on the resident's representative's request to administer a medication to calm down the resident. O staff have recommended to the practitioner that a resident be administered a medication in order to prevent a resident from displaying behaviors such as wandering into other residents' rooms. O staff administer a medication to quiet the resident because the resident continually calls out without attempting alternative interventions. O staff become frustrated with a resident who continually requests staff assistance, such as for toileting, or continually puts on the call light, and administer a medication to sedate or subdue the resident. O staff administer a medication that subdues or sedates a resident when insufficient staffing levels do not allow for the resident's needs to be met. O staff administer a medication to sedate or subdue the resident and / or to restrict the resident to a seated or lying position, since the resident continually wanders into other residents' rooms or attempts to leave the unit, and O staff become upset with a resident who resists receiving a bath and pinches staff. The staff had not reassessed the resident nor revised interventions regarding how to provide bathing care in order to meet the resident's needs. Instead, staff administer a medication that is used to subdue the resident prior to providing the bath, but the medication is not used to treat an identified medical symptom. Investigative protocol for chemical restraints use. Use this protocol to investigate whether the facility is using a medication as a chemical restraint when an allegation of use of a chemical restraint is received, or the survey team determines noncompliance with F657 and / or F658, and the resident was or is receiving an unnecessary medication that restricts movement or sedates or subdues the resident. Note, if the survey team identifies an unnecessary medication that is acting as a chemical restraint sedating or subduing a resident, the noncompliance is cited at F605, chemical restraints, and not cited at F757, unnecessary medications. Both tags shall not be cited for the same noncompliance. Procedures. The survey team must first use the interpretive guidance refer to F757 and F758 and critical element pathway for unnecessary medications, psychotropic medications, and medication regimen review form CMS 20082 to determine whether the medication is used to treat a medical symptom. Review the assessment, care plan, practitioner orders, and consulting pharmacist reviews to identify facility interventions and to guide observations to be made. Corroborate observations by interview and record review. Gather information regarding the resident's mental, physical, functional, and psychosocial status and the medication-related therapeutic goals identified in the care plan as the basis for further review. Observation. Record observations regarding any potential environmental causes of distress to the resident, such as staffing levels, overstimulating noise or activities, understimulating activities, lighting, hunger/thirst, physical aggression leading to altercations, temperature of the environment, and crowding. In addition, observe for any alteration to the residents' customary location or daily routine. Record any visible physical and psychosocial reaction to the potential use of a medication, such as drowsiness, somnolence, excessive sedation, and hallucinations. Neurologic consequences, such as akathisia, neuroleptic malignant syndrome NMS, Parkinsonism, tardive dyskinesia, and / or confusion, agitation, anxiety, nervousness. O. Social isolation, withdrawal, loss of self-esteem, and slash or O. Lack of participation in individualized activities, according to the resident's care plan. Interviews. Interview the resident and slash or resident representative to the degree possible to identify O. Prior to administration of the medication, whether other interventions have been attempted, if so, what alternatives and what. The response was whether staff provided information regarding why the medication was being used, the risks and slash or benefits of using the medication, and when and for how long the medication was going to be used. O. Who requested the medication to be used and why. O. Describe the effect of the medication on the resident's functioning, participation in individual and slash or group activities, and how it makes them feel, and O. Describe any changes in the resident's ability to understand, sleeping patterns, or social involvement since receiving the medication. Interview direct care staff and slash or licensed personnel, e.g. nursing, social worker, as appropriate, on various shifts that provide care to the resident to determine O. Why the medication is being administered and what effect physical and slash or psychosocial it has on the resident. O. Depending on whether distressed behavior is expressed, how do staff respond and what individualized, person-centered interventions are attempted. O. Prior to administration of the medication, whether other interventions have been attempted, if so, what alternatives, and how the interventions met or failed to meet the resident's needs. O. How long the medication has been administered and when it began. O. Prior to administration of the medication, what is determined to be the underlying causes of the medical symptom that is being treated. How is the causes treated? O. Who and how the facility monitors for adverse consequences related to the administration of the medication. O. How is it determined that the medical symptom is no longer present, and who determines this? O. If the medication continues to be administered and the medical symptom is no longer present, what is the clinical rationale for continuing the use of the medication, and where is this documented? O. How staff are assigned to monitor, care for, and be familiar with residents' behaviors, e.g., the number, location, and consistency of staff assigned across different shifts/units. O. Who supervises the overall delivery of care to the residents to assure care planned interventions are implemented, and how supervision occurs to assure that a chemical restraint is not used for staff convenience, and O. Whether staff have discussed concerns with the director of nurses and administrator regarding the behavioral symptoms of specific residents and the monitoring of interventions, and whether staff have requested more resources or changes to resident assignments and the response to the concerns. Interview the practitioner regarding concerns identified during the investigation, including when the staff contacted him/her, what concerns they identified regarding the residents' behavior, the response provided, including whether other interventions were attempted prior to the use of a medication, what medical symptom is being treated with the medication, whether the medication is considered to be the least restrictive in type, dose, and duration that may be used to treat the symptom, and the plan for discontinuing and slash or revising interventions. Interview the pharmacist to identify when she conducted the last medication regimen. Review for the resident if the medication was administered prior to the last review and it was not identified as a concern, whether she can provide information regarding the indication for use of the medication, if the medication was administered prior to the last review and it was identified as a concern, whether she notified the practitioner, director of nurses, and or medical director, and what was the response, and what is the facility's process for notifying the pharmacist when initiating a medication for a change in the resident's condition, such as when there are expressions or indications of distress or other changes in a resident's psychosocial status. Interview the social worker to determine any patterns of behaviors that may impact the resident's safety or care provided, whether he/she was aware of interventions attempted, how attempts met or did not meet the resident's needs, whether he/she was aware of what medications are administered to the resident, whether he/she has identified any changes in the resident's behavior or activity level after administration of the medication, and why he/she believes the medication is being administered. Interview the director of nurses to identify his or her knowledge regarding the behavioral symptoms of specific residents and the monitoring of interventions. Also, interview the director of nurses and administrator to identify whether staff have requested more resources or changes to resident assignments and the response to the concerns. Record review. Review the assessment, care plan, practitioner orders, progress notes, and consulting. Pharmacist reviews. Determine whether there was a decline in the resident's functional and/or psychosocial status related to the medication that was administered. If so, the surveyor must determine whether the decline can be attributed to disease progression or administration of an unnecessary medication. Determine if documentation in the resident's record reflects, prior to administration of the medication, whether other interventions have been attempted. If so, what alternatives, and how the interventions met or failed to meet the resident's needs. Prior to administration of the medication, whether the facility identified, to the extent possible, and address the underlying causes of the medical symptom. Indication for use for the medication S, including the medical symptom S being treated. Whether the record reflects any adverse consequences after administration of the medication. Whether the record reflects whether there was a change in functioning and/or activity after administration of the medication. If a medication used to treat medical symptoms was appropriate at one time, determine if it was discontinued once it was no longer necessary, or if a clinical rationale to continue the medication is documented, and whether the medication is administered on a PRN basis on particular days or shifts, or when certain staff is caring for the resident and the symptoms for which the medication is prescribed are not documented. Facility review. It may be necessary to interview the medical director regarding medications that are not required to treat the resident's medical symptoms result in the resident being subdued, sedated, or withdrawn or limited in his or her functional capacity. Determine whether the Quality Assessment and Assurance Committee is aware of psychotropic medication used to address resident behavioral symptoms, whether there is sufficient qualified staff trained to provide interventions for behavioral symptoms, and supervision of staff to assure that medications are only used to treat a medical symptom and do not have the effect of convenience or discipline. Key elements of noncompliance. To cite deficient practice at F605, the surveyor's investigation will generally show that the facility has failed in one or more areas to do any one or more of the following. Assure that the resident is free from restraints imposed for discipline or staff convenience. Convenience can be caused intentionally or unintentionally by staff. Identify medical symptoms that were being treated with the use of a chemical restraint. If a chemical restraint is in use, the facility O provides the least restrictive alternative for the least time possible, including and as appropriate, developing and implementing a plan for gradual dose reduction in the absence of identified and documented clinical contraindications. O monitors and evaluates the resident's response to the medication and O discontinues the use of the medication when the medical symptom is no longer being treated, unless reducing or eliminating the use of the medication may be clinically contraindicated. Potential tags for additional investigation. During the investigation, the surveyor may have determined that concerns may also be present with related outcome, process, and / or structure requirements. The surveyor is cautioned to investigate these related requirements before determining whether non-compliance may be present. Some examples of related requirements that should be considered include the following. Section 42, CFR Section 483.10, Section 483.10A12, Section 483.10B12, F650 resident rights and dignity. Section 42, CFR Section 483.10C23, F653, right to participate planning care. Section 42, CFR Section 483.21B1, F656 develop/implement comprehensive care plan. Section 42, CFR Section 483.35, Section 483.35A, and Section 483.35 CF 725 and F 726, sufficient and competent staff. Section 42, CFR Section 483.40BB1, F 742 treatment/SVC for mental/psychosocial concerns. Section 42, CFR Section 483.45C, F 756 drug regimen review, report irregular, act on. Section 42, CFR Section 483.45D, F 757 drug regimen is free from unnecessary drugs. Section 42, CFR Section 483.45, F 758 psychotropic medications. Section 42, CFR Section 483.70G, F 841 responsibilities of medical director. Section 42, CFR Section 483.75, G2 Roman 2F, 867, QAA activities. Deficiency categorization. In addition to actual or potential physical harm, always consider whether psychosocial harm has occurred when determining severity level. See Psychosocial Outcome Severity Guide. Examples of severity level. 4. Noncompliance, immediate jeopardy to resident health or safety includes, but is not limited to, the facility administered a medication to a resident for staff convenience without a medical symptom identified. The resident was admitted to a secured area of the facility 2 months prior to the survey. During observations, the resident was observed lying in a reclining chair, sleeping, and staff had difficulty arousing the resident for meals. The staff had to provide one-to-one assistance to assist the resident to eat. The resident was unable to hold the utensils and was being fed a pureed meal. The resident required a 2-person assist to transfer from bed to chair and required total assistance for activities of daily living. The resident's record revealed that on admission, the resident was independent in mobility and ambulation and did not require assistance to eat. Staff interviewed stated that they had difficulty monitoring the resident as they were taking care of other residents. They stated that there were no identified interventions or activities to address these behaviors. As a result, staff requested a medication from the physician for the wandering behavior. The physician was interviewed and stated that the medication was being administered for wandering, but that he was not aware that the resident was sedated, and the resident's decline in walking and activities of daily living. There was no other evidence in the resident's record or from interviews with staff and the physician that indicate a medical reason for the decline and sedating effect. The facility failed to assure that a medication it administered to a resident was being used to treat a medical symptom and not for staff convenience. The resident was admitted for post-surgical rehabilitation of a fractured hip. During an interview, the resident's representative stated that prior to admission, the resident had been alert, was able to recognize her family members, was used to sitting with the family after the evening meal at home, and, although pleasantly confused, enjoyed a warm bath prior to bedtime and slept through the night. However, after admission, there had been a significant change in the resident's status. The resident's record reflected that the resident, after admission, was immediately put to bed after the evening meal every day. Subsequently, the resident began yelling out for help, wanted to get out of bed, and disrupted other residents' sleep. During an interview with the practitioner, staff had contacted him and requested an antipsychotic medication to keep the resident quiet during the night hours, as she was disruptive and agitated. The practitioner ordered an antipsychotic medication twice a day, but did not provide documentation of a medical symptom being treated with the medication. Observations throughout the survey revealed the resident seated in a wheelchair, subdued or sleeping, sucking on her hand, mumbling to self, and not aware of surroundings or visitors. Staff interviewed corroborated that there had been a decline in the resident's condition since the administration of the medication, due to the significant change in the resident's status related to the initiation and use of a chemical restraint. Serious harm occurred to the resident. Examples of severity level 3 noncompliance actual harm that is not immediate jeopardy include, but is not limited to, the facility administered a medication that was not being used to treat medical symptoms, the facility did not attempt any less restrictive interventions, and the medication was used for the convenience of staff. As a result of this noncompliance, the resident was sedated into the morning hours. The resident was unable to be aroused sufficiently to eat breakfast in the dining room where he normally eats meals, and now required assistance by staff to eat breakfast. The resident was observed to attend and participate in his other meals and activities for the rest of the day. The record did not indicate any falls or any decline in other activities of daily living. The resident, diagnosed with Alzheimer's disease, had displayed nighttime behaviors that frustrated other residents and nursing staff, such as wandering into other residents' rooms and rummaging through drawers and closets. To address the resident's behavior, staff contacted the attending physician to discuss the issue and request a long-acting anti-anxiety medication. No other attempts of non-pharmacological interventions were identified or implemented prior to the use of the chemical restraint. Staff stated that they did not have the time to implement other interventions. The resident's record did not indicate a medical symptom being treated, nor a reduction of the medication when the resident's functional status declined. Examples of severity level 2, noncompliance, no actual harm with potential for more than minimal harm that is not immediate jeopardy include, but are not limited to. The facility failed to assure that an anti-anxiety medication was being administered to treat a medical symptom and not for the convenience of staff, although the resident has not experienced falls or other adverse consequences in relation to the administration of the medication. The potential exists for more than minimal harm with the continued use of the anti-anxiety medication in the absence of a medical symptom. Interviews and record review revealed that the facility was giving a resident anti-anxiety medication prior to the resident taking showers occasionally on weekends. Staff indicated that the resident had occasionally declined showers not because she was anxious, but because she found bed baths to be more relaxing than the shower environment. The staff interviewed stated that the nurse aides, who worked the daytime weekend shift, were upset about the resident refusing the shower as they did not have time to come back and shower the resident at another time, not realizing that this was not the resident's preference. The weekend nurse contacted the physician for a medication to alleviate the resident's anxiety to taking a shower. A nursing assistant who was assigned to provide the resident's care during the week stated that sometimes the resident does not want to take a shower, and on those occasions, she would give the resident a bed bath. The nursing assistant said the resident is not resistive or combative. Severity Level 1. No actual harm with potential for minimal harm. The failure of the facility to assure residents are free from chemical restraints is more than minimal harm. Therefore, Severity Level 1 does not apply for this regulatory requirement. Tag F606. Section 483.1. 2A. The facility must. Section 483.1. 2A3. Not employ or otherwise engage individuals who I have been found guilty of abuse, neglect, exploitation, misappropriation of property, or mistreatment by a court of law. Roman 2. Have had a finding entered into the State Nurse Aid Registry concerning abuse, neglect, exploitation, mistreatment of residents or misappropriation of their property, or Roman 3. Have a disciplinary action in effect against his or her professional license by a state licensure body as a result of a finding of abuse, neglect, exploitation, mistreatment of residents or misappropriation of resident property. Section 483.12A4. Report to the State Nurse Aid Registry or licensing authorities any knowledge it has of actions by a court of law against an employee, which would indicate unfitness for service as a nurse aide or other facility staff. Intent. The facility must not hire an employee or engage an individual who was found guilty of abuse, neglect, exploitation, or mistreatment or misappropriation of property by a court of law, or who has a finding in the State Nurse Aid Registry concerning abuse, neglect, exploitation, mistreatment of residents or misappropriation of resident property, or has a disciplinary action in effect taken against his or her professional license. The facility must report knowledge of actions by a court of law against an employee that indicates the employee is unfit for duty. Definitions. Found guilty by a court of law applies to situations where the defendant pleads guilty, is found guilty, or pleads no contest to charges of abuse, neglect, exploitation, misappropriation of property, or mistreatment. Finding is defined as a determination made by the state that validates allegations of abuse, neglect, exploitation, mistreatment of residents, or misappropriation of their property. Mistreatment, as defined at Section 483.5, means inappropriate treatment or exploitation of a resident. Guidance. Employment. Note, for purposes of this guidance, staff includes employees, the medical director, consultants, contractors, volunteers. Staff would also include caregivers who provide care and services to residents on behalf of the facility, students in the facility's nurse aid training program, and students from affiliated academic institutions, including therapy, social, and activity programs. Facilities must be thorough in their investigations of the histories of prospective staff. In addition to inquiry of the State Nurse Aid Registry or licensing authorities, the facility should check information from previous and/or current employers and make reasonable efforts to uncover information about any past criminal prosecutions. It has been reported that former nurse aides with a finding of abuse, neglect, misappropriation of resident property, exploitation, or mistreatment may seek employment in other departments of a facility, such as maintenance or laundry services/department, or at another nursing home in a non-nursing capacity. Some states may have additional requirements for criminal background checks, and state law may prohibit persons convicted of certain crimes from working in a long-term care facility. The state survey agency may use its own authority for assuring facility compliance, such as the use of the National Background Check Program or specific state licensure requirements that may address criminal background checks. In addition, some facilities may have more stringent hiring restrictions than what is required by state or federal law. If a facility has not developed or implemented policies and procedures related to screening procedures prior to employment, a finding of noncompliance should be considered at F607, not F606, if it is determined that the facility employed or engaged an individual, either directly or under contract, who was found guilty by a court of law of abuse, neglect, misappropriation of property, exploitation, or mistreatment, or had a finding entered into the state nurse aid registry, or has a disciplinary action in effect against his or her professional license concerning abuse, neglect, mistreatment of residents, or misappropriation of resident property. A finding of noncompliance is cited at F606. Reporting to the state nurse aid registry or licensing authorities. A nurse aide found guilty of neglect, abuse, mistreatment, misappropriation of property, or exploitation by a court of law must have his or her name entered into the state nurse aid registry. See 483.1 2A4. A licensed staff member found guilty of the above must be reported to his or her licensing board. Further, if a facility determines that actions by a court of law against an employee are such that they indicate that the individual is unsuited to work in a nursing home, then the facility must report that individual to the state nurse aid registry if a nurse aide or to the state licensing authorities if a licensed staff member. Examples of convictions that may indicate unfitness to work in a nursing home include, but are not limited to, child abuse, sexual assault, theft, and assault with a deadly weapon. Note, in addition, according to 42 CFR 483.15, 6 C1 Roman 4A2, C1 Roman 4D, Registry of Nurse Aides, the state must include the following information on any finding of abuse, neglect, or misappropriation of property by the individual. Documentation of the state's investigation, including the nature of the allegation and the evidence that led the state to conclude that the allegation was valid. The date of the hearing, if the individual chose to have one, and its outcome, and a statement by the individual disputing the allegation, if he or she chooses to make one. This information must be included in the registry within 10 working days of the finding and must remain in the registry permanently unless the finding was made in error, the individual was found not guilty in a court of law, or the state is notified of the individual's death. Refer to the CE Pathways for Abuse Form CMS 20059 and Neglect Form CMS 20130, and the investigative protocols for tags F602 and F603. Key elements of noncompliance. To cite deficient practice at F606, the surveyor's investigation will generally show that the facility did any one or more of the following: hire or engage an individual who, unless the individual in question has appealed their disqualification from employment in a nursing home, and that appeal has been successful under state or federal law, O has been found guilty of abuse, neglect, exploitation, misappropriation of property, or mistreatment by a court of law, or O has had a finding entered into the state nurse aid registry concerning abuse, neglect, Exploitation, mistreatment of residents or misappropriation of their property. Or O has had a disciplinary action in effect against his or her professional license by a state, professional licensure body as a result of a finding of abuse, neglect, exploitation, mistreatment of residents or misappropriation of resident property, or failed to report to the state nurse aid registry or licensing authorities any knowledge of actions taken by a court of law that would indicate unfitness as a staff member of a nursing home. Tag F607. Section 483.12b. The facility must develop and implement written policies and procedures that. Section 483.12b1. Prohibit and prevent abuse, neglect, and exploitation of residents and misappropriation of resident property. Section 483.12b2. Establish policies and procedures to investigate any such allegations, and Section 483.12b3. Include training as required at paragraph Section 483.95. Section 483.12b4. Establish coordination with the CAPI program required under Section 483.75. Section 483.12b5. Ensure reporting of crimes occurring in federally funded long-term care facilities in accordance with Section 1150b of the Act. The policies and procedures must include, but are not limited to, the following elements. Section 483.12b5 Roman 2. Posting a conspicuous notice of employee rights, as defined at Section 1150 BD3 of the Act. Section 483.12b5 Roman 3. Prohibiting and preventing retaliation, as defined at Section 1150 BD1 and 2 of the Act. Intent. This regulation was written to provide protections for the health, welfare, and rights of each resident residing in the facility. In order to provide these protections, the facility must develop written policies and procedures to prohibit and prevent abuse, neglect, exploitation of residents, and misappropriation of resident property. These written policies must include, but are not limited to, the following components. Screening C, Section 483.12a3 and 483.12b1. Training C, Section 483.12b3. Prevention C, Section 483.12b1. Identification C, Section 483.12b2. Investigation C, Section 483.12b2. Protection C, Section 483.12b2 and 483.12c3, and Reporting/Response C, Section 483.12b2, 483.12b4, 483.12b5, 483.12c1 and 4. In order to ensure that the facility is doing all that is within its control to prevent such occurrences, these policies must be implemented, i.e., carried out, otherwise the policies and procedures would not be effective. The facility is expected to provide oversight and monitoring to ensure that its staff, who are agents of the facility, implement these policies during the provision of care and services to each resident residing in the facility. A facility cannot disown the acts of its staff, since the facility relies on them to meet the Medicare and Medicaid requirements for participation by providing care in a safe environment. Note, for purposes of this guidance, staff includes employees, the medical director, consultants, contractors, volunteers. Staff would also include caregivers who provide care and services to residents on behalf of the facility, students in the facility's nurse aid training program, and students from affiliated academic institutions, including therapy, social, and activity programs. Definitions. Covered individual is anyone who is an owner, operator, employee, manager, agent, or contractor of the facility. See Section 1150 BA3 of the Act. Crime. Section 1150 BB1 of the Act provides that a crime is defined by law of the applicable political subdivision where the facility is located. A political subdivision would be a city, county, township, or village, or any local unit of government created by or pursuant to state law. Law enforcement, as defined in Section 2011-13 of the Act, is the full range of potential responders to elder abuse, neglect, and exploitation, including police, sheriffs, detectives, public safety officers, corrections personnel, prosecutors, medical examiners, investigators, and coroners. Serious bodily injury means an injury involving extreme physical pain, involving substantial risk of death, involving protracted loss or impairment of the function of a bodily member, organ, or mental faculty, requiring medical intervention such as surgery, hospitalization, or physical rehabilitation, or an injury resulting from criminal sexual abuse. See Sections 2011-19A and B of the Act. Criminal sexual abuse. In the case of criminal sexual abuse, which is defined in Section 2011-19B of the Act, serious bodily injury/harm shall be considered to have occurred if the conduct causing the injury is conduct described in Section 2241 relating to aggravated sexual abuse, or Section 2242 relating to sexual abuse of Title 18, United States Code, or any similar offense under state law. In other words, serious bodily injury includes sexual intercourse with a resident by force or incapacitation, or through threats of harm to the resident or others, or any sexual act involving a child. Serious bodily injury also includes sexual intercourse with a resident who is incapable of declining to participate in the sexual act or lacks the ability to understand the nature of the sexual act. Guidance. The facility must develop and implement policies and procedures that include the following 7 components. I. Screening. The facility must have written procedures for screening potential employees for a history of abuse, neglect, exploitation, or misappropriation of resident property in order to prohibit abuse, neglect, and exploitation of resident property, and consistent with the applicable requirements at Section 483.12A3. This includes attempting to obtain information from previous employers and/or current employers and checking with the appropriate licensing boards and registries. See F629. For requirements related to registry verification and multi-state registry verification. Additionally, a facility's services may be furnished under arrangement with a registry, contracted or temporary agency staff, or students from affiliated academic institutions. The facility's policies must also address how pre-screening occurs for prospective consultants, contractors, volunteers, caregivers, and students in its nurse aid training program, and students from affiliated academic institutions, including therapy, social, and activity programs. The facility should require these individuals be subject to the same scrutiny prior to placement in the facility, whether screened by the facility itself, the third-party agency, or academic institution. The facility should maintain documentation of the screening that has occurred. The facility must have written procedures for screening that may include, but are not limited to, for prospective employees, reviewing the employment history, e.g., dates of employment, position, or title, particularly where there is a pattern of inconsistency. O. Information from former employers, whether favorable or unfavorable, and / or O. Documentation of status, and any disciplinary actions from licensing or registration. Boards and other registries. Note, if a facility has not developed and / or implemented policies and procedures related to screening procedures prior to employment, a finding of noncompliance should be considered at F607, not F606, if it is determined that the facility employed or engaged an individual, either directly or under contract, who was found guilty by a court of law of abuse, neglect, misappropriation of property, exploitation or mistreatment, or had a finding entered into the state nurse aid registry, or has a disciplinary action in effect against his or her professional license. Concerning abuse, neglect, mistreatment of residents or misappropriation of resident property, a finding of noncompliance must be cited at F606. In addition, a facility must develop and implement policies and procedures to prohibit and prevent both abuse and neglect. This would include screening prospective residents to determine whether the facility has the capability and capacity to provide the necessary care and services for each resident admitted to the facility. The facility's written procedures may include, but are not limited to, for prospective residents, reviewing O. An assessment of the individual's functional and mood/behavioral status, O. Medical acuity, and O. Special needs, e.g., mechanical ventilation care, dialysis, hospice. The facility can then determine whether, in consideration of current staffing patterns, staff qualifications, competency and knowledge, clinical resources, physical environment, and equipment, it can safely and competently provide the necessary care to meet the resident's needs. For example, a resident may have a prior history of distressed behaviors, such as unsafe wandering, physically aggressive behaviors including sexually aggressive behaviors, or mental/psychiatric illnesses, in order to provide protections and a safe environment for the resident and other residents. The facility must determine whether it has sufficient competent and qualified staff in order to meet the needs of the resident. If the individual is admitted, pre-admissions screening information may provide information that may be used as part of the initial assessment and care planning data. Roman II, training. The facility must have written policies and procedures that include training new and existing nursing home staff and in-service training for nurse aides in the following topics, which include prohibiting and preventing all forms of abuse, neglect, misappropriation of resident property, and exploitation, identifying what constitutes abuse, neglect, exploitation, and misappropriation of resident property, recognizing signs of abuse, neglect, exploitation, and misappropriation of resident property, such as physical or psychosocial indicators, reporting abuse, neglect, exploitation, and misappropriation of resident property, including injuries of unknown sources, and to whom and when staff and others must report their knowledge related to any alleged violation without fear of reprisal, and understanding behavioral symptoms of residents that may increase the risk of abuse and neglect and how to respond. These symptoms include, but are not limited to, the following: O. Aggressive and / or catastrophic reactions of residents, O. Wandering or elopement type behaviors, O. Resistance to care, O. Outbursts or yelling out, and O. Difficulty in adjusting to new routines or staff. Note, the provision of training on abuse prohibition alone does not relieve the nursing home of its responsibility to assure that the resident is free from abuse. Ongoing oversight and supervision of staff assures that its policies and procedures are implemented as written. Note, Federal regulations at 42 CFR Section 483.95C and Section 483.95G specify that a facility must develop, implement, and maintain a training program that includes staff training related to abuse, neglect, and exploitation. If the facility fails to develop and implement policies and procedures that include training as required at 42 CFR Section 483.95C and G2, then F607 would be cited. Refer to tag F943 if there are concerns related to the development, implementation, and maintenance of an effective training program for all new and existing staff, which includes training on activities that constitute abuse, neglect, exploitation, and misappropriation of resident property, procedures for reporting incidents, and dementia management. Refer to tag F947 for concerns related to the provision of in-service training, which must include dementia management training and resident abuse prevention training. Roman 3. Prevention. The facility must have and implement written policies and procedures to prevent and prohibit all types of abuse, neglect, misappropriation of resident property, and exploitation that achieves but is not limited to establishing a safe environment that supports, to the extent possible, a resident's consensual sexual relationship, and by establishing policies and protocols for preventing sexual abuse, such as the identify when, how, and by whom determinations of capacity to consent to a sexual contact will be made, and where this documentation will be recorded, and the resident's right to establish a relationship with another individual, which may include the development of or the presence of an ongoing sexually intimate relationship. Identifying, correcting, and intervening in situations in which abuse, neglect, exploitation, and or misappropriation of resident property is more likely to occur. This includes the implementation of policies that address the deployment of trained and qualified, registered, licensed, and certified staff on each shift in sufficient numbers to meet the needs of the residents and assure that the staff assigned have knowledge of the individual residents' care needs and behavioral symptoms. If any, see also F627 related to proficiency of nurse aides. Assuring that residents are free from neglect by having the structures and processes to provide needed care and services to all residents, which includes, but is not limited to, the provision of a facility assessment to determine what resources are necessary to care for its residents competently, the identification, ongoing assessment, care planning for appropriate interventions, and monitoring of residents with needs and behaviors which might lead to conflict or neglect, such as verbally aggressive behavior, such as screaming, cursing, bossing around / demanding, insulting to race or ethnic group, intimidating, physically aggressive behavior, such as hitting, kicking, grabbing, scratching, pushing / shoving, biting, spitting, threatening gestures, throwing objects. Sexually aggressive behavior such as saying sexual things, inappropriate, touching / grabbing. Taking, touching, or rummaging through others' property. Wandering into others' rooms / space. Residents with a history of self-injurious behaviors. Residents with communication disorders or who speak a different language. And residents that require extensive nursing care and / or are totally dependent on staff for the provision of care. Ensuring the health and safety of each resident with regard to visitors such as family members or resident representatives, friends, or other individuals subject to the residents' right to deny or withdraw consent at any time and to reasonable clinical and safety restrictions. Providing residents and representatives information on how and to whom they may report concerns, incidents and grievances without the fear of retribution, and providing feedback regarding the concerns that have been expressed. See F685 for further information regarding grievances. The facility may also develop and implement policies and procedures which achieve the following: identifying, correcting, and intervening in situations in which abuse, neglect, exploitation, and or misappropriation of resident property is more likely to occur. This includes an analysis of and implementation of policies that address at a minimum features of the physical environment that may make abuse, neglect, exploitation, and misappropriation of resident property more likely to occur, such as secluded areas of the facility, and the identification of who is responsible for the supervision of staff on all shifts, and how supervision will occur in order to identify inappropriate staff behaviors, such as using derogatory language, rough handling, ignoring residents while giving care, and directing residents who need assistance with the bathroom to urinate or defecate in their beds, providing staff information on how and to whom they may report concerns, such as insufficient staffing or a shortage in supplies without the fear of retribution, and providing feedback regarding the concerns that have been expressed. Roman 4. Identification. The facility must have written procedures to assist staff in identifying abuse, neglect, and exploitation of residents and misappropriation of resident property. This would include identifying the different types of abuse: mental/verbal abuse, sexual abuse, physical abuse, and the deprivation by an individual of goods and services. Because some cases of abuse are not directly observed, understanding resident outcomes of abuse could assist in identifying whether abuse is occurring or has occurred. Possible indicators of abuse include, but are not limited to, an injury that is suspicious because the source of the injury is not observed or the extent or location of the injury is unusual, or because of the number of injuries either at a single point in time or over time, and sudden or unexplained changes in the following behaviors and or activities, such as fear of a person or place, or feelings of guilt or shame. V. Investigation. The facility must have written procedures for investigating abuse, neglect, misappropriation, and exploitation that include: note, see also Section VI regarding protection of the alleged victim. Identifying staff responsible for the investigation. Exercising caution in handling evidence that could be used in a criminal investigation, e.g., not tampering or destroying evidence. Investigating different types of alleged violations. Identifying and interviewing all involved persons, including the alleged victim, alleged perpetrator, witnesses, and others who might have knowledge of the allegations. Focusing the investigation on determining if abuse, neglect, exploitation, and or mistreatment has occurred, the extent and cause, and providing complete and thorough documentation of the investigation. VI. Protection. The facility must have written procedures that ensure that all residents are protected from physical and psychosocial harm during and after the investigation. This must include responding immediately to protect the alleged victim and integrity of the investigation, examining the alleged victim for any sign of injury, including a physical examination or psychosocial assessment if needed, increased supervision of the alleged victim and residents, room or staffing changes, if necessary, to protect the residentess from the alleged perpetrator, protection from retaliation, and providing emotional support and counseling to the resident during and after the investigation, as needed. Roman 7. Reporting/response. The facility must have written procedures that must include immediately reporting all alleged violations to the administrator, state agency, adult, protective services, and to all other required agencies, e.g., law enforcement when applicable within specified timeframes, assuring that reporters are free from retaliation or reprisal. Post a conspicuous notice of employee rights, including the right to file a complaint with the state survey agency if they believe the facility has retaliated against an employee or individual who reported a suspected crime and how to file such a complaint. Reporting to the state nurse aid registry or licensing authorities any knowledge it has of any actions by a court of law which would indicate an employee is unfit for service. Taking all necessary actions as a result of the investigation, which may include, but are not limited to, the following. Analyzing the occurrences to determine why abuse, neglect, misappropriation of resident property or exploitation occurred and what changes are needed to prevent further occurrences. Defining how care provision will be changed and / or improved to protect residents receiving services. Training of staff on changes made and demonstration of staff competency after training is implemented. Identification of staff responsible for implementation of corrective actions. The expected date for implementation, and identification of staff responsible for monitoring the implementation of the plan. To encourage reporting of reasonable suspicions of a crime, facilities should develop and implement policies and procedures that promote a culture of safety and open communication in the work environment. This may be accomplished through prohibiting retaliation against an employee who reports a suspicion of a crime. Actions that constitute retaliation against staff include when a facility discharges, demotes, suspends, threatens, harasses, or denies a promotion or other employment-related benefit to an employee, or in any other manner discriminates against an employee in the terms and conditions of employment because of lawful acts done by the employee. When a facility files a complaint or a report against a nurse or other employee with the state professional licensing agency because of lawful acts done by the nurse or employee. For reporting a reasonable suspicion of a crime to law enforcement. An example of retaliation would be if a staff member, on behalf of or as an agent of the facility, harasses an employee who had reported a reasonable suspicion of a crime. In addition to developing policies prohibiting retaliation for reporting suspicions of a crime, the facility must develop and implement policies and procedures for posting notice in a conspicuous location informing covered individuals of their rights under Section 1150B of the Act, including the right to file a complaint with the state survey agency if they believe the facility has retaliated against an employee or individual who reported a suspected crime and how to file such a complaint. The sign may be posted in an area that is visible to employees, such as the same area where the facility posts other employee signs, such as labor management posters. Size and type. Requirements for the sign should be no less than the minimum required for any other required employment-related signs. Roman 8, coordination with CAPI. The facility must develop written policies and procedures that define how staff will communicate and coordinate situations of abuse, neglect, misappropriation of resident property, and exploitation with the CAPI program under Section 483.75. Cases of physical or sexual abuse, for example by facility staff or other residents, always require corrective action and tracking by the QAA Committee at Section 483.75G2. This coordinated effort would allow the QAA committee to determine if a thorough investigation is conducted, whether the resident is protected, whether an analysis was conducted as to why the situation occurred, risk factors that contributed to the abuse, e.g., history of aggressive behaviors, environmental factors, and whether there is further need for systemic action such as insight on needed revisions to the policies and procedures that prohibit and prevent abuse/neglect/misappropriation/exploitation. Increased training on specific components of identifying and reporting that staff may not be aware of or are confused about. Efforts to educate residents and their families about how to report any alleged violations without fear of repercussions. Measures to verify the implementation of corrective actions and timeframes, and tracking patterns of similar occurrences. Note, for failures related to the development and implementation of policies and procedures to communicate and coordinate with the CAPI program situations of abuse, neglect, misappropriation of resident property, and exploitation, cite tag F607. For failures related to the QAA Committee's identification of quality deficiencies or its development and implementation of action plans to correct identified quality deficiencies, cite tag F867. Refer also to the CE pathways for abuse form CMS 20059 and neglect form CMS 20130 and the investigative protocols for tags F602 and F603. Investigative protocol for policies and procedures related to allegations of retaliation by the facility against a covered individual. Use this protocol during any survey, if based on a complaint or an investigation of abuse, neglect, misappropriation of resident property, or exploitation, an allegation of retaliation by the facility against a covered individual was received. Refer to the CE pathways for abuse form CMS 20059 and neglect form CMS 20130 and the investigative protocols for tags F602 and F603, which gathers information about what information was or was not reported by covered individuals and whether retaliation may have occurred. The protocol below investigates whether the facility developed and implemented policies and procedures related to posting notification of employee rights and prohibiting and preventing retaliation. Procedures, facility policies and procedures. Obtain and review the facility's policies and procedures to determine whether the facility is posting notification of employee rights and prohibiting and preventing retaliation against covered individuals who make reports of a reasonable suspicion of a crime. Observations. Observe whether the facility has posted notification of employee rights and whether the notification includes all of the required components. Note the location of the notification in relation to whether it is likely to be noticed by all employees. Interview of state professional licensing authorities. If there is an allegation of facility retaliation against an employee, the surveyor should contact the appropriate state licensing board to determine whether the facility had filed a complaint or report against the employee, and if so, what information was provided in the complaint or report. Interview staff. For an allegation of retaliation, interview staff about what occurred, how the facility allegedly retaliated against staff, and when. Interview administrator. Interview the administrator to determine the following: how the administrator oversees the implementation of policies and procedures for reporting of suspected crimes. For an allegation of retaliation, whether any actions were taken against an employee, and if so, what actions and Why? O. Whether the facility had submitted a report to the state professional licensing agency against the employee S, and if so, why? Review of employee personnel records. If there is an allegation of retaliation against an employee or other covered individual, obtain a copy of the employee's personnel records and records for other covered individuals as applicable to determine if the facility may have taken any action against the individual which may be related to the report of a suspected crime. Note, if the surveyor discovers a reasonable suspicion of a crime committed against a resident of or an individual receiving services from the facility, and it has not been reported by a covered individual, the surveyor reminds the facility of the covered individual's obligation to report suspected crimes pursuant to Section 1150B of the Act within the required timeframes. Covered individual is anyone who is an owner, operator, employee, manager, agent, or contractor of the facility as defined in Section 1150BA3 of the Act. If a covered individual reports the suspected crime to local law enforcement, the surveyor must verify that the report was made. E.g., obtain time/date of report, name of person who received report, case number, etc. If the covered individual refuses to report, or the surveyor cannot verify that a report was done, the surveyor must consult with his or her supervisor immediately, and the state agency must report the potential criminal incident to law enforcement immediately. Key elements of noncompliance. To cite deficient practice at F607, the surveyor's investigation will generally show that the facility has failed to do one or more of the following: develop and implement written policies and procedures that prohibit and prevent abuse, neglect and exploitation of residents and misappropriation of resident property, and includes the screening of prospective employees and residents, or develop and implement written policies and procedures for the investigation of allegations of abuse, neglect and exploitation of residents and misappropriation of resident property, and includes the staff identification of abuse, neglect, exploitation, and misappropriation of resident property, protection of residents during investigations, and the reporting of allegations and investigative findings and taking corrective actions, or develop and implement written policies and procedures that include training as required at Section 483.95, or develop and implement written policies and procedures that establish coordination with the CAPI program required under Section 483.75, or develop and implement written policies and procedures related to posting conspicuous signage of employee rights related to retaliation against the employee for reporting a suspected crime and prohibiting and preventing retaliation. Tag F609. Section 483.12b. The facility must develop and implement written policies and procedures that Section 483.12b5 ensure reporting of crimes occurring in federally funded long-term care facilities in accordance with Section 1150b of the Act. The policies and procedures must include, but are not limited to, the following elements: annually notifying covered individuals, as defined at Section 1150BA3 of the Act, of that individual's obligation to comply with the following reporting requirements. Each covered individual shall report to the state agency and one or more law enforcement entities for the political subdivision in which the facility is located any reasonable suspicion of a crime against any individual who is a resident of or is receiving care from the facility. Each covered individual shall report immediately, but not later than 2 hours after forming the suspicion, if the events that cause the suspicion result in serious bodily injury, or not later than 24 hours if the events that cause the suspicion do not result in serious bodily injury. Section 483.12c, in response to allegations of abuse, neglect, exploitation, or mistreatment, the facility must. Section 483.12c1, ensure that all alleged violations involving abuse, neglect, exploitation, or mistreatment, including injuries of unknown source and misappropriation of resident property, are reported immediately, but not later than 2 hours after the allegation is made. If the events that cause the allegation involve abuse or result in serious bodily injury, or not later than 24 hours if the events that cause the allegation do not involve abuse and do not result in serious bodily injury to the administrator of the facility and to other officials, including to the state survey agency and adult protective services where state law provides for jurisdiction in long-term care facilities in accordance with state law through established procedures. Section 483.12c4, report the results of all investigations to the administrator or his or her designated representative and to other officials in accordance with state law, including to the state survey agency within 5 working days of the incident, and if the alleged violation is verified, appropriate corrective action must be taken. Intent. The intent is for the facility to develop and implement policies and procedures that provide annual notification to each covered individual of their obligation to comply with the reporting requirements under Section 1150BB of the Act. Ensure reporting reasonable suspicion of crimes against a resident or individual receiving care from the facility within prescribed timeframes to the appropriate entities, consistent with Section 1150B of the Act, and ensure that all covered individuals, i.e., the owner, operator, employee, manager, agent, or contractor, report reasonable suspicion of crimes, as required by Section 1150B of the Act. The facility should provide oversight and monitoring to ensure that implement the required policies and procedures per 42 CFR Section 483.12b. In addition, the facility must report alleged violations related to mistreatment, exploitation, neglect, or abuse, including injuries of unknown source and misappropriation of resident property, and report the results of all investigations to the proper authorities within prescribed timeframes. Definitions. Abuse is defined at Section 483.5 as the willful infliction of injury, unreasonable confinement, intimidation, or punishment with resulting physical harm, pain, or mental anguish. Abuse also includes the deprivation by an individual, including a caretaker, of goods or services that are necessary to attain or maintain physical, mental, and psychosocial well-being. Instances of abuse of all residents, irrespective of any mental or physical condition, cause physical harm, pain, or mental anguish. It includes verbal abuse, sexual abuse, physical abuse, and mental abuse, including abuse facilitated or enabled through the use of technology. Alleged violation is a situation or occurrence that is observed or reported by staff, resident, relative, visitor, another healthcare provider, or others but has not yet been investigated and, if verified, could be non-compliance with the federal requirements related to mistreatment, exploitation, neglect, or abuse, including injuries of unknown source and misappropriation of resident property. Covered individual is anyone who is an owner, operator, employee, manager, agent, or contractor of the facility. See Section 1150BA3 of the Act. Crime. Section 1150 BB1 of the Act provides that a crime is defined by law of the applicable political subdivision where the facility is located. A political subdivision would be a city, county, township, or village, or any local unit of government created by or pursuant to state law. Exploitation, as defined at Section 483.5, means taking advantage of a resident for personal gain through the use of manipulation, intimidation, threats, or coercion. Injuries of unknown source. An injury should be classified as an injury of unknown source when all of the following criteria are met. The source of the injury was not observed by any person, and the source of the injury could not be explained by the resident, and the injury is suspicious because of the extent of the injury or the location of the injury. E.g., the injury is located in an area not generally vulnerable to trauma, or the number of injuries observed at one particular point in time, or the incidence of injuries over time. Law enforcement, as defined in Section 2011-13 of the Act, is the full range of potential responders to elder abuse, neglect, and exploitation, including police, sheriffs, detectives, public safety officers, corrections personnel, prosecutors, medical examiners, investigators, and coroners. Misappropriation of resident property, as defined at Section 483.5, means the deliberate misplacement, exploitation, or wrongful, temporary or permanent use of a resident's belongings or money without the resident's consent. Mistreatment, as defined at Section 483.5, is inappropriate treatment or exploitation of a resident. Neglect, as defined at Section 483.5, means the failure of the facility, its employees, or service providers to provide goods and services to a resident that are necessary to avoid physical harm, pain, mental anguish, or emotional distress. Serious bodily injury is defined in Section 2011-19 of the Act and means an injury involving extreme physical pain, substantial risk of death, protracted loss or impairment of the function of a bodily member, organ, or mental faculty, or requiring medical intervention such as surgery, hospitalization, or physical rehabilitation. See Section 2011-19A of the Act. Serious bodily injury is considered to have occurred when an injury results from criminal sexual abuse. See Section 2011-19B of the Act. Criminal sexual abuse. In the case of criminal sexual abuse, which is defined in Section 2011-19B of the Act, serious bodily injury/harm shall be considered to have occurred if the conduct causing the injury is conduct described in Section 2241 relating to aggravated sexual abuse, or Section 2242 relating to sexual abuse of Title 18, United States Code, or any similar offense under state law. In other words, serious bodily injury includes sexual intercourse with a resident by force or incapacitation, or through threats of harm to the resident or others, or any sexual act involving a child. Serious bodily injury also includes sexual intercourse with a resident who is incapable of declining to participate in the sexual act or lacks the ability to understand the nature of the sexual act. Sexual abuse is defined at Section 483.5 as non-consensual sexual contact of any type with a resident. Willful is defined at Section 483.5 in the definition of abuse and means the individual must have acted deliberately, not that the individual must have intended to inflict injury or harm. Guidance reporting. It is the responsibility of the facility to ensure that all staff are aware of reporting requirements and to support an environment in which covered individuals report a reasonable suspicion of a Crime and staff and others report all alleged violations of mistreatment, exploitation, neglect, or abuse, including injuries of unknown source and misappropriation of resident property. Protection of residents can be compromised or impeded if individuals are fearful of reporting, especially if the alleged abuse has been carried out by a staff member. See Section 483.1 2B5I. During investigations, some staff have stated that he/she was aware or had knowledge that the incident had occurred, but did not report because he/she did not think it met the definition of abuse, neglect, mistreatment, exploitation, or misappropriation of resident property or a reasonable suspicion of a crime. Anecdotal reports have indicated that failure to report an alleged violation may be due to, but not limited to, the following. An individual's allegation is not believed due to a history of reporting false allegations. Staff fear of retaliation, or fear losing his or her job. Sympathy for co-workers, for example, not wanting to cause trouble for the co-worker. Communication, cultural or language issues, or residents/resident representatives may fear retaliation. Note, once an individual suspects that a crime has been committed, facility staff should exercise caution when handling materials that may be used for evidence or for a criminal investigation. Facilities should reference applicable state and local laws regarding preserving evidence. It has been reported that some investigations were impeded due to washing linens or clothing, destroying documentation, bathing or cleaning the resident before the resident has been examined, or failure to transfer a resident to the emergency room for examination, including obtaining a rape kit, if appropriate. The following table describes the different reporting requirements that are addressed under 42 CFR 483.12. What is to be 42 CFR 483.1, 2B5, and 42 CFR 483.12C. Reported Section 1150B of the Act. Any reasonable suspicion of all alleged violations of abuse, neglect, who is a crime against a resident or exploitation or mistreatment, including required to an individual receiving care injuries of unknown source and report from the facility misappropriation of resident property, to whom any covered individual, to the results of all investigations of, which means the owner, alleged violations, operator, employee, manager, agent or contractor the facility, of the facility, state survey agency, saw the facility administrator, and to other, and one or more law officials in accordance with state law. When 42 CFR 483.1, 2B5, and 42 CFR 483.12C. Section 1150B of the Act. Enforcement entities for the including to the SA and the Adult Protective Political Subdivision, in which services where state law provides for. The facility is located, i.e., jurisdiction in long-term care facilities. The full range of potential responders to elder abuse, all alleged violations, neglect, and exploitation 1 immediately, but not later than 2, including police, sheriffs, hours * if the alleged violation, detectives, public safety involves abuse or results in serious, officers, corrections bodily injury, personnel, prosecutors, 2 not later than 24 hours * if they, medical examiners, alleged violation involves neglect, investigators, and coroner's exploitation, mistreatment, serious bodily injury, misappropriation of resident, immediately but not later property, and does not result in, then 2 hours * after forming serious bodily injury. The suspicion, no serious bodily injury not later than 24 hours *. Results of all investigations of alleged Violations within 5 working days of the incident. Asterisk reporting requirements under this regulation are based on real clock time, not business hours, ensuring the reporting of a reasonable suspicion of a crime. A facility's policies and procedures for reporting under 42 CFR 483.1 2B5 should specify the following components, which include, but are not limited to, identification of who in the facility is considered a covered individual, identification of crimes that must be reported. Note, each state and local jurisdiction may vary in what is considered to be a crime, and may have different definitions for each type of crime. Facilities should consult with local law enforcement to determine what is considered a crime. Identification of what constitutes serious bodily injury, the time frame for which the reports must be made, and which entities must be contacted, for example, the state survey agency and local law enforcement. There are instances where an alleged violation of abuse, neglect, misappropriation of resident property and exploitation would be considered to be reasonable suspicion of a crime. In these cases, the facility is obligated to report to the administrator, to the state survey agency, and to other officials in accordance with state law C. F609. Regardless, covered individuals still have the obligation to report the reasonable suspicion of a crime to the state survey agency and local law enforcement. Some facilities may have policies and procedures where the administrator could coordinate timely reporting to the state survey agency and law enforcement on behalf of covered individuals who choose to report to the administrator. Risks to the covered individual for reporting to the administrator could be mitigated if an individual has clear assurance that the administrator is reporting it, and submitting a collective report would not cause delays in reporting according to specified timeframes. Reports should be documented, and the administrator should keep a record of the documentation. It remains the responsibility of each covered individual to ensure that his or her individual reporting responsibility is fulfilled, so it is advisable for any multiple person report to include identification of all individuals making the report. In addition, a facility cannot prohibit or circumscribe a covered individual from reporting directly to law enforcement, even if it has a coordinated internal system. Surveyors must review whether the facility has included in its policies and procedures examples of crimes that would be reported, examples of situations that would likely be considered crimes. In all subdivisions would include, but are not limited to, murder, manslaughter, rape, assault and battery, sexual abuse, theft/robbery, drug diversion for personal use or gain, identity theft, and fraud and forgery. There are political subdivisions that have other examples for which instances of elder mistreatment are considered to be crimes, because all reasonable suspicions of crimes must be reported, regardless of whether it is perpetrated by facility staff, residents, or visitors. It would be especially beneficial for the facility to work with local law enforcement in determining what would not be reported, e.g., all cases of resident-to-resident conflict may not rise to the level of abuse and may not be appropriate to report to local law enforcement. Even in the presence of a policy and procedure, failure to report a reasonable suspicion of a crime may be indicative of failure to implement the facility's policies and procedures. Surveyors should investigate further and document the failure to develop and or implement policies and procedures for reporting suspected crimes, e.g., how the facility may not have provided notification to its employees, how covered individuals are fearful of reporting or do not want to get others in trouble, etc. Facilities must ensure the reporting of a reasonable suspicion of a crime by implementing proper policies and procedures addressing the following actions, which should include, but are not limited to, orienting new and temporary/agency/contractor staff to the reporting requirements, assuring that covered individuals are annually notified of their responsibilities in a language that they understand, identifying barriers to reporting such as fear of retaliation or causing trouble for someone, and implementing interventions to remove barriers and promote a culture of transparency, and reporting, identifying which cases of abuse, neglect, and exploitation may rise to the level of a reasonable suspicion of crime, and recognizing the physical and psychosocial indicators of abuse/neglect/exploitation, working with law enforcement annually to determine which crimes are reported, assuring that covered individuals can identify what is reportable as a reasonable suspicion of a crime with competency testing or knowledge checks, providing in-service training when covered individuals indicate that they do not understand their reporting responsibilities, and providing periodic drills across all levels of staff across all shifts to assure that covered individuals understand the reporting requirements. Annual notification of reporting obligations to covered individuals. The facility must develop and implement written procedures that include, but are not limited to, notifying covered individuals annually of their obligations to report reasonable suspicion of crimes in the facility C Section 483.1 2B5I. Policies and procedures should include, but are not limited to, the following: identification of who are the covered individuals in the facility, how covered individuals are notified of the reporting requirements. Notification must include the following: each covered individual's independent obligation to report the suspicion of a crime against a resident or individual receiving care and services from the facility directly to local law enforcement and the state survey agency. The timeframe requirements for reporting reasonable suspicion of crimes. If the events that cause the reasonable suspicion result in serious bodily injury to a resident, the covered individual must report the suspicion immediately, but not later than 2 hours after forming the suspicion. If the events that cause the reasonable suspicion do not result in serious bodily injury to a resident, the covered individual shall report the suspicion not later than 24 hours after forming the suspicion. Penalties associated with failure to report. If a covered individual fails to report within mandated timeframes, the covered individual will be subject to a civil money penalty of not more than $200,000, as adjusted annually under 45 CFR Part 102, and the covered individual may be excluded from participation in any federal health care program as defined in Section 1128 BF of the Act. If a covered individual fails to report within mandated timeframes and the violation exacerbates the harm to the victim of the crime or results in harm to another individual, the covered individual will be subject to a civil money penalty of not more than $300,000 as adjusted annually under 45 CFR Part 102, and the Secretary may make a determination in the same proceeding to exclude the covered individual from participation in any federal health care program as defined in Section 1128 BF of the Act. The mechanism for documenting that all covered individuals have been notified annually of their reporting obligations. Documentation may include a copy of a notice or letter sent to covered individuals with confirmation that it was received or a completed training/orientation attendance sheet documenting the individual completed training on. Reporting obligations. Reporting alleged violations. An alleged violation can be observed or reported by staff, resident, relative, visitor, another, healthcare provider, or others. For example, a receiving hospital may report to the facility suspicious bruising of the resident near the inner thighs and groin area, which were identified. During a medical exam in the emergency department, an individual, e.g., a resident, visitor, facility staff who reports an alleged violation to facility staff does not have to explicitly characterize the situation as abuse, neglect, mistreatment, or exploitation in order to trigger the federal requirements at Section 483.12c. Rather, if facility staff could reasonably conclude that the potential exists for noncompliance with the federal requirements related to mistreatment, exploitation, neglect, or abuse, including injuries of unknown source and misappropriation of resident property, then it would be considered to be reportable and require action under Section 483.12c. For example, if a resident is abused but does not allege abuse, the resident's failure or inability to provide information about the occurrence is immaterial when the abuse may be substantiated by other supporting evidence. Another example is when a nurse aide witnesses an act of abuse but fails to report the alleged violation. The failure to report does not support a conclusion that the abuse did not occur, and the facility would not meet the reporting requirements. All alleged violations, whether oral or in writing, must be reported to the administrator of the facility and to other officials in accordance with state law through established procedures, including to the State Survey and Certification Agency and Adult Protective Services where state law provides for jurisdiction in long-term care facilities. Conformance with this provision requires that each state agency has a means to collect reports, even during off-duty hours, e.g., answering machine, voicemail, fax, electronic transmission, etc. The facility must have documentation of the report, including what was reported and the date and time the report was made to the SA. The facility must submit reports that are accurate to the best of its knowledge. At the time of submission of the report, it is important that facilities not make reports that are misleading, such as reports that deliberately omit facts or reports that are designed to make the incident appear less serious than it was, or reports that misrepresent the facility's response. Deliberate misrepresentations or omissions could result in a deficiency at F609 or may give rise to other deficiencies. Initial report for alleged violations of abuse, or if there is resulting serious bodily injury, the facility must report the allegation immediately, but no later than 2 hours after the allegation is made. For alleged violations of neglect, exploitation, misappropriation of resident property, or mistreatment that do not result in serious bodily injury, the facility must report the allegation no later than 24 hours. The facility must provide in its report sufficient information to describe the alleged violation and indicate how residents are being protected. See Section 483.12c3. It is important that the facility provide as much information as possible, to the best of its knowledge, at the time of submission of the report, so that state agencies can initiate action necessary to oversee the protection of nursing home residents. Please see Exhibit 358 for a sample form for initial reporting, with examples of information. Follow-up investigation report within 5 working days of the incident. The facility must provide in its report sufficient information to describe the results of the investigation and indicate any corrective actions taken if the allegation was verified. It is important that the facility provide as much information as possible to the best of its knowledge at the time of submission of the report, so that state agencies can initiate action necessary to oversee the protection of nursing home residents. See Section 483.12C4. The facility should include any updates to information provided in the initial report. Please see Exhibit 359 for a sample form. For investigation report, with examples of information. In the absence of a shorter state timeframe requirement, all alleged violations involving abuse or resulting in serious bodily injury are reported immediately, but not later than 2 hours after the allegation is made. If the alleged allegation involves neglect, misappropriation of resident property, or exploitation, and does not result in serious bodily injury, the facility must report not later than 24 hours after the allegation is made. The facility is not prohibited from fulfilling its reporting obligations earlier than the timeframes provided in the regulations, so that immediate actions can be taken to protect the residentess. If an alleged violation has been identified and reported to the administrator/designee, the facility must report it and provide protection for the identified residentess prior to conducting the investigation of the alleged violation. In some situations, the facility may initially evaluate an occurrence to determine whether it meets the definition of an alleged violation. For example, upon discovery of an injury, the facility must take steps to evaluate whether the injury meets the definition of an injury of unknown source. Similarly, if a resident states that his or her belongings are stolen, the facility may make an initial determination whether the item has been misplaced in the resident's room, in the laundry, or elsewhere before reporting misappropriation of property. However, if the alleged violation meets the definition of abuse, neglect, exploitation, or mistreatment, the facility should not make an initial determination whether the allegation is credible before reporting the allegation. Note, at the conclusion of the investigation, and no later than 5 working days of the incident, the facility must report the results of the investigation, and if the alleged violation is verified, take corrective action in accordance with Section 483.12C4. The phrase "in accordance with state law" modifies the word "officials" only. State law may stipulate that alleged violations and the results of the investigations be reported to additional state officials beyond those specified in federal regulations. This phrase does not modify what types of alleged violations must be reported or the timeframes in which the reports are to be made. States may not eliminate the obligation for any of the alleged violations, i.e., mistreatment, neglect, abuse, injuries of unknown source, exploitation, and misappropriation of resident property to be reported, nor can the state establish longer time frames for reporting than mandated in the regulations at Section 483.12C1 and 4. No state can override the obligation of the nursing home to fulfill the requirements under Section 483.12C, as long as the Medicare/Medicaid certification is in place. Some states may have different reporting requirements that could go beyond the federal requirements or are more specific than the federal requirements. For example, some states require that all falls be reported to the SA. The SA should continue to manage and investigate these cases under its state licensure authority. If the state determines that these occurrences do meet the definition of abuse, neglect, mistreatment, or injuries of unknown source, as outlined in this guidance, the SA must assess whether the nursing home has met the requirements for reporting and investigating these cases in accordance with 42 CFR, Section 483.12C. If the surveyor discovers a reasonable suspicion of a crime committed against a resident of or an individual receiving services from the facility, and it has not been reported by a covered individual, the surveyor reminds the facility of the covered individual's obligation to report suspected crimes pursuant to Section 1150B of the Act within the required timeframes. Covered individual is anyone who is an owner, operator, employee, manager, agent, or contractor of the facility as defined in Section 1150BA3 of the Act. If a covered individual reports the suspected crime to local law enforcement, the surveyor must verify that the report was made. E.g., obtain time/date of report, name of person who received report, case number, etc. If the covered individual refuses to report, or the surveyor cannot verify that a report was done, the surveyor must consult with his or her supervisor immediately, and the state agency must report the potential criminal incident to law enforcement immediately. See F609. Identification of alleged violations. The following addresses facility responsibilities for reporting allegations/occurrences involving staff-to-resident abuse, resident-to-resident altercations, injuries of unknown source, misappropriation of resident property/exploitation, and mistreatment. A report of an alleged violation does not automatically indicate that a citation at F600, F602, or F603 is warranted. The survey team must conduct a thorough investigation of the allegation. If the collected evidence supports that abuse, neglect, or misappropriation of resident property/exploitation has occurred, it is appropriate for the survey team to cite the current or past noncompliance at the appropriate tag, e.g., F600 free from abuse and neglect. Section I, staff-to-resident abuse. All allegations/occurrences of all types of staff-to-resident abuse must be reported to the administrator and to other officials, including the state survey agency and adult protective services, where state law provides for jurisdiction in nursing homes. See 483.12c. This includes, but is not limited to, all allegations/occurrences of physical, sexual, mental, and verbal abuse, including deprivation of goods and services by staff, and involuntary seclusion perpetrated by staff. See F600 and F603 for examples of types of abuse. Staff taking or distributing demeaning or humiliating photographs or recordings of residents through social media or multimedia messaging, and all reports from residents of abuse perpetrated by staff. Allegations must not be dismissed on the basis of a resident's cognitive impairment tests. Section Roman II, resident-to-resident altercations. Resident-to-resident altercations that must be reported in accordance with the regulations include any willful action that results in physical injury, mental anguish, or pain, as defined at Section 483.5. The tables below includes examples of resident-to-resident altercations and whether they are required to be reported. Note, this is not an exhaustive list of all reportable types of resident-to-resident altercations. There may be other incidents that are also reportable. Examples of mental/verbal conflict. Required to report, not required to report, unless it rises to the level of what's described in the first column: intimidation, non-targeted outbursts, bullying, aggressive behavior in which someone, residents with certain intentionally and repeatedly causes another resident conditions, e.g., mental anguish or discomfort adapted from the Huntington's/Tourette's. American Psychological Association, 2 who exhibit verbalizations. Communication that is motivated by an actual or arguments or disagreements. Perceived characteristic, such as race, color, religion, which do not include any. Sex, disability, or sexual orientation that results in behavior or communication. Mental anguish or social withdrawal ***, identified in the required to. Threats of violence report column. Inappropriate sexual comments that are used in a deliberately **threatening manner. Required to report, not required to report, unless it rises to the level of inappropriate sexual comments that offend, humiliate, what's described in the first, or demean a resident ***, column. Taking and slash or distributing demeaning or humiliating photographs or recordings of residents through social media or multimedia messaging. Note: having a mental disorder or cognitive impairment does not automatically preclude a resident from engaging in deliberate or non-accidental actions. There may be some situations in which the psychosocial outcome to the resident may be difficult to determine or incongruent with what would be expected. In these situations, it is appropriate to consider how a reasonable person in the resident's circumstances would be impacted by the incident. Examples of sexual contact. Note: see also guidance at F600 related to sexual abuse and capacity and consent. Required to report, not required to report, unless it rises to the level of what's described in the first column. Unwanted touching of the breasts or consensual sexual contact between perineal area residents who have the capacity to. A resident who fondles or touches a consent to sexual activity. Person's sexual organs and the resident affectionate contact such as hand. Being touched indicates the touching is holding or hugging or kissing a resident. Unwanted through verbal or nonverbal cues who indicates that he/she consents to the sexual activities where one resident action through verbal or nonverbal cues indicates that the activity is unwanted, sexual activity between residents in a through verbal or nonverbal cues relationship, married couples or sexual activity or fondling where one of the partners, unless one of the residents' capacity to consent to sexual indicates that the activity is unwanted. Activity is unknown through verbal or nonverbal cues. Sexual assault or battery X, rape, sodomy, coerced nudity. Instances where the alleged victim is transferred to a hospital for examination and / or treatment of injuries resulting from possible sexual abuse. Required to report, not required to report, unless it rises to the level of what's forced observation of masturbation or described in the first column. Pornography. Forced, coerced, or extorted sexual activity. Other unwanted actions for the purpose of sexual arousal or sexual gratification, resulting in degradation or humiliation of another resident. Examples of physical altercations. Resident-to-resident physical altercations that must be reported include any willful action that results in physical injury, mental anguish, or pain. Examples include, but are not limited to, the following. Physical injury. A physical injury resulting from the willful action including, but not limited to, the following. Willful death. Action *, injury requiring medical attention beyond first aid such. Willful actions, as a cut requiring suturing or an injury requiring transfer. Include, but are to a hospital for examination and / or treatment. Not limited to, fractures, subdural hematoma, concussion. The following, bruises. Hitting, facial injury-wise, such as broken or missing teeth, facial. Slapping fractures, black eyes, bruising, bleeding, or swelling of. Punching the mouth or cheeks. Choking mental anguish *. Pinching psychosocial outcomes, resulting from the willful action. Biting including, but not limited to, the following: kicking, fear of a person or place, or of being left alone or of being. Throwing, in the dark, disturbed sleep, nightmares. Objects, changes in behavior, including aggressive or disruptive. Grabbing, shoving behavior toward a specific person. Running away, withdrawal, isolating self, feelings of guilt. And shame, depression, crying, talk of suicide or attempts. Asterisk the action asterisk, there may be some situations in which the psychosocial itself was outcome to the resident may be difficult to determine or deliberate or incongruent with what would be expected. In these non-accidental situations, it is appropriate to consider how a reasonable, not that the person in the resident's circumstances would be impacted by individual the incident intended to inflict injury or pain. Harm, pain resulting from the willful action including, but not limited to, the following. Note, complaints of pain related to the altercation. Onset of pain evidenced by nonverbal indicators, such as O groaning, crying, screaming. O grimacing, clenching of the jaw. O resistance to being touched. O rubbing/guarding body part. Asterisk having a mental disorder or cognitive impairment does not automatically preclude a resident from engaging in deliberate or non-accidental actions. The general examples of physical altercations below illustrate possible cases that would likely not need to be reported, as long as it is not a willful action that results in physical injury. Mental anguish or pain. Every case is fact-specific, and all facts, circumstances, and conditions involving the event/occurrence would need to be examined. A resident lightly taps another resident to stop an irritating behavior or get attention, with no resulting physical injury, mental anguish, or pain. A resident who is slow impedes the pathway of another resident, such as in the dining room. The other resident nudges the resident out of the way to get to his or her table faster. But there is no harm to the victim. A resident who swats at another resident who is trying to take some food off his or her plate. And no physical injury, mental anguish, or pain has occurred. Note, even if a physical altercation is not required to be reported, the facility should take into consideration that physical altercations can increase the risk for abuse to occur to residents involved in the altercation and possibly other residents in the facility. The facility must meet requirements related to appropriate assessment. See Section 483.20, Resident Assessment, Care. Planning by the interdisciplinary team. See Section 483.2, Comprehensive Person-Centered Care. Planning and provide care and services according to acceptable standards of practice. See Section 483.2, 1B3I tag, F658, to prevent harm as a result of resident-to-resident altercations, as well as the development and implementation of policies and procedures to prevent abuse of residents. See Section 483.1, 2B1 tag, F607. Through these actions, the facility can determine areas of needed improvement in care/service provision, staff training, or staff deployment. Section 3. Reporting suspicious injuries of unknown source. Injuries of unknown source. An injury should be classified as an injury of unknown source when all of the following criteria are met. The source of the injury was not observed by any person, and the source of the injury could not be explained by the resident, and the injury is suspicious because of A. The extent of the injury, B. The location of the injury, e.g., the injury is located in an area not generally vulnerable to trauma, or C. The number of injuries observed at one particular point in time, or D. the incidence of injuries over time. Examples of injuries of unknown source. Required to report, not required to report, unless it rises to the level of what's described in the first column. Unobserved/unexplained fractures, sprains, bruising in an area where the resident or dislocations has had recent medical tests/lab draws. Unobserved/unexplained injuries that and there is no indication of abuse or could have resulted from a burn, including neglect. Blisters or scalds, injuries where the resident was able to. Unobserved/unexplained bite marks explain or describe how she received. Unobserved/unexplained scratches, and the injury as long as there is no other. Bruises found in suspicious locations, such indication of abuse or neglect. As the head, neck, upper chest or back, injuries that were witnessed by staff. Unobserved/unexplained swelling, that is where there is no indication of abuse or not linked to a medical condition neglect. Unobserved/unexplained lacerations with note, even if the injury is not one that or without bleeding. Unobserved/unexplained skin tears in sites requires a report. The facility should. Found in suspicious locations, e.g., in sites adequately assess and monitor the resident, notify the physician/resident. Other than the arms or legs. Representative as appropriate, and unobserved/unexplained skin tears in patterns, e.g., bilateral, symmetrical skin document the injury and investigation as a part of the resident's medical record. Tears on both arms. Unobserved/unexplained patterned bruises that suggest hand marks or finger marks, or bruising pattern caused by an object. Unobserved/unexplained bilateral bruising. To arms, bilateral bruising of the inner thighs, wraparound bruises that encircle the legs, arms or torso, and multicolored bruises, which would indicate that several injuries were acquired over time. Unobserved/unexplained facial injuries, including facial fractures, black eyes, bruising or bleeding or swelling of the mouth or cheeks with or without broken or missing teeth. Unobserved/unexplained bruising or other injuries in the genital area, inner thighs, breasts. Unobserved/unexplained injury requiring transfer to a hospital for examination and or treatment. Note, any injury that is explained and appears to be a result of abuse must be reported. Note, if there is a reasonable suspicion of a crime having occurred related to the injury, covered individuals must report to the state survey agency and law enforcement under required timeframes. See tag F609. Section Roman 4. Reportable events related to potential neglect. Neglect means the failure of the facility, its employees or service providers to provide goods and services to a resident that are necessary to avoid physical harm, pain, mental anguish, or emotional distress. See Section 483.5. In other words, neglect occurs when the facility is aware, or should have been aware of, goods or services that a residentess requires, but the facility fails to provide them to the residentess, resulting in physical harm, pain, mental anguish, or emotional distress. Alleged violations of neglect include cases where the facility demonstrates indifference or disregard for resident care, comfort, or safety, resulting in physical harm, pain, mental anguish, or emotional distress. There may be some situations in which the psychosocial outcome to the resident may be difficult to determine or incongruent with what would be expected. In these situations, it is appropriate to consider how a reasonable person in the resident's position would be impacted by the incident. Examples of events to be reported include, but are not limited to, the following. 1. Failure to meet payroll or pay supplier bills, resulting in residents not receiving goods or services such as insufficient staff, including the night shift and weekends, resulting in the lack of provision for residents' care needs, e.g., residents who need continuous skilled nursing care or supervision, residents with cognitive deficits requiring continuous supervision, or lack of essential supplies or equipment such as incontinence supplies, wound care supplies, or oxygen equipment or adaptive equipment according to the needs of the residents, or lack of sufficient amounts of food to meet the residents' nutritional needs. 2. Staff repeatedly ignoring residents' needs for assistance with activities of daily living, resulting in residents remaining in bed when they want to be up and repeatedly missing activities, or residents being left in fecal material or urine. 3. Failure to oversee the management of pain for a resident, resulting in a resident not receiving required medications or treatments, leading to prolonged excruciating pain. 4. Failure to implement and monitor planned interventions, resulting in repeated failures to provide necessary care and services to prevent the development of new avoidable pressure ulcer that develops into a stage 3 or 4 pressure ulcer. Note, noncompliance at the residence right/quality of care/quality of life tag alone does not automatically indicate noncompliance at F600 or F609. The survey team would need additional evidence that identifies that the facility knew or should have known to provide necessary staff, supplies, services, policies, training, or staff supervision and oversight to meet the resident's needs but failed to take action, resulting in harm to the resident. For example, a survey team identifies that a facility had failed to perform a skin assessment for a resident, resulting in failure to implement interventions to prevent the development of an avoidable stage 2 pressure ulcer for a resident. Upon further investigation, the survey team finds that the facility identified the pressure ulcer and treated it with no further worsening, while the survey team would identify noncompliance at F686. The facility would not be cited at F600, and the facility would not be expected to report this as an alleged violation of neglect. Section V. Reportable allegations of misappropriation of resident property and exploitation. The facility must exercise reasonable care for the protection of the resident's property from loss or theft. See Tag F584, 42 CFR Section 483.10 I1 Roman 2. The facility is expected to be responsive to a residents' concerns about lost items. Exploitation, as defined at Section 483.5, means taking advantage of a resident for personal gain through the use of manipulation, intimidation, threats, or coercion. Misappropriation of resident property, as defined at Section 483.5, means the deliberate misplacement, exploitation, or wrongful, temporary or permanent use of a resident's belongings or money without the resident's consent. Examples of allegations of misappropriation of resident property and exploitation that must be reported include, but are not limited to, theft of personal property, including but not limited to jewelry, computer, phone, and other valuable items such as eyeglasses and hearing aids. Unauthorized/coerced use by staff of residents' personal property. Theft of money from bank accounts. Unauthorized or coerced purchases on a resident's credit card. Unauthorized or coerced purchases from residents' funds. Staff who accept money from a resident for any reason, including when staff have made the resident believe that staff was in a financial crisis, or the resident believes that he/she is in a relationship with the staff person. A resident who provides a gift to staff in order to receive ongoing care based on staff's persuasion, and missing prescription medications, or diversion of a resident's medication S, including, but not limited to, controlled substances for staff use or personal gain. Examples of allegations that would not be reported are theft of nominal items with little to no monetary or sentimental value. Lost items that are not listed under must be reported. Section VI, reportable allegations of mistreatment. Mistreatment, as defined at Section 483.5, is inappropriate treatment or exploitation of a resident. Allegations of mistreatment should be reported only if they meet the criteria for reporting alleged. Violations of abuse and or exploitation, which are described under the sections above. Refer to the CE Pathways for Abuse Form CMS 20059 and Neglect Form CMS 20130, and the investigative protocols for tags F602 and F603. Investigative protocol for policies and procedures related to reporting of reasonable suspicion of a crime. Use this protocol during any survey if based on a complaint or an investigation of abuse, neglect, misappropriation of resident property, or exploitation, a covered individual did not report a reasonable suspicion of a crime. Refer to the CE Pathways for Abuse Form CMS 20059 and Neglect Form CMS 20130 and the investigative protocols for tags F602 and F603, which gathers information about what information was or was not reported by covered individuals and whether retaliation may have occurred. The protocol below investigates whether the facility developed and implemented policies and procedures related to ensuring the reporting reasonable suspicion of crimes and notifying covered individuals of their reporting responsibilities. Procedures. If the surveyor discovers a reasonable suspicion of a crime being committed against a resident of or an individual receiving services from the facility, and it has not been reported by a covered individual, the surveyor reminds the facility of the covered individual's obligation to report suspected crimes pursuant to Section 1150B of the Act within the required timeframes. Covered individual is anyone who is an owner, operator, employee, manager, agent, or contractor of the facility as defined in Section 1150BA3 of the Act. If a covered individual reports the suspected crime to local law enforcement, the surveyor must verify that the report was made, e.g., obtain time/date of report, name of person who received report, case number, etc. If the covered individual refuses to report, or the surveyor cannot verify that a report was done, the surveyor must consult with his or her supervisor immediately, and the state agency must report the potential criminal incident to law enforcement immediately. Facility policies and procedures. Obtain and review the facility's policies and procedures to determine whether the facility is notifying covered individuals of their reporting responsibilities and ensuring the reporting of reasonable suspicions of crimes. Interview staff. Interview staff who may have knowledge of the alleged incident to determine how did staff follow facility policies and procedures, such as what is his or her responsibility in reporting a reasonable suspicion of a crime? What is the facility's policies and procedures for reporting? What actions were taken when there was a suspected crime? When she may have last received orientation, training, in-service, and or notification regarding the reporting of suspected crimes and whether there are any barriers to reporting. Additional interviews with other staff across all levels and different shifts may also be conducted. Interview administrator. Interview the administrator to determine how the administrator oversees the implementation of policies and procedures for reporting of suspected crimes, review of in-service training/orientation records, obtain and review documentation of training to determine whether covered individuals were notified annually of their responsibility in a language that the individual would understand to report allegations of suspected crimes against residents and individuals receiving care from the facility. Key elements of noncompliance. To cite deficient practice at F609, the surveyor's investigation will generally show that the facility failed to do any one or more of the following: develop policies and procedures related to ensuring the reporting of suspected crimes within mandated timeframes, i.e., immediately but not later than 2 hours if the suspected crime resulted in serious bodily injury, within 24 hours for all other cases, and notifying covered individuals annually of their reporting obligations. Identify a situation as an alleged violation involving abuse, neglect, exploitation, or mistreatment, including injuries of unknown source and misappropriation of resident property. Report an alleged violation involving abuse or resulting in serious bodily injury immediately, but not later than 2 hours after the allegation is made, to the administrator of the facility and to other officials, including to the State Survey and Certification Agency and Adult Protective Services in accordance with state law. Report an alleged violation involving neglect, misappropriation of resident property, exploitation, or mistreatment, and does not result in serious bodily injury not later than 24 hours, to the administrator of the facility and to other officials, including to the State Survey and Certification Agency and Adult Protective Services in accordance with state law, or report the results of all investigations within 5 working days to the administrator or his or her designated representative and to other officials in accordance with state law, including to the State Survey and Certification Agency. If tag F609 is cited for failure to develop and or implement policies and procedures for ensuring the reporting of a reasonable suspicion of a crime, the survey team includes the following language at the beginning of the deficient practice statement on the form CMS 2567. Based on observations/interviews/record review, the facility failed to develop and or implement policies and procedures for ensuring the reporting of a reasonable suspicion of a crime in accordance with Section 1150B of the Act. Deficiency categorization, ensuring reporting of a reasonable suspicion of a crime. In addition to actual or potential physical harm, always consider whether psychosocial harm has occurred when determining severity level. See Psychosocial Outcomes Severity Guide. Example of severity level 4. Noncompliance, immediate jeopardy to resident health or safety include, but are not limited to: the facility failed to implement policies and procedures for covered individuals to identify and report a suspected crime to local law enforcement and the SA, resulting in failure to protect a resident from further potential criminal activity by an alleged perpetrator. In addition, the facility had failed to report the alleged violation of abuse to the administrator as well as the State Survey Agency. A resident with a cognitive impairment who was dependent on staff for care reported to family members that she was touched down there and identified the alleged perpetrator. Family members reported this to the licensed staff person on duty. However, the staff told the family that the resident was confused. Staff did not report the family's allegation to anyone and failed to provide protection for the resident, allowing ongoing access to the resident by the alleged perpetrator. The resident had emotional changes including crying and agitation, and cowered with fear whenever the alleged perpetrator approached the resident. The resident subsequently developed a sexually transmitted disease (STD). Based on interviews with various staff members, these covered individuals were not aware of their reporting responsibilities for a suspected crime, even though they had participated in abuse prevention training and had received their annual notification of their reporting obligations. Each staff member assumed that this did not need to be reported because the resident was confused. Therefore, the facility had failed to ensure reporting. Example of severity level 3 noncompliance: actual harm that is not immediate jeopardy include, but are not limited to: the facility failed to implement policies and procedures for covered individuals to report to local law enforcement the suspicion of a crime related to drug diversion. A resident was prescribed opioid pain medication to manage severe pain following recent surgery. For a fractured hip, a resident had requested that staff review his pain medication as it was not effective over the weekend. The resident informed staff that he was unable to attend weekend daytime activities due to discomfort and lack of sleep from having pain at night. The resident stated that he received a different colored pill during the weekend, but it did not seem to work like the medication that was given during the weekdays. The facility's investigation revealed that the same staff nurse worked on each of the weekend night shifts when the resident was identified to have unrelieved pain. This staff nurse had access to the controlled medications for residents on that unit. During interview with the nurse aide who worked on the same shift as the nurse aide stated that she saw the nurse coming out of the resident's room with the medication cup, and the nurse had told her that the resident was sleeping and she would give the medication later. The nurse aide reported that she then saw the nurse take the medication herself. She stated that she was afraid to report what she had seen since she did not want to jump into any conclusions or cause any trouble for the nurse. Interviews with other staff revealed they were not aware of facility policies or of their obligations to report a suspected crime, including possible drug diversion. Example of severity level 2, noncompliance: no actual harm with potential for more than minimal harm that is not immediate jeopardy include, but are not limited to: the facility failed to provide annual notification to staff on their obligations to report suspected crimes and to post signage of employee rights related to retaliation against the employee for reporting a suspected crime. During the investigation, the surveyors did not see any signage related to employee rights related to retaliation. Based on interviews with 5 staff members, they had not received their annual notification from the facility regarding their obligations to report suspected crimes to law enforcement and to the state survey agency without fear of retaliation. However, the staff members were knowledgeable about their obligations. Additionally, 2 other staff members who were recently hired within the last 30 days were not knowledgeable of their reporting obligations or rights to report a suspected crime without retaliation. Example of severity level 1, no actual harm with potential for minimal harm: the failure of the facility to meet the requirements under this federal requirement is more than minimal harm. Therefore, severity level 1 does not apply for this regulatory requirement. Tag F610. Section 483.12c. In response to allegations of abuse, neglect, exploitation, or mistreatment, the facility must: Section 483.12c2. Have evidence that all alleged violations are thoroughly investigated. Section 483.12c3. Prevent further potential abuse, neglect, exploitation, or mistreatment while the investigation is in progress. Section 483.1, 2C4, report the results of all investigations to the administrator or his or her designated representative and to other officials in accordance with state law, including to the State Survey Agency within 5 working days of the incident, and if the alleged violation is verified, appropriate corrective action must be taken. Intent. The facility must take the following actions in response to an alleged violation of abuse, neglect, exploitation, or mistreatment. Thoroughly investigate the alleged violation. Prevent further abuse, neglect, exploitation, and mistreatment from occurring while the investigation is in progress, and take appropriate corrective action as a result of investigation findings. Note: refer to F609 for the requirement to report the findings of the investigation within 5 working days. Guidance. Facilities investigation of alleged violations. For all alleged violations of abuse, neglect, exploitation, misappropriation of resident property, exploitation, and mistreatment, including injuries of unknown source, the surveyor reviews whether the facility maintains evidence that all alleged violations are thoroughly investigated. There is no specific investigation process that the facility must follow, but the facility must thoroughly collect evidence to allow the administrator to determine what actions are necessary, if any, for the protection of residents. Depending upon the type of allegation received, it is expected that the investigation would include, but is not limited to, conducting observations of the alleged victim, including identification of any injuries as appropriate, the location where the alleged situation occurred, interactions and relationships between staff and the alleged victim and / or other residents, and interactions / relationships between resident to other residents. Conducting interviews with, as appropriate, the alleged victim and representative, alleged perpetrator, witnesses, practitioner, interviews with personnel from outside agencies such as other investigatory agencies, and hospital or emergency room personnel. Conducting record review for pertinent information related to the alleged violation, as appropriate, such as progress notes, nurse, social services, physician, therapist, consultants as appropriate, etc., financial records, incident reports if used, reports from hospital / emergency room records, laboratory or X-ray reports, medication administration records, photographic evidence, and reports from other investigatory agencies. Even if an alleged violation was reported to law enforcement as a reasonable suspicion of a crime committed against a resident, the facility must still conduct its own internal investigation, to the extent possible, in consultation with the law enforcement authority. When law enforcement is contacted, the facility must not impede the investigation and must maintain any potential evidence, e.g., clothing, linens, etc., as instructed by law enforcement. It has been reported that some investigations were impeded due to washing linens or clothing, destroying documentation, bathing or cleaning the resident before the resident has been examined, or failure to transfer a resident to the emergency room for examination, including obtaining a rape kit, if appropriate. Prevention. Depending on the nature of the alleged violation, the facility must immediately put effective measures in place to ensure that further potential abuse, neglect, exploitation, or mistreatment does not occur while the investigation is in process. Examples of instances where the facility failed to provide protections include, but are not limited to, the alleged perpetrator continues to have access to the alleged victim and / or other vulnerable residents. Retaliation occurs against a resident who reports an alleged violation. A resident who continually fondles other residents is moved to another unit, where he/she continues to exhibit the same behaviors to other residents. A resident with a history of striking is left unsupervised with a resident who has been targeted in the past in / or other residents, and the facility conducts an inadequate investigation and ceases temporary resident protection measures that were implemented as a result of the alleged violation. Examples of measures to protect residents include, but are not limited to, monitoring of the alleged victim and other residents at risk, such as conducting unannounced management visits at different times and shifts, evaluation of whether the alleged victim feels safe, and if the he/she does not feel safe, taking immediate steps to alleviate the fear, such as a room relocation, increased supervision, etc., immediate assessment of the alleged victim and provision of medical treatment as necessary, immediate notification of the alleged victim's practitioner and the family or responsible party, removal of access by the alleged perpetrator to the alleged victim and assurance that ongoing safety and protection is provided for the alleged victim and, as appropriate, other residents, notification of the alleged violation to other agencies or law enforcement authorities, and whether administrative staff, including the administrator, were informed and involved as necessary in the investigation. Corrective actions. As a result of a facility's investigation, if an alleged violation is verified, the facility must take appropriate corrective action to protect residents. The facility should oversee the implementation of corrective action and evaluate whether it is effective. While some corrective actions may be limited in scope, facilities should determine whether more systemic actions may be necessary to prevent recurrence of the situation. In addition, the Quality Assessment and Assurance Committee should monitor the reporting and investigation of the alleged violations, including assurances that residents are protected from further occurrences and that corrective actions are implemented as necessary. Refer to the CE Pathways for Abuse Form CMS 20059 and Neglect Form CMS 20130. And the investigative protocols for tags F602 and F603. Key elements of noncompliance. To cite deficient practice at F610, the surveyor's investigation will generally show that the facility failed to do any one or more of the following: initiate an investigation of an alleged violation of abuse, neglect, exploitation, misappropriation of resident property, exploitation and mistreatment, including injuries of unknown source, or complete a thorough investigation of the alleged violation, or maintain documentation that an alleged violation was thoroughly investigated, or prevent further potential abuse, neglect, exploitation, or mistreatment while the investigation of an alleged violation is in progress, or take corrective action following an investigation of an alleged violation if the allegation was verified. This concludes the reading of Appendix PP, Regulation Section 483.12, tags F600 through F610.